That, in effect, turned the cross-examination of that witness from dealing with the specific issues in the case to having that witness testify as a character witness for Mr. Murdaugh. Among his other areas of inquiry was his being a loving father, great provider, financially secure, things of that nature, all indicating an opinion by that witness as to the good character of the defendant, either through direct statements or circumstantially through the evidence that was adduced from that witness. In the court's view, that opened the door for the state to respond by asking questions, as the state did. Hence, the court overruled the objections. In addition to all of that, the objection was totally inappropriate. As the court laid out and reviewed with the parties early in the trial, that objection should be made and the legal basis stated. An objection of totally inappropriate is, in the words of Judge Joe Anderson, in effect, no objection at all. That's not a legal basis for an objection. That summarizes the basis for the court's ruling on that issue, as to those questions yesterday. And that character type evidence was not only sought by from Mr. Gibson, but also, was it Loving? But also Mr. Loving. And none of that really implicated Rule 404, 404B. One, it opened the door. Number two, is 404A type reputation, questioning that the state had a right to respond to per the rules. And thirdly, it addressed an issue raised in the case by the defense. The defense in the case has primarily been the defendant has such a great character that he could not possibly have committed these offenses. That's been a general thread from opening statement throughout. In addition, the defense introduced through that witness, which was also introduced through other testimony in the case by the defendant, that the boating case was a reason for the murders to have occurred. And by the defense inquiring of the witness yesterday as to his knowledge and belief concerning, or his knowledge concerning the boating case, that likewise opened the door for the state to address that issue. And that's the basis for the court's ruling as to opening the door, introducing the boating case, and reputation type evidence that the state had a right to respond. Under Rule 403, yet to be addressed by the court is Rule 404 issues. And those issues will, to some degree, have to be addressed in camera. And I'm wondering if the state has other witnesses to testify as to other things, since we have the jury here ready to go, prior to addressing any other
Well, we do have first of all, we do have a Snapchat custodian who has flown in that we need to get in so that person can make the flight. Based on how things ended yesterday, I was prepared this morning. We were planning on going forward with some of the witnesses from the law firm, and that's going to, there's certainly stuff beyond 404, but that's also going to put some of the 404 issues squarely into play. So that's kind of where we were planning to go this morning, Your Honor, with the testimony that we have. I can certainly get some more forensic people rolling. I apologize if I sort of misread what we needed to be ready to do, but that's kind of what we focused on last night and are ready to address this morning.
Yeah, well, the court didn't have a lot of time to do jury planning issues, and it might have, the jurors typically come at 9:30. It might have been a better idea had, with greater thought, to have had them come later. And I don't know how long these issues will take to be addressed.
I think with the two law firm witnesses out of the gate, I think once the court has, we could do some very focused in-camera testimony, and I think that for those witnesses, the court can then rule on what's admissible and what's not, and once that's done, then we can get underway with the jury for those witnesses and proceed accordingly. And then, of course, we can certainly have a discussion as far as other witnesses and then perhaps arrange a time to do any other in camera. But I think setting the table with these two witnesses is going to set the table for many of the issues that, whether they're in or out, that the court has to decide.
All right. Well, first, as it relates to Rule 404, and Rule 404B states that evidence of other crimes or wrongs is not admissible to prove the character of a person in order to show action in conformity therewith. In other words, not admissible to show propensity to commit the crime or a crime, but it may be admitted for certain other reasons, including motive, identity, intent, and perhaps the existence of a common scheme or plan. Additionally, I'll address it later regarding res gestae, but my view of the evidence is that evidence of the other alleged crimes can be introduced in this case to show motive, intent, common scheme or plan. Given the proper analysis as it relates to that evidence being offered. As I indicated earlier, that the court agrees with the view and as expressed by the court in U.S. v. Siegel, 536 Federal 3rd 306, wherein the court addressed the issue of previous crimes involving, previous alleged crimes involving multiple victims, and that the state should be able to pursue its theory of proving that why suddenly or why some such tragic, the motive for such tragic occurrence to have taken place on the dates alleged here. And under the federal rule, it goes on to say that evidence of other crimes or bad acts is necessary if it is an essential part of the crimes on trial or where it furnishes part of the context of the crime This state has not adopted that portion of Rule 404B, but the courts have addressed that issue in some of the cases, particularly one that stands out to me as one of my cases, State v. Frankie Lee McGee from Richland County, in which the res gestae was used as a basis for the courts properly allowing certain evidence, including evidence of commission of an earlier crime, the test being whether it logically relates to the crime with which the defendant is charged. Court states in that opinion under res gestae that one of the accepted bases for the admissibility of the evidence of other crimes arises when such evidence furnishes part of the context of the crime or is necessary to a full presentation of the case, or is so intimately connected with and explanatory of the crime charged against the defendant and is so much a part of the setting of the case and its environment that its proof is appropriate in order to complete the story of the crime on trial by proving its immediate context or the res gestae or the uncharged offense is so linked together in point of time and circumstances with the crime charged that one cannot be fully shown without proving the other, and thus is part of the res gestae of the crime charged. And where evidence is admissible to prove this full presentation of the offense, there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. And interestingly, involved in that case, the court held that did not require a 403 analysis. Because the evidence was properly admitted as part of the res gestae, the issue of whether or not a 404B analysis was done was not necessary. And at this point, the court hasn't addressed any particular issue under 404B, but I find that it is admissible provided that the proper scrutiny is done in relation to clear and convincing evidence and a logical relationship to the offense for which we're having this trial. And additionally, as relates to intent, evidence tending to prove a defendant's state of mind or intent at or near the time of the crime is relevant to establish possible guilt. So there are many areas under which it's appropriate for the court to consider admitting this evidence of other crimes, other bad acts, in a manner that does not address or seek to have the jury conclude that it's propensity evidence, and the court will address all of that as we proceed. Yes, sir, Mr. Griffin.
Thank you, Your Honor. I just want to get some arguments on the record for purposes. Yes, as to Your Honor's conclusion that we opened the door by presenting evidence of good character, I would respectfully disagree, and the evidence that we presented was specifically limited to the relationship between the defendant and the victim for which he's accused of murdering. In our view, that is not character witness. That's a factual issue relating to the relationship between the parties. And so I just want to put that on the record. Your Honor puts great emphasis and reliance on U.S. v. Siegel, and that's a federal case. And I want to point out that
I gave the site, federal site.
yes, sir.
Federal second.
The federal site is 536 F3rd 306.
F3rd, yes.
Yes, sir. And and it's important to distinguish the federal crimes for which the defendant in Siegel was charged with. First, the defendant, she was charged with murdering the victim to prevent him from reporting fraud, and that's a specific federal statute, 18 U.S.C. 1512 A1C. She's also charged with impending an official investigation by transporting the deceased body across state lines. But further, the indictment alleged a broader scheme and artifice to defraud. And in the indictment, it listed many of the prior crimes that the defendant committed in the federal indictment. And so, and under federal rule 404B, you can prove those up. And then there were others that the court considered they were related to the whole scheme and artifice to defraud. The indictment in this case, Your Honor, is simply on June 7th, 2021, the defendant with malice aforethought murdered Ms. Maggie Murdoch, murdered Mr. Paul Murdoch, and used violent weapons in commission of those two crimes. There's no scheme and artifice to defraud here.
You're currently addressing it as if the court ruled based on 404. And the court clearly stated that we have not reached any determination on 404 that the basis of the court's ruling was 403. The boating case, as you introduced through the witness, and opening the door by giving testimony, soliciting testimony of generally good character of the defendant, such that neither of the two witnesses could possibly imagine a scenario under which what would cause this crime to have occurred, and the state is entitled to confront that evidence in the manner in which the court ruled. But you're arguing 404. I cited that for an additional basis to say the court will need to look at all of that as we proceed with evidence of prior bad acts, but the basis of the court's ruling was not 404, but 403, opening the door and responding to the evidence that you adduced.
Yes, sir. I apologize. I misunderstood.
Yes.
Your Honors.
I did not rule based on U.S. v. Siegel and overruling your objection yesterday.
Fair enough. I guess I would ask for clarification of where we go from here. Is your intentions to have a hearing outside the presence of the jury on their proposed 404B evidence?
Yes, sir.
Okay. Then I can save all the arguments from then. Thank you.
Yes, sir. And again, with regard to planning purposes for the jury, you said a witness, whatever can be done without getting into the 404 or the court's need for an in-camera hearing, where we need to dismiss the jury for whatever period of time that might be, we can press on with what you have otherwise at this time, and whatever that is what we'll hear.
Yes, sir, Your Honor. Like I say, we have one short custodian, and then I think our next witness who's here would be somebody where we would need to address some of the 404. That would be Jeannie Seckinger from the law firm. If you give me one moment, I can to confer with my staff, and we can see if we can get some other people rolling so that we can kind of stagger that and continue to have presentations for the jury during the course of the day.
All right. Minutes.
to order.
Are you ready to proceed?
Yes, sir. We do have, again, that custodian witness. Then I think we would have to, we are rolling some additional witnesses, but I think at that time we would have to break and do at least the first in-camera witness. Again, I think that may set the table for a lot of subsequent things. And then we can have some additional work outside of any 404 stuff in the afternoon, Your Honor. But certainly happy to do that, or if you want, we can put up some multiple witnesses on the in-camera here today.
So I think as it relates to each alleged bad act, it must be the court must be informed and proffer and addressed separately. Of course, some may be a series of things occurring almost simultaneously, so that may be a different scenario. But we'll see how it goes. We're ready to proceed with the jury.
Yes, sir, Your Honor.
Jury is present, sir.
All right, thank you. Good morning. Good morning. Welcome back. Day number 9. State's case. You may call your next witness.
Thank you. State call Heidi Galore.
You affirm the testimony about the court in this trial shall be the truth, so help you God. I do. Thank you. Please take a seat in the witness stand. State your name again for the record. Spell your last name, please.
My name is Heidi Galore. Last name is spelled Galore.
Please call. Good morning, Ms. Galore. Where do you work?
Morning. I work for SNAP Incorporated.
What are your duties there?
I'm an law enforcement operations lead, so I assist with and help manage a team of folks who respond to law enforcement legal process. Sure. Our team responds to legal process submitted to our company, subpoenas, search warrants, that kind of thing.
All right. So you're in charge of responding to search warrants or subpoenas from law enforcement or other legal entities?
Correct.
All right. And briefly, please, what is Snapchat?
Snapchat, it's an application that was created by Snap Incorporated to help people express themselves. People can connect to their friends, people they know, and I guess you could consider it a social networking type of application.
Is social media another word that could be used for Snapchat?
Yes.
Does it give the ability for individuals to send each other messages?
Yes.
Does it give the ability for individuals to send each other pictures or videos?
Yes.
And in the normal course of this business, does Snapchat keep records if the user so chooses?
Yes.
What kind of records does Snapchat keep?
Basic subscriber information, content that was sent to and from folks, IP logs, geolocation, depending on the settings of the user.
Okay. I'm going to show you what's been marked as States Exhibit 305 and 304. I'm going to ask if you recognize these two items.
I do, yes.
And what are you holding?
The paper here is the basic subscriber information for the user that was produced in the search warrant.
And what's that CD?
The CD contains the full production of files that was sent to your agency, requested from the search warrant.
All right. And that was a search warrant from SLED
Yes,
that Snapchat responded to?
correct.
Okay. And you said there was subscriber information on that piece of paper, correct?
Yes,
And is that also located on the CD and the digital records?
yes, yes.
I'm gonna go back to you real quick. And Your Honor, at this time, state would move these into evidence.
No objection, Your Honor.
They're admitted without objection.
I'm going to hand you back States 304. And you indicated that was subscriber information. Is that correct?
Correct.
And could you read for the jury the subscriber information for the information on the account that you provided in response to the search warrant?
Sure. The username is listed here. The username is listed here as Paul9499. Common spelling for Paul. The email address listed here is paulmurdaugh7845@gmail.com. This was created. The account was created on Saturday, May 18th, 2013. There's a creation IP, but it's not listed here. Sometimes it's captured at the time of creation of the account. In this case, it doesn't seem to be. Phone number listed here is 803-842-7845. Display name is listed as Paul Murdaugh, and the status is active.
Okay. And when somebody uses a telephone number, for example, to create a Snapchat account, does Snapchat verify that number?
If the user wants to verify the phone number, yes, they can, but it's not required.
Okay. And what about the email? Is that required?
Not required either, no.
All right. I'm going to hand you State's Exhibit 306. This is already in evidence. And I believe this is a CD. Do you recognize that CD?
Yes, I do.
And have you reviewed the contents of that CD?
Yes, I have.
And what is on the contents of that CD?
It's a video of a subject near a tree, and it's a short video with some audio.
Okay. And did that video, was that part of the full search warrant return that we just talked about?
Yes.
All right. And did you take a look at that video and the records contained in the other CD to determine when that video was first uploaded and first sent?
Yes.
Okay. Well, first of all, let's talk about the upload. Was it uploaded to something called Memories?
Yes.
And can you describe to the jury what is Memories? What does that function with Snapchat?
Memories is kind of like a bucket where you can save your data. You can either create a video or some sort of photo on the app itself and save it to your memories so that it's always there when you need it, or you can upload from your camera, your phone, into Memories to then send to folks later, or just have it in there.
So is that a form of saving, like saving something in the cloud?
Correct, yes, it'll be on the server.
All right. And in reviewing these records, did you determine when this account uploaded that particular video to Memories?
Yes, this video was first seen on Memories on June 7th, 2021 at 7:39 hours Eastern.
And does Snapchat also keep a record when an individual sends out a communication?
Yes.
And did you determine, reviewing the records, whether that account sent out that particular video?
Yes, it was sent on the same day, June 7th, 2021 at 7:56 hours Eastern Time.
All right, thank you. And I'm going to show you, if you look at your monitor in front of you, and I'm going to show you State's Exhibit 306, and see if you recognize it. And did you recognize that video?
That didn't show up on the...
Oh, I'm sorry, can we get the, it on the screen? My apologies. Oops. Okay. What's going on now? Try it again. Sorry about that. Can you see the what's on your screen right now?
Yes.
All right. And I'm going to play that one more time. Okay. And do you recognize that video, man?
Yes, I do.
All right. And is that video, the video we just discussed that was part of the Snapchat search warrant return?
Yes.
That you just testified was uploaded at 7:39 p.m. and sent at 7:56 p.m.?
Yes.
No further questions.
Good morning, ma'am.
Morning.
Can we pull up the Snapchat video, just have it frozen on a screenshot? Doug? I think it's plugged into this computer. All right, that's good. So this is what, or part of what Snapchat gave to the state on July 6th, is that, of 2021. Is that correct?
Correct.
So the state had this on July 6, 2021, in the state's possession,
I believe so, yes.
this information. And you testified that this was uploaded at 7:39 p.m. on the 7th of June, correct?
Correct.
Is that exactly when this video was shot?
I can't tell that information from the production.
Are you certain that's not something that could be told from the, perhaps the metadata for the video file?
There was no metadata produced for this production. It wasn't requested, so it wasn't produced.
So if someone were to right-click on this video file and you know, where it has various metadata that pops up on the screen, would we see a media created date?
I don't know.
Well,
I
let's
wouldn't know.
see if we would. Court's indulgence for a moment. Can you see on the screen the metadata for this file?
Yes.
And does it say June the 7th, 2021 at 7:38 p.m.?
Yes.
And so this was shot basically a minute before it was uploaded, is that correct?
It appears so, yeah.
And I'm sorry if that seems picky, but in this case, you know, every minute and every second, you know, can matter. Does Snapchat keep a list of, and I might be getting the terminology wrong, friends or contacts that Paul would have had on Snapchat?
Yes.
Was that list produced?
No.
And why was that list not produced?
It wasn't requested in this case.
And you mentioned earlier geolocation data. Was that produced?
No, not in this case.
And why was that not produced?
I don't believe it was requested.
Is it possible for, I don't know how it works, for some or all of Paul's friends to have access to his location through the app?
Yes, if his settings were, if he made his settings visible, his geolocation visible to his friends, yes.
And would that information about whether that was that setting was in place to allow that, is that something that Snapchat would have had available to produce?
I'm not sure I'm not sure about that. If you can see that it's actually turned on or off. Yeah.
Was that requested?
No.
No further questions, Your Honor.
By the state.
Nothing else for the state.
All right, thank you.
Thank you.
Step down. Yes, sir.
The state's next witness would be Jeannie Seckinger.
Ladies and gentlemen of the jury, there are matters that must be addressed outside of your presence. I do not know exactly how long it would take, but I do not like to have jurors sit in jury rooms just for long periods of time. So we're going to excuse you through after you speak for the bailiff. We're going to take a recess with the jury while we deal with these matters. Let's see now. You all have lunch coming at what time? Nobody knows. 1 o'clock, 1:15. All right. Well, we won't need you before lunch. So if you'll go to the jury room and wait for further instructions, but we'll be having you all take a break until around that time. Proceed.
All right. Again, the state would call Jeannie Seckinger.
Raise your right hand. You affirm the testimony you write before the court in this trial shall be the truth, so help you God. This, and you take a seat in the witness stand. State your name again for the record. Spell your last name.
My name is Jeannie Seckinger, Seckinger.
Ms. Seckinger, how you doing today?
I'm good.
Good. Let me fix the cell mode real quick. You understand we're here right now outside the presence of the jury for an in-camera hearing to determine the admissibility of some of your testimony.
I do.
And just very quickly, if you would, give us a little bit. I'm not going to go through all the background that I wouldn't in front of the jury unless Your Honor would like, but give us a little bit about your background and where you currently work, how that led to where you currently work.
Okay. I graduated with a BS in accounting from USC, went to work in an accounting firm for a few years, then switched to industrial at Westinghouse. And in 1999, I came to work at PMPED, which is Peters Murdoch Parker, as a temporary bookkeeper, and that has grown over the years to the office manager, CFO, accountant, anything business and insurance and HR related.
Okay, and that's for whom?
For Peters Murdoch Parker, Elstroth and Dietrich.
All right, so that's PMPED,
Correct.
and that's the law firm that Alex Murdaugh used to work for?
Correct.
Does that have a different name now?
We are now a new entity that's called Parker Law Group, LLP.
All All right, so just very quickly, you've already kind of said this, but go through sort of the financial side of your job duties as it existed for PMPED back in the relevant time periods.
Okay, so my financial duties are, actually I have people under me that do the day-to-day processing of checks, but my duties are to balance and reconcile accounts, provide financial statements, help with all tax documents, preparation of taxes, also prepared anything for any government census or surveys that we needed and anything HR related.
I want to ask you a little bit about the financial structure of how PMPED works, if I could. And if you could explain that a little bit. People often think of lawyers as partners, but are they called partners under the employment agreement that everyone signed?
No, we're called partners when we refer to each other as they're in the business, but for tax purposes, everybody was an owner. It was a C corporation, so everybody's shareholders. And within Peters Murdoch Parker, every employee was a salaried employee, including the partners.
Okay. And did the employment agreement that everyone signed require that any fees or money generated by any partner or lawyer by the firm had to go to the firm?
It did.
And explain to me how, if you're and let's just call them quote partner, if you're a partner, how does the compensation work? What are the elements of compensation as it worked under the PMPED structure back in 2021 and prior?
So every partner received a base salary that they would receive in biweekly payments throughout the year. That was set at a level of about $125,000. The majority of their pay came through an end-of-the-year bonus, which is when we closed out the books and settled on the books. And primarily, after overhead and expenses were met, the net profit was divided amongst those partners. And in a simplified form, it was basically distributed based on a ratio of the fees that they brought in percentage to the total.
Right. But that distribution would not take place until when?
Usually the last week of December.
Yes, sir.
Waters, there's distracted. Can you repeat the previous question for me?
Yes, sir. Going back, Ms. Seckinger, we were talking a little bit about the compensation structure for PMPED as it existed in 2021. And if you could, again, explain to the court how that worked. How are partners, and we're going to call them loosely that term, how are they compensated?
Okay. Partners are employed salaries who are paid a biweekly paycheck throughout the year with a base salary of $125,000. And at the end of the year, they received a bonus check, usually in the last week of the year, that divided up the remaining profits of the firm based upon the percentage of revenue each attorney brought into the total.
All right. So when fees came in, they're going to be attributed to a particular lawyer, and ultimately that's going to be a percentage of the total revenues, and that's going to determine their percentage of the compensation at the end of the year after all overhead is paid.
Correct.
Is there also some sort of 7.5% fund or fee or something like, or not, or amount that's put aside?
There is. You would take the gross bonuses that are the gross fees everybody brought in, less than overhead, and once we get to that number, everybody would throw in a pot 7.5%, and that money was divided back equally among the employees. And then a new percentage was arrived at to determine how much everybody would receive of the net income.
All right. So you have to take care of overhead, right?
Yes.
And what is an overhead, just generally?
Overhead is just basically the expenses to run the business, what it costs us to advance client costs, what it costs to pay our employees, what it costs to rent the building, to provide equipment, office supplies, postage, etc.
All right. And that's got to be accounted for, and then you got to account for this 7.5% as well, correct?
That's right.
All right. And then only after that does each partner get compensation based on their relative contribution during that year.
Correct.
All right. Is typically the vast majority of compensation received by a partner at PMPED received in that distribution at the end of the year?
Yes.
And when does that take place?
The last week of the year, generally speaking.
Okay. And what is the point of that goal? Why do you want to sort of clear out all the money and clear the books?
Basically, that we don't want to leave the money in there to be taxed by the corporation because it's a C Corp entity, so the objective is to get it out to the partners and avoid double taxation.
And so because of that, is it up to each individual partner to essentially manage the bulk of their compensation that's received in one lump sum during the course of the next year?
Yes, they need a budget.
All right, let me show you what's been marked for purposes of this hearing as States 310 and see if you recognize that document.
Yes, this is the employment agreement each shareholder/partner would have signed.
Okay. And I just want to direct your attention to number 2, and if you could tell the court what that provision that's signed by all the partners says.
It says the employee accepts such employment and agrees that the employee will devote the employee's entire time and endeavor to the employer's business.
All right. And then number 3, if you could read that to the court, please.
Services for the benefit of the employer. All professional services rendered by the employer shall be rendered as an employee of the employer, and all proceeds and remuneration received therefore shall inure to the employer's benefit.
Okay. Now tell me what that means.
That means that all fees earned should come through payable to PMPD.
All right. And so if a lawyer earns fees, is it appropriate at all for those fees to go directly to the lawyer as opposed to going through the law firm?
No.
Is that a hard rule to understand?
No.
Anybody ever have a problem with that rule or not understand it?
No.
Pretty easy and hard and fast rule in that firm, correct?
That's right.
If you get the money written straight to you, what is that?
The money's taken straight to you?
Yeah.
That would be stealing it.
Stealing. Please, could y'all turn the screen for me? All right. So, is that better? Can you see that, Ms. Seckinger?
Yes,
All right. So, 2 and 3 are the provisions you were just referring to.
that's correct.
Tell me just a little bit of your observation. How long have you known Alex Murdaugh? Let me ask you that.
I've known Alex since I was in high school, so roughly 40 years.
Okay. And how long have you worked with him, or did you work with him?
About 23, 24 years since 1999.
And did he have a lucrative practice in your observation?
Yes, he did well.
Was he sometimes getting as much as 7 figures in the end of the year?
He has.
Are you familiar with what's been called the boat case?
Yes.
And tell me what your understanding of the boat case is, just generally. What was that?
Generally speaking, it was an accident that several children got in one evening where it was in Paul's, or the Murdoch's boat. Paul was accused as the driver, and there were a lot of civil suits and some criminal proceedings going on related to that crime.
And following the boat case, is it your understanding that Paul Murdoch was charged?
Yes.
Is it your understanding that Alex Murdaugh was civilly sued?
Yes.
And there was ongoing civil litigation at the time Paul and Maggie were murdered?
That's correct.
After the boat case happened, did you and Alex ever have any discussions about structuring fees?
We did. We did in late May of 2021.
Okay.
Right about the end of the month, we had some discussions about Hirschberger. A disbursement came through that he had tried to send his fees to a structured settlement. And the conversation was that he had done it improperly, because to structure fees properly, it has to be part of the release. It has to go straight from the insurance company, straight to the structured annuity place. And we would need to be told about it in our firm so we could account for it in our 7.5%. But in this particular case, Alec had sent the money directly to Forge. We discussed the fact that it would not be any tax benefit to him, and at that point in time he said he was not really worried about the tax benefit of it. and he said he was trying to put some money in Maggie's name due to the boat wreck, and that he was trying to figure out if he was going to structure fees for the future.
Okay. Did he say he was trying to do a favor for anyone too?
He did say he was friends with Michael Gunn, and who is the owner of, or one of the operators of Forge, and that he was going to try to put up to about $250,000 into a structure as a favor for Michael Gunn.
All right, when you say Forge, what are you talking about?
So Forge is a company that does structured annuities.
Do you have the full name real quick?
It's Forge Consulting.
All right, let's call it Forge Consulting.
Okay, Forge
Trying to do that.
Consulting.
All right, tell me about Forge Consulting and what they are.
They're a company that will do structured annuities for clients. They'll do structured fees for attorneys. They do some wealth management. They do minor pool trust. They have several different things that they do. I think they've branched out into insurance coverage now. They provide a lot of financial tools.
Now, when you say that you had a conversation with him about him supposedly structuring fees, how did this come to your attention?
It came to my attention over the fact that a disbursement, one of my secretaries or my assistant brought to me, that had been brought to her attention by Alex secretary or paralegal Annette Griswold, and came and asked me if this was proper, and then came to me after the fact, and that's when I went and had conversations with Alec about this.
Okay. And so had the money already been paid?
Yes.
And you went to Alec and you asked, what's this about?
Yes.
And he said, I'm doing what?
I'm trying to defer and put money into Maggie's name and structure some fees.
Did he tell you where that money had gone? What was your belief where that money had gone after you talked to Alec?
My belief was it had gone to Forge Consulting.
The real entity, Forge
Yes.
Consulting.
Yes.
All right. I'm going to show you just real quick what's been marked for purposes of this hearing as States 311 and see if you recognize that series. I think there's 4 documents in there.
Yes, these are the Hirschberger settlement documents, which is the case that we're talking about, with the fee that he sent as a structure.
Okay. And are there 1 or 2 in there ultimately?
There are ultimately 2. There's one that's structured to look like fee, and then the other one was structured to look like it was client's money that was being sent on the client's behalf.
Which one were you aware of at the time?
I was aware of the fee one for the $83,333.33.
All right. At the time, did you think that any money had been misappropriated or stolen, or did you just think Alec was trying to sort of divert some money because of the boat case, but not necessarily anything misappropriated at that
Right.
time?
We were not thinking about him misappropriating funds or stealing any client funds. What we were concerned about was he was trying to either defer income by leaving it in somebody's trust, or either trying to put some money into Maggie's name to avoid things for the boat accident.
And when you say we were concerned, who's concerned?
Myself and some of the partners.
Why are y'all concerned about him potentially trying to put money in a structure or in Maggie's name because of the boat case?
Well, because that would be wrong, and we did not want any part of that.
Let me put this up on the screen real quick. All right. Do you recognize this document right here?
Excuse me. Yes, that's the document that is in question with the $83,333.33 fee sent to Forge.
All right. And right there, tell me what this disbursement sheet is very quickly. Explain that to the court.
So this is where the client recovered $250,000. You can see it came from 3 different insurers, and we would take a portion of our fee. Generally, this looks like a third, and our expenses of $9,300. The Sedgwick claims would have been a lien that we were paying off, and then the $140,678.55 would have been the money dispersed between the beneficiaries of that estate.
And what is this line right here?
That would represent the fee.
All right. At this point in time, had you actually seen the check that was made out for those fees?
I don't recall if I actually looked at it at that point in time.
And normally fees, where would they go?
Normally, if fees would come to us and we would deposit into our income account, what we call our income account.
Okay. So fees come in from somebody who pays a settlement. Where do they go initially? What account do they go in?
To the income account, the PMPD operating income account.
Okay. Fees go in there?
Yes.
All right. When a settlement comes in, where does it go?
It goes into a client trust account for the benefit of the client.
And then the portion of that is allocated for fees, it goes from the trust account to where?
To the income account.
Okay. It usually doesn't go out to Ford's Consulting or anything like
No.
that? All right. After you had that conversation at Alec, did you follow up any more on the matter?
We had a couple of conversations about it in relation to when we were having some other conversations, but we didn't really readdress this again until late September, late August, early September.
Did you kind of put it on the back burner?
I did. I was, at that point, it had been done, and I was trying to figure out how we were going to account for it on our books, and just kind of had it out there as a reminder to try to see, to put in my mind later to see if anything else had been done like that, or to see if he was going to try to do that again.
After that particular event, you said that was in late May sometime?
You're right.
Did another matter come to your attention about disbursements as it related to Alex Murdaugh's practice in his business?
It did.
And tell me what that was, please.
So on, this was a case called the Ferris versus Mack Truck case. And on a Monday, I believe it was May 24th, Annette Griswold called me and said that she had something she needed to discuss with me. I was out of the office that day in our Waldoboro office, but when I returned, we met. And when she showed me, what had happened was we received a check for our client expenses. So this case was actually disbursed by the associated attorney, which was Chris Wilson. So he sent us a check for the money that we had forwarded as client expenses, but we did not receive a fee check. And that in itself is odd generally.
And why is that odd? Why did Annette call you? Because y'all had received a fee check from Alex's best friend, Chris Wilson, but not the, the expense check, but not the fee check.
Right. Most of the time we receive them together. Well, Annette, when she did not receive them together, called my assistant, Nicole, to make sure we had not already received the fee, verified that we had not already received the fee, and at that point, Annette had some conversations with Vicki Lyman in Chris's office. And Vicki informed Chris that their bosses had already got the fee when the settlement was signed, which had happened in March, and this was May.
And Vicki informed Chris, or Vicki informed Annette?
Vicki informed Annette of that.
So why is that a concern to you that now you're hearing the fee's already been paid?
Because now we know we don't have the check. We've never received it. So either he's got a fee, either he's got a check he hasn't turned in to us that is properly payable to PMPD, or he's received a check payable to him.
All right. And when you were considering the possibility that he perhaps received a check payable to him, aside from that being stealing, as you had earlier testified to it, what's your concern then?
Saying that he's trying to hide money from the boat wreck.
Hide money from the boat wreck. All right, stand by for me. Show you what's been marked as, for the purposes of this hearing, as Exhibit 312, and see if you recognize this document.
Yes, this is the expense check that we received in the Ferris matter.
Okay. And
from Wilson Law Group.
Just quick flip through it and just tell me generally what's in that packet.
The rest of the packet is our deposit, which is an internal record, our client cost report, which matches that expense check. Then the rest of it, the second what I'm looking at right now is a check made payable to Richard Alexander Murdoch, Esquire, for $192,000, and it references Ferris fees.
Okay, keep going.
Next page is the deposit, where it says Bank of America deposit only, and it looks like ACH. That looks like, it actually looks to me like Alex initials, and then it says Bank of America.
Is there a series of emails after that?
Series of emails starts with Vicki Lyman informing Annette Griswold about the fact that their bosses had received the fee back when the disbursement was signed.
All right, let me put those emails up on the screen. I believe there's no objection versus this hearing. All right. So this is email, and Annette Griswold, explain to the judge who Annette Griswold is, please.
Annette Griswold is one of Alex's primary paralegals.
Okay. And right here, this is an email that was ultimately sent to you as part of bringing this to your attention?
Yes.
All right, and what is she asking right there?
She said, why just expenses and no fee?
All right, and what was the response there?
Dear friend, it is only cost because your boss and mine and Liz's got their fees once they were signed.
Okay. So, and that's informing you that Chris Wilson's office says they already got the fees.
Correct.
All right. After that, did you have a conversation with Annette what to do?
I did. I actually talked with Lee Cope. We went to Lee. Sometimes a lot of the partners are not in the office, and Lee Cope was the one who was in the office. So I went to talk to Lee about what we should do. And, of course, Annette was worried about getting, ramifications if she was wrong and didn't want to be in trouble. So Lee and I decided to take it over from there. And the course of action that we decided upon was that I would send an email to Annette requesting the disbursement, the supporting documents, and the general ledger printout from Chris Wilson's office, which is what we keep in our office.
All right. And if we go right here, is that the email you're speaking of right there?
That is.
All right. What's the date on that?
May 27th.
All right. And so then what happens to that email from there if we look over to the next page?
So apparently Vicki in Chris Wilson's office was on vacation. So on June 2nd, Annette clarifies with Vicki what exactly we were looking for. And again, she asked for the full disbursement paperwork, including the disbursement sheets, expenses, supporting docs, and ledger.
All right. And you're included on that email?
I am CC'd, yes.
Okay. All right. Did y'all ultimately get a response on that?
Vicki responded that she would have to send that email to Chris because she did not have privy to that information. So that was on the 2nd. The next day, Alec came into my office early and asked me why I needed that information and assured me that the money was in Chris Wilson's account and that they could get it any time.
Okay. And did y'all discuss anything further when you had that conversation?
Just that we needed to get it, or I needed proof that it was there, that it was necessary to get it. At that point, I didn't indicate to him that I thought it was missing. I was just asking for the documentation.
And that was on what day?
It was sometime in between June 2nd and June 7th.
Okay. All right. On June 7th, did the issue come back to a head?
The issue did come back to head.
Just clear, this is June 7th, 2021.
Yes.
And how much were these fees supposed to be, did you know?
$792,000 in total.
And to this point, the firm had not received those fees, is that correct?
That's correct.
And Chris Wilson's office is saying initially, we already dispersed them.
Yes. And Chris Wilson's not saying anything to me.
Was, to your knowledge, was an inquiry made to Chris Wilson at that time?
Lee Cope, we had not inquired Chris Wilson other than requesting this information at this point in time.
All right. So tell me about June 7th. How does that go?
So on June 7th, I was going to make another run at finding out from Alec if we had their information. I went upstairs to his office is on the 2nd floor, and he was leaning on a file cabinet outside his office. And he turned and looked at me when I came up and said, "What do you need now?" And gave me a very dirty look, not a look that I'd ever received from Alec, from just kind of frustrated with me look, which made me go, oh, you want to know, let's go in your office. So we went in the office and closed the door, and at that point I told him that I had reason to believe that he had received the funds himself and that I needed proof that he had not.
Received those fees himself?
Yes.
And I needed proof that they were not?
Yes.
What did he tell you?
He told me again that he assured me that the money was there and that he could get it. And at that point I said, I'm just trying to do my job, and if I don't get this paperwork and verify that with these questions, I'm not doing my job. He actually acted like he respected that, and again said that that money was there and that he again was trying to decide what he was going to be doing with it.
And did y'all get to conclude that conversation, or just something interrupted?
We did not. He took a phone call in the middle of that conversation. That phone call was about his father who was in the hospital, that he was going to be terminal, and that there was nothing else they'd be able to do for his father. So that changed the mood of the conversation. We quit talking about business, and I immediately asked about him and his family and his dad, and we got talking as friends at that point, concern over the family. And after that, I shortly left, so it briefed and cut down the conversation.
All right. You'd come in there asking for proof where that money was, because you had reason to believe he took it, and then the conversation ultimately got short by the call about his father.
Yes.
Did you have a conversation later in the day with Alec?
I did. Around 4 o'clock, my phone rang, and I remember that because I had been under the impression Alec was going to leave and go to the hospital or leave to deal with his father. And around 4 o'clock, my office extension rang, and at that point, he was asking me for some information on his 401k balances because he stated he was working on some financials for the hearing on the boat accident that was later in the week.
There was a hearing later in the week, and he was working on financials for the boat accident.
Correct.
Did that strike you as odd?
That he called and asked me?
Yeah.
No, he had asked me before. So, and I would be the one to give him the 401k. So it didn't surprise me that he's calling to ask me about that. But I was surprised that he was in the building working on it.
Yeah, why was that?
I just thought he was leaving a deal with his father.
Because that interrupted the prior conversation.
That's right.
Is that the last conversation you had with him?
It is.
When did you find out about the murders?
I initially found out through the rumor mill around 10:30 or 11 o'clock the evening of them, but I did not get confirmation until I received a text from the partner roughly 2:30 or 3 o'clock in the morning.
Were you shocked by that?
Yes.
Scared?
Yes.
Worried?
Yes.
Worried for Alec?
Worried for everybody, yes, especially Alec.
In the wake of the murders, do you know if the hearing that was later that week got canceled?
It did get canceled.
That was a hearing in the boat case where he's personally a defendant?
That's my understanding, yes.
In the wake of the boat case, did you and the partners have a discussion about what to do about getting to the bottom of these Ferris fees?
We did. We did not the week of the murders because pretty much our office shut down the week of the murders, and then his father also passing away. But when we got back around to it, Lee and Mark Ball and I were the ones doing the discussion. Lee decided that he would call Chris Wilson himself directly and try to get the information, and Lee took over from there.
In the wake of the murders, did anyone want to bring that up to Alec again?
No, nobody wanted. Alec was distraught and upset and not in the office much, and nobody wanted to harass him about nothing that we thought was really missing. We had several months till the end of the year to clear it up, so we were not going to harass him at that point in time.
So that part just got stopped in its tracks, is that true?
Yes, Lee took over calling Chris Wilson and trying to pursue it.
All right, and when was that? You said in July sometime?
Yes, probably early July.
All right, and what was the result of that?
Lee said, and you could speak to him more clearly, but Lee said Chris Wilson got off the phone pretty quick with him, which was surprising because apparently Chris Wilson has the gift of gab. But again, Chris assured Lee that it was there.
All right. Ultimately, did y'all get an email about this particular issue?
We did. Ultimately, on July 19th, there was an email from Chris to Alec stating that the money was in Chris Wilson's trust and would have been available anytime that we requested it. That email was forwarded to Lee Cope and myself.
From whom?
From Alec.
And what is that the email up on the screen that you're talking about right now?
It is.
All right. And we see $600,000 for Andrew Ferris and $192,000 for Denise. Explain that breakdown, if you would, please.
So there's two parties in this case, and apparently there was 2 recoveries, and each of them would have had a fee dependent upon their recovery. So to me, this looks like Andrew's portion, the fee for his settlement was the $600,000, and Denise's was $192,000.
At this point in time, had the firm received this $792,000?
No.
Did this email, though, sort of end the inquiry, at least for the present moment?
Yes.
All right, well, let's move the story forward again. Did this matter ever come to your attention again at a later time?
Yes.
All right, and tell me when that came to your attention.
That would have been in September, after we found some other misappropriations, and we had confronted Alec, and he had resigned. We ended up having more conversations with Chris Wilson right after that, and Chris admitted that he did not have all the money.
Well, let me back it up. Before we get to there, I'm talking about as far as it relates to Alec. Did this particular issue with trying to get the Ferris fees come to your attention? And let me take you to early September of 2021.
No, not that I recall.
Okay. In early September 2021, did the Hirschberger matter that you mentioned earlier, did that come back to your attention?
That came back to my attention. I started pursuing that and decided I was going to go through and look and make sure that he had not tried to already defer something else that we had missed. And at that point, I decided to print a ledger printout of our system of payments to Forge. And as I did that, I started printing all the documents that would relate to those disbursements, the disbursement statements and the canceled checks. And as I started printing the canceled checks off, I could see Bank of America on the back and Alex Murdaugh's signature. And everyone that came out was just put it a little bit more in the grave for me. That's when I found that out. I had William Barnes come over, who was a partner who was in there in the office that day, and had him look at them. He also believed that they were Alex signatures on the back of these checks.
All right, and just real quick, these are checks coming from the client trust account?
Yes.
And they're made out to what?
Forge.
But what's unusual to you that's causing you to have that feeling that you just described?
The endorsement in the Bank of America on the back, and the fact that it looked like Alex signature.
Okay. All right. And so you talked to William Barnes, is that right?
Yes.
And did you talk to other partners about what you were finding?
We did. William and I then called Mark Ball, who had been aware of this situation the whole time. Mark Ball was the treasurer, so he came back into the office. We showed him the signatures. He agreed with us, and he also recognized one of the disbursements as a case that could not have possibly been dispersed yet because it was held up waiting some court orders for a workers' comp lien. We also talked to Lee Cope that night about it, and we came to the plan for Lee to call Michael Gunn with Forge and see if they had banked at Bank of America. And Michael Gunn confirmed that they had not banked at Bank of America in a number of years.
Did y'all send them a list of clients, the ones that you were pulling off of your system that had payments to Forge at Bank of America?
We did. We gave them a few names that evening, not the complete list. We gave them a few names that we had, and he verified that Michael Gunn verified to Lee Cope that those were not any structures or any annuities, and they didn't have records of them.
All right. Around this time, did Annette bring you anything, and that this is all going on?
Yes. So this is completely independent and coincidental. Annette, the same afternoon of September 2nd, was in his office trying to look for something, and when she moved to file, a check fell out. When the check fell out, she looked down, and it was Chris Wilson, and it was the $225,000 check payable to Richard Alexander Murdoch that we'd already found.
And I'm going to show you what's been marked as Exhibit 313 states for purposes of this hearing. Do you recognize that?
That's the check.
This is the actual check that was found. Is that right?
That's correct.
All right, hold on for me real quick. It's got an endorsement on the back. Let me ask you this. You've worked with Alex Murdaugh for how long?
23 years roughly.
During that time, did you become familiar with his handwriting?
Yes.
Can you recognize it when you see it?
Yes.
Looking at the handwriting, the endorsement on the back of that document, do you recognize it?
That's his signature in
This is
handwriting.
writing?
What, do you have copies of these various exhibits for the court?
Yes, sir. Your Honor, if you'll just give me 1 second, I'll hand the exhibits we're talking about up to the court as well. But up on the screen, is this the check?
Yes. Yes.
And then on the back, whose writing is that?
Alex.
Once you started printing out all those forged ones that had Alex writing on it in Bank of America, and you contacted Forge, did you ask them whether or not they ever banked the real Forge, if they ever banked at Bank of America?
Lee Cope had that conversation, and Michael Gunn verified that they had not banked there in a number of years, more than 10 years.
And they didn't have any active structures on any of the clients that y'all had given them?
That's correct.
As a result of that, what did the leadership at the firm do next?
We convened a meeting on the morning of Friday, September 3rd at Lee Cope's house with the majority of the partners and myself present. We discussed what we had found and showed everybody the documentation that we had recovered. And then the choice was made. Randy was not present initially. The choice was made to bring Randy in and show him what we had found.
And after Randy was brought in and showed what was found, what happened next?
Randy immediately conceded that we needed to talk to Alec, that it looked like he had stolen. And Danny and Randy got together and met with Alec outside of the office.
Okay. And did they confront him with this information?
They did, and it is my understanding that Alec admitted it and that it was determined he would resign.
Okay. Did he ask for a leave of absence?
I think he tried to do a few other things before resigning, but we made him resign.
After the decision was made to resign, was it announced right away, or was there any statement put out or anything like that right away?
It was not announced right away because the decision was made. Johnny Parker was getting married the next day, and it was late on a Friday, and that we were going to kind of hold off until the first of the week. We were going to contact some ethics attorneys and see what we needed to do and announce it the first of the week.
So we're in the weekend, September 3rd, September 4th, something like that?
Yes.
Is that Labor Day weekend?
Yes.
What's the next thing you recall hearing about Alec?
The next thing I heard about Alec was I was actually with my family on the sandbar, and the next thing I heard was Suzanne Peoples with the EMS came down and told me that Alec had been shot in the head and was being flown out to Savannah.
Was that on the side of the road at Old Salcahatchee?
That's correct.
What's the first thing you thought when you heard he had been shot?
Nobody knew what to think. A lot of thoughts went through, but fear went through. Was this retaliation? Was he involved in something bigger? that was going to get more of us in trouble, and just fear.
All right. As the months went on after that, did y'all continue to review your records looking for additional misappropriations?
We did. We immediately decided, once we found this out on September 2nd and had the confrontation on the 3rd, we immediately started doing a dig into our books and proactively going to look for anything. And anything that we found, we turned over to law enforcement. We also had a forensic audit from an outside firm come in and provided information from them. So this took most of September, gathering all this information and going through all of our stuff to figure out what else we had missed or what else had occurred.
You've already described the checks to the Forge account at Bank of America, which was a fake Forge account. Is that correct?
That's right.
Was there another manner in which Alex Murdaugh misappropriated money that you uncovered in your review of the firm's records as CFO?
Yes, we've also found out some payments made through Palmetto State Bank.
Okay. And generally explain how those were working.
So those were working on, some of those Russell Lafitte was the conservator on, and funds were directed to Palmetto State Bank as if they were going to be held for the beneficiary. And those checks were later converted into personal use for Alec.
All right.
And incidentally, the week after we of the roadside shooting, when we were going stuff in Alec's office, we actually found Forge, our Alexander Murdoch, doing business at Forge bank statements in his office.
Okay, so you found the Bank of America bank statements?
Yes.
And the title on those bank statements was what?
Our Alexander Murdoch, doing business as Forge.
Okay. I'm going to get a document marked, if I could, real quick. The client trust account checks, what color are they?
Green.
All right. And the operating checks, are they a different color?
Blue.
All right, 314 for this hearing. This will be the spreadsheet that's in one of the folders in the packet I just gave you. It starts at the top, the check date 12/26/18. And I'm going to show you what's been marked as states 314 for this hearing and see if you recognize that document.
Yes, this is a spreadsheet that we've developed of the money and the clients that had money stolen using the Forge payment method.
All right. And by the Forge payment method, you mean what?
Basically, checks payable to Forge that looked like they were going to be for a structured annuity on the behalf of the client.
All right. And again, for the purposes of this hearing, in preparing that chart, you've been keeping a chart and keeping these records. Is that correct?
That's right.
Is this all the misappropriations, or is this focused just on some for purposes of a particular category?
This is just for purposes of this particular category.
And what category is that again?
Forge.
All right. All right, I'm going to put this up on the screen. And just real quick, if you could just go across and tell me what the various categories represent, please.
Excuse me. The categories, if you see the column with category Forge payment, those would be where checks were actually written to Forge as if those were the beneficiary's proceeds that were being sent for a structured annuity.
Okay.
The next line where it says Barrett Boulware took insurance proceeds, this is actually a check that was payable to Barrett Boulware from Southern Fidelity Insurance, and Alec actually endorsed that check. He had power of attorney on that file. He actually endorsed that check, and later we were able to trace it into his personal accounts.
All right.
If you keep going down, the majority of these are Forge payment, If you get to Dion Martin, the first line says
Just
fake.
real quick, I'm sorry to interrupt you. Just going across, though, we've got the client, we've got the civil action number, we've got the category that you were just describing, we got the date the trust was funded, and then we have the amount. Is that
That's
correct?
right.
And the date the trust was funded, what does that category refer to?
That refers to when we found out and did the deep dive into exactly what had happened on each file and deposited the money back immediately into our client trust. So that's the firm actually, as we found these, put money in client trust. We then met with all the clients, reestablished what the correct disbursements should have been, and returned all funds to the clients.
So the firm had to pay the money back that you've determined in each one of these cases that Alex Murdaugh misappropriated through the fake forge on this list.
We did.
What's the total amount on this sheet?
$2,841,512.55.
All right. And again, does this represent everything or just a particular category?
Just a particular category.
Just real quick, I see that says 129.11 for Thomas Moore. Is that supposed to be 21?
Yes. And that would be the date and the check number of the check that was taken.
I'm going to hand Exhibit 314 up to you. And if you could correct that with my pen here, and then just put your initials next to it, please. Going back to Exhibit 314, if we look at all the check dates on here, we have the earliest one being about August of 2015. Is that correct?
That's right.
And then it continues all the way up to early 2021. Is that correct?
That's correct. Your spreadsheet that was just marked, have you also prepared some supporting documentation for each one of those transactions of misappropriation that you've identified? Yes, we have.
And these are from the records and your investigation into the records at the firm?
That's correct.
And each one of these, has the firm had to make the clients whole because of the defendant's misappropriation?
We did.
All right, I'm going to show you what's been marked as 315, and this is particular case is Elise Mallory. And just as an example, and see if you recognize that document.
Indeed, this first document is the disbursement which would have been drafted at the end of the case that states the recovery, expenses, fees, and payments to clients. Next we have, this one actually had a payment to forge, so I have a copy of that canceled check. And then the third and fourth pages are where we did our correcting disbursements with footnotes about what had happened and explained everything to our clients when we reimbursed them.
Okay. Let's put that up on the screen real quick. And are there similar documents, supporting documents for each one of these transactions that's on your spreadsheet?
There is.
All right. So this is a disbursement sheet, is that right?
That's correct.
And I didn't ask you, but very quickly, tell me what a disbursement sheet is and how they're supposed to work.
So a disbursement sheet just shows at the conclusion of the case, once the recovery, it will show the recovery amount, list out the fees that were sent to the attorneys, shows fee splits if there's multiple attorneys, shows the amount of expenses we collect back, any liens or loans that were payable that were in the scope of that case, and then the final amount would be the payment to the client or the client's beneficiaries if they had beneficiaries.
All right. And then down here at the bottom of this particular one, do you recognize that signature?
Yes, that's Alex.
Okay. And going to the second page, what is this right here?
That is a copy of the check that was payable to Forge that you saw in the bottom line of that other disbursement, as well as the back of it showing the endorsement.
All right. And is that the real Forge or the fake Forge?
That's the fake Forge.
All right. And then what is this document right here?
This is the correcting disbursement. The yellow totals would signify what the correct amount should have been and the corrections that would needed to have been made.
All right, going back to this first page, in this particular one, how much was the recovery?
$183,528.
All right, and then was there an attorney fee taken from PMPED?
There was an attorney fee taken. In this case, it was $30,000, which was a reduced fee. We generally get a third or 40%, but there are instances where the attorney will reduce their fee for some reasons.
Right. And do you know why? Who requested the fees be reduced in this case?
That would be Alec would have done that.
Alec did that, and so but those fees got paid to the firm from that recovery, correct?
They did.
All right, great. So the rest of that money went to the client, didn't it?
It did not. It actually went to the fake Forge account where Alec stole the money from the client.
Every last bit of it.
Every bit, the $152,866.
That client didn't get one dime until y'all had to make it right.
That's right.
And that's similar to the rest of the examples we have.
It's exactly like the rest.
Been going on for years.
Yes.
Documentation like that for each one of these, and they're in the packet up there. I'm happy to go through all of those with the witness. I don't want to sell myself short if I need to. I don't know if the point for purposes of Your Honor is made, or if you would like me to go through each one of those. I'm happy to keep going.
Is this Mr. Griffin? Is this yours?
So if you,
Okay. Let's indulge just one moment, Your Honor.
Do you have a summary of everything, Ms. Seckinger?
Ms. Seckinger, yes.
Seckinger is.
I can do that from the spreadsheet, Your Honor. And then we're marking the supporting documentation, which I'll go ahead and mark. But I think with Ms. Seckinger, we can kind of walk through each one and describe each one while we do that. But each packet has, we've got this spreadsheet that has each one on there. And then for each one of them, we tried to minimize it down to the bare minimum. And again, this isn't even all of the misappropriation. But we've just have a few supporting documents for each one, which is the disbursement sheet, the fake forged check typically, and then the corrected disbursement sheet that the firm had to do. That's generally what each packet has. For example, like the one we last did. Is that correct, Ms. Seckinger?
That's correct.
And so I can go through those quickly, and we can do that on the spreadsheet. And then we have one other category that they uncovered of manner in which he was able to misappropriate money going back to, I think, 2008, 2009, something like that.
You may proceed.
Thank you. All right. So, Your Honor, we're going through that packet that was provided up there with you, and we're going to go in order except for Hirschberger, which we already talked about. And so, Ms. Seckinger, can you see okay on that screen there?
Yes.
Okay. All right. I'm going to just kind of move through these as expeditiously but as accurately as we can. First one, we have this particular client, Ms. Adriana. Is that correct?
That's right.
All right. And I'm going to put 317 up on the screen. And is this the disbursement sheet for that?
That is the disbursement sheet for that, yes.
All right. And down at the bottom, do you recognize the signature where it says attorney?
That's Alex's signature.
All right. And would typically the attorneys meet with the clients and get them to sign these disbursement sheets before any disbursements were made?
Typically, we did the checks on the attorney's signature, and then the attorney met with the client and had them signed at the same time they distributed and discussed the disbursement.
Gotcha. All right. And then right here on this particular one, we have a total recovery amount of how much?
$247,500.
All right. And then the firm gets paid its fees out of that.
And again, that looks like a reduced fee of $22,000.
And what happens to the rest of the money?
The $225,073.46 went to a fake forge account that was for Alex's benefit.
All right. And is that the check right there?
That is.
Whose signature is that right there?
That's Alex.
All right. And that's $225 and change. And then you have the corrected disbursement sheet. Is that correct?
That's correct.
And this is where the firm had to make good on Alex's misappropriation.
That's correct.
All right, let's move to the next one. This would be for Mr. Barrett, using the first name. Is that correct?
That's right, Barrett Bolware.
All right, and just using the first name. We have this first one is the $75,193. Is that right?
That is the check I discussed earlier that was payable to Barrett that Alec endorsed directly and deposited into his account.
All right, and I'm on the exhibit 318. We're going to the third page, but is this that check right here that was made out to Mr. Bolware?
That is, and that was actually found as we went through his desk after September 3rd.
All right, and you recognize that writing right there? I can zoom in if you need to.
That's Alec's writing.
All right, and this is the deposit slip went along with it?
Yes.
And what's the name right there?
Alex Murdaugh.
All right, going to the next one on the list, we have this one, and the amount is $279,850.65. Is that right?
That's correct.
All right, and we're still in exhibit 318. And this is the disbursement sheet, the original disbursement sheet right there.
That's correct.
Whose signature is down at the bottom?
That's Alex Murdaugh's.
And what does that say right there?
$279,000, $850.65. Payable to forge.
Fake forge or real forge?
Fake.
All right, and then what is that right there?
That's the check payable to forge showing Alex signing it and endorsement on the back.
Okay. All right, let's move on to the next one. We have, this is Hirschberger. We already did that one, correct?
That's correct.
Well, yeah, we already did that one. All right, let's go on, and we did the next two. Those were those two fees that Alec told you he was structuring?
That's right.
All right, or at least this one was, correct?
That's right.
All right, let's go on to Ms. Gary. This is States 319. This is the disbursement sheet right here.
That is the initial disbursement sheet.
Okay, and what is that right there?
Excuse me, that is not the initial, that's the second one. So there's a forward structure right there of $112,500, a payment of the personal rep and the amount divvied between the beneficiaries. That forward structure should have been paid to the beneficiaries, and again, it was paid to the fake forge account.
All right.
You see the check signed by Alec and endorsed by Alec.
All right, so that's $112,500 right there, correct?
That's right.
And then you have the corrected disbursement where y'all had to make right to the clients.
That's correct.
All right. Moving on to the next one. We have Mr., and I'm going to use their first names. Use that for me if you can, please.
Okay.
All right, Mr. Christopher.
Mm-hmm.
All right, and we have this. You have this disbursement right here. Is that correct?
That's right.
And whose signature is that right there?
Alec Murdaugh's.
And we got how much?
$750,000.
Going to what?
Fake forge.
The fake forge. Is that correct?
That's right.
And then we have the check.
That we do.
And who's do you recognize that on the back?
That is Alec Murdaugh's.
Okay, and this is $750,000.
That's correct.
All right, And then we have another disbursement sheet where y'all had to correct it and make it right to the client.
That's correct.
Y'all had to pay back $750,000
We did.
that Alex spent,
We
client
did.
money.
We did. He stole it.
All right, let's go to the next one. Dion Martin, we have 3 for Mr. Martin, is that correct?
That's correct.
All right, let's look at that. We have,
So you have a little new category here. You see the above where it says structured annuity directly to Michael Gunn for $500,000, and then it's offset by the proceeds structured annuity below. This would represent like there was an annuity associated with that case that had been properly structured and sent, and that resulted in there being a $200,000 fee taken on that $500,000 that should not have been taken from the client.
so just a sleight of hand with paperwork, and Ella created a phantom real $200,000 in fees from thin air.
That's right.
All right, but that's not the end of this one, is it?
No.
Okay. All right, right here on the second page, we have a disbursement to Forge, is that correct?
That's right.
And is that real Forge or fake Forge?
That's the fake forge.
How much is that one?
$338,000, $56.14.
Okay. Now, we already talked about on this list, we talked about the fake fee of $200,000 that you just mentioned.
That's right.
And we did the 338,056.
That's right.
14. Okay, let's keep going. And what's that?
That's the check for the $338,000 that's payable to the fake forge and endorsed by Alec.
All right. And then what is this disbursement sheet?
This one is showing a structured payment of $45,000, and this one incidentally had a quote attached to it and is signed by the client. And that also went to the fake forge account and his personal account. This is a copy of the quote from Forge.
But no Forge structure was ever
No,
materialized.
none was done. We verified none was ever done.
All right. And what is that $45,000 check there?
This is the $45,000 check to the fake forge deposited by Alec.
And is this the disbursement sheet where y'all had to correct it and make it right to the client?
Yes.
All right. Moving on to the next one. We have at least Mallory, and that's the one I showed you at the beginning as an example. Is
That's
that
right.
All right. So we've done that one, and that was $183,528, where he took every last dime of it. Is
That's
that correct?
right.
Yeah. All right, the last one I talked about was 321. The one before that was 320, and the one before that was 319. We are now on 322. Let me turn the page. And we have Mr. Jamian, is that correct?
That's correct.
All right, and right here we've got a disbursement sheet, is that correct?
That's correct.
All right, and we have a forge of $90,000.
That's correct.
All right, and is that real forge or fake forge?
Fake forge.
Okay, and what is this right here, sideways?
That is the check payable to Forge, the fake forge, and the endorsement on the back of the check.
All right. All right, and then we have an expense disbursement right there of 5541.17, is that correct?
That's correct.
And is that another amount that y'all had identified?
We identified later that that was an incorrect charge to a client file, so we reimbursed that as well.
Okay, and is this that page right here?
Yes.
And what did Alec bill to the client that y'all determined was improper?
Some airfare.
To where?
On a private flight. I can't recall, but I believe that one might have been down to the Keys.
All right. Did y'all have to pay that money back too in this corrected disbursement?
We did.
That was Exhibit 322. We got 333. Mr. Johnny, $95,000. Is that right?
That's correct.
All right. On the first page, we have the disbursement sheet, and we have a forge line right here for $95,000.
That's correct.
Did that go to the real forge or the fake forge?
Fake forge.
Okay. We have a copy of the check right there. Is that correct?
That's the copy of the check and the endorsement, and a copy of the correcting disbursement.
Y'all had to make that right to the client.
We did.
Moving on to 324, Mr. Jordan.
We got a disbursement to Forge, is that right?
That's right, for $85,000, along with the fake check and the endorsement on the check.
Okay. And then the corrected disbursement, correct?
You missed the one for $65,000. There was two in that one.
Yep, there it is right there.
That's right, and then the correcting.
All right. So we had an 85 and a 65,000 for that one, correct?
Correct.
Exhibit 325. This is now Mr. Manuel, and we have a $70,000 forge. Is that correct?
That's correct.
Fake forge.
Fake forge.
All right. And what's that right there?
The check payable to Forge, the fake forge, and the endorsement. And this is the correcting disbursement where we paid the client back that $70,000.
Go on to the next one. We got Miss Mary, and we got a settlement proceeds to Forge of $19,500 right there. Is that correct?
That's correct.
And this is Exhibit 326. And did that go to real Forge or fake Forge?
The fake forge.
All right. And what is that right there?
Copies of the check, the fake forge, and the endorsement on the back by Alex.
All right. And then the corrected disbursement having to pay the money back
Correct.
by the firm. All right. Going on to Mr. Randy. Right here, we've got a disbursement of $9,569.30 on Exhibit 327.
Correct.
All right. Next page, we have what?
The copy of the check payable to the fake forge and the endorsement by Alex on the back of it.
All right. And then the correction disbursement.
Correct.
All right, and last one for this set is Exhibit 328, and we have Thomas Moore. Is that correct?
That's correct.
And whose signature is that right there?
That is Alex.
And an amount to Forge of $125,000. Is that right?
Incidentally, that's a forged signature for the client. The client confirmed that when we met with them.
Do you recognize that handwriting
It appears to me to be Alex printing.
on the disbursement sheet?
Yes, sir.
All right, and then we have the fake check right there,
That's correct.
or the fake Ford check, and then that's all on that one for right now. Is that correct?
Well, it's partial correction. Yeah.
Okay. All right. Things like this going on in a lot of cases that Alec had? Fair amount?
Well, we found them in these several cases, and in the scope of all cases, not so much. I mean, we have a ton of volume, so this doesn't represent a large proportion of those, but this was common with them.
And that's my point, is
Yes.
that there's a large volume,
Yes.
and these are sprinkled throughout over years and years and years.
Sprinkled out over a decade or better.
Whenever there was an opportunity, it happened.
Yes.
All right. I'm going to show you. Let me get a couple more documents, Mark. show you what's been marked as Exhibit 329 here to this proceeding, and see if you recognize that.
I do. This is a spreadsheet of the payments that were made to Palmetto State Bank and misappropriated through that method.
All right, you testified earlier that the fake forge account, the Richard Alexander Murdoch DBA forge, started around 2015. Is that right?
That's correct.
But you just uncovered a different mechanism whereby Alex Murdaugh misappropriated money from clients prior to that. Is that correct?
That's correct. Most of these took place in 2011 and 2012.
Okay. And did Alec have some particularly big cases in those years?
He did.
And what were those cases?
So he had Arthur Badger, which was against a UPS truck in Allendale where his wife was killed, and I believe a couple of children hurt. There were several beneficiaries in that case. In that same wreck, well, then they had another one with Hakeem Pickney, who in that same wreck had a cousin in the car named Natasha Thomas.
Okay. Let's talk about the Badger case. What was the total settlement in that particular case?
In the Badger case, the total that was apportioned to Arthur Badger was $3.1 million. There was also a companion case, Donna Badger, with a good bit apportioned to it as well. I can't recall the number right here right off the top of my head.
All right. But just for Arthur Badger, who was just one of the clients that Alec had, correct?
Right.
Just for Arthur Badger, what was the attorney fee that he received in that settlement?
He received $1,240,000.
The firm did.
The firm
But
did.
that would be ultimately on his books at the end of the year.
It would be credited to him.
$1,260,000, is that right?
$1,240,000.
Is that all the money that Alec received from that particular case once y'all did your review?
That is not.
What else did Alec take?
$1,325,000.
Another $1.325 million, is that right?
That's right.
And how did he go about doing that?
Checks were payable to Palmetto State Bank that were then converted into personal items, payments for bank loans, payments for loans from a conservator account, payments to Johnny Parker, I believe it was, one to his father for paying back personal loans that they had given him.
Okay. And so we've got now what's been marked as Exhibit 329 up on the screen. I'll let the sirens go by. Guess I'll just talk over them. All right, we've got on this one at the top, we have Mr. Arthur Badger, is that right?
That's right.
And we have the date, and we have the amount, which is how much?
$1,360,000, and that is because we returned the PR fee in that case as well because the PR failed to do their job properly.
Okay. And I'm going to show you what's been marked for this hearing is 330. And is this the disbursement sheet?
Yes, sir.
And down here we have Palmetto State Bank payment to fund structure per client request. Is that right?
That's right.
And that's the $1.325 million.
That's correct.
And did that go to the client?
No.
I see there's an email right here. Who is that from and to, and what's the date on that? You need me to bring it to you?
So this email is from Russell to Alec. Doesn't look right. There was an email that came from Alec to Russell asking if we could recut the checks in a certain way. Then Russell independently sent an email to Alec, which was forwarded to me and my accounting staff, asking if we could recut the $1.3 million check into 4 different checks.
And did y'all do that?
We did.
Have any reason at all to mistrust what was going on at that time?
No.
All right. So ultimately,
And ultimately, those got broken down into all these payments. This is the payments of how these checks were written and what benefit they went to.
and they were made out to what entity?
Palmetto State Bank.
And then after they were made out to Palmetto State Bank, what happened to them?
They got converted to personal usage for Alex Murdaugh's benefit.
Real quick, I see the spreadsheet says July 2005. I'm going to point you to this disbursement, though. What's the date on that disbursement?
November 2012.
So is that an error that needs to be corrected?
I'm sure that that's an error that needs to be corrected.
I'm going to bring your spreadsheet. Let's do that real quick. Give me a pen and November 11th, 2012. All right, let's talk about another case. I'm looking now at Exhibit 332, and we go back to your spreadsheet, and we have Natasha Thomas. Do you recognize that?
I do.
All right, and what was the amount on that particular one?
There were two payments. One was for $325,000 even. The other one was $25,245.08.
All right, and looking at Exhibit 332, we have down here at the bottom, we have payment, and it says what entity right there?
Palmetto State Bank.
For $325.
Yes.
So was a check cut from the trust account for $325?
Yes,
And is that it right there?
that is it.
And did that money go to the client?
No, that money went for Alex's benefit.
All right. Did y'all have to pay that back and make that right for his
We did pay that
misappropriation?
back.
All right.
What you're seeing now is just all the different payments that were made from that money.
Those were converted at the bank into personal use for Alec.
That's correct.
All right, we're looking at the second check for how much was that?
$25,245.08.
All right, and that's made out to what entity?
Palmetto State Bank.
From the client trust account?
Correct.
Did that go to the client or did that go somewhere else?
That went to Alex's personal use again.
All right. And did y'all ultimately have to make that right?
We did.
Last one is Mr. Hakeem, correct?
That's correct.
Is that in a companion case to Ms. Thomas?
It is.
Mm-hmm.
Got two misappropriations, is that right?
That's correct.
Okay. Looking at this disbursement sheet, we have right here on the disbursement sheet, what entity is that?
Palmetto State Bank,
For how much?
$309,581.46.
All right, and that's signed by who on this?
Russell Lafitte, conservator.
And is that the check right there?
That is the check.
Made out to what entity?
Palmetto State Bank,
In what year?
December 2011.
Okay, and did that money go to the client?
It did not.
Did you ultimately have to pay that back?
We did.
And then finally, $60,000 for
The
opinions.
PR fee again. We decided to pay the PR fee back.
And that's the PR fee right there for Mr. Lafitte, is that correct?
That's right.
The one who signed that disbursement sheet.
That's correct.
mentioned Russell Lafitte. Do you have a relation to Russell Lafitte?
Russell Lafitte is my brother-in-law. He's married to my husband's sister.
June 7th, 2021, you came in demanding answers about those Ferris fees, correct?
That's correct.
And that conversation ended because you got a call about his father, correct?
That's correct.
And the inquiry got pushed to the side because of the tragedy of the murder of Maggie and Paul, is that correct?
That's correct.
And additionally, Alec called you about having to get finances together for a hearing in the vote case later that week. Is that correct?
That's correct.
And that hearing got canceled as a result of the tragedy of the murder of Maggie and Paul.
That's correct.
And ultimately, in July, y'all received an email from Chris Wilson saying the money was in the account. Is that correct?
That's correct.
What did you later find out about whether or not all that money was in the account?
We found out after September 3rd that all that money was not in the account. Chris Wilson called us and actually wanted us to pony up the other portion of the money.
And what portion was that?
There's a couple $100,000 that was still missing.
And once, a few months later, your attention got turned back to these matters, and you ran that inquiry, then the whole thing started to unravel. Is that correct?
That's correct.
Not further at this time, Your Honor.
Mr. Griffin?
Yes, thank you, Your Honor.
Do you have an idea about how long you plan to be? So we'll take a break now for about 10 minutes.
seated.
Mr. Griffin?
Good morning, Ms. Seckinger.
Good morning.
I want to first just go to June. I want to go to June the 7th when you were up in Alex Murdaugh's office, and you were talking to him about the Ferris attorney fee money, correct?
Correct.
And while you were in the midst of this conversation, he received a telephone call informing him that his father was being readmitted back to the hospital, correct?
That was my understanding, yes.
And his father had just gotten out of the hospital either that Saturday or Sunday, right?
I don't know.
Okay, and do you know that he spent the Friday night in the hospital with his dad?
I don't know.
Do you, well, his father was Randolph Murdoch, who was one of the principals of that law firm, correct?
I know who his father was, yes.
Was he a principal of the law firm?
He was previously. He wasn't at the time of his death.
Was he beloved by the partners in the law firm?
Yes.
And his father, and when Alec got the phone call that his father was going back into the hospital, and you mentioned that the belief was that it was terminal.
Correct.
You stopped your work and turned into a friend, right?
That's correct.
Provided him sympathy, correct?
That's correct.
And backed off of what you were doing to allow him to whatever he was going to do with his father, right?
That's right.
And so when you walked out of the office, things had come to a standstill as to your investigation through Alec directly as to where's the Ferris fee money, right?
That's right.
And Mr. Randolph Murdoch passed away. Monday was the 7th. He passed away on the 10th, I believe, didn't he?
I'm not sure of the date, but that sounds right.
That Thursday, right? And if Alec had stayed out of the office from that Monday when he got a phone call that his dad was going back in the hospital and terminal until his dad passed, and shortly after he passed, I mean, no one would have said a thing in that firm, would they?
I'm not sure if they would have not.
Now, what you were looking at, investigating, was where is the fee due to the law firm on the Ferris case, right?
That's right.
And that was a case where Alec was associated with Chris Wilson, and they represented plaintiff, I assume, Mr. Ferris or Ms. Ferris or the state of Ferris.
Correct.
And they got a excellent result during the case. It was a verdict, a non-jury verdict after a trial in Richland County. You remember that?
I don't know the details of the case.
And that and you were the firm got an expense check but no fee check, and the immediate question went out to Chris Wilson's paralegal, where's the fee for the law firm, correct?
That's right.
And the paralegal said, our bosses got paid, and then that caused you to look into the matter.
That's right.
Okay. Now, and Alec told you, no, the money is still in Chris Wilson's trust account, right?
That's right.
And he said that to you on multiple occasions.
That's right.
And in fact, Chris Wilson sent an email saying the money's in my trust account.
He did in July.
In July, that was forwarded on to you, right?
That's right.
And I noticed, well, let me back up. Did Alex explain, did he come up with a story to explain, well, the reason the money is in the trust account is because I'm considering whether to structure the fee?
We did discuss that, yes.
And in that law firm, your law firm that you're an employee of, partners have structured attorney's fees in the past, correct?
They have.
And so the fact that, and just so the record is clear, when we're talking about structuring attorney's fees, it is delaying the payment of the fees through some financial product. Isn't that correct?
That's right.
And by delaying the payment of the fees through a financial product, if successful, it allows to delay the payment of taxes on that money.
That's correct.
Now, in the times that the fees have been structured in the past, when the payment of the fees have been delayed, who is the beneficiary of the financial product? Is it the partner that brought the fee to the firm, or is it the law firm?
So we've only done it once or twice in the past, and when it was done, it was the beneficiary was the partner, but it was also contributed and figured into our allocation at the fee breakdown at the end of the year.
So there's no, I mean, the fact that there's a structure, the time you did it, when it was disclosed above board, it is, and just use, say, a $100,000 fee, for example. I mean, to allocate it to the firm, that partner who delayed receiving $100,000 till sometime in the future would still have to put his 7.5% or her 7.5% into the kitty of the firm?
Right, and that would also be a percentage of the money that he would receive. That'd be taken into account of that.
Well, would it? I mean, if it was $100,000?
It did.
So he got credit on, or she got credit for the $100,000, even though it never went to the firm?
Yes.
Okay. So if a partner,
If a partner did it correctly, it would be recognized and it would be accounted for correctly. The question wasn't whether he was going to structure a fee, it was whether he had received the fee personally.
understand, and he had said he had it and it was at Chris Wilson's office.
That's what he stated.
Now, the spreadsheet and the files that you were asked about, I noticed the Ferris matter wasn't on any of them, correct?
That's right.
And the Ferris matter wasn't on any of them because the Ferris matter, the firm ultimately got paid $792,000, which was what the firm was owed on the Ferris case.
We did.
And after Maggie and Paul's murder, and after Mr. Randolph's death, murder on the 7th, Mr. Randolph Murdoch's death on the 10th, how long of a delay was there before you got in touch with Lee Cope and Lee reached out to Chris Wilson?
There wasn't a delay in me getting in touch with Lee Cope. Lee Cope knew about it. The decision was made to call me off of it. Now Lee would deal with it from there with Chris Wilson.
Okay, so as far as you know, there was no delay. It was just taken over by Lee Cope.
There wasn't a delay on my part. It was taken over by Lee Cope.
And you don't know whether Lee, how long it took Lee Cope to reach out
You
to
would
Chris?
have to ask Lee.
And so, and you can't testify to that. You would have to ask Lee, right?
Yeah, I don't know.
And then you had talked about a Hirschberger case where there was actually what appeared on paper to be a structured fee, correct?
That's right.
And you're having done one in the past, it did not appear that that the proper procedures were followed so that Alec would have to pay income tax on it,
That's
whether
correct.
it's structured or not.
That's correct.
And his explanation, I think you said that was back in,
Late May, early June.
yeah, that check was May 12th, 2021, the Hirschberger.
I can't be sure when the exact conversations were. They were all going on around the same time, but it had been after that check.
Okay. And that, and so the thought there was, and Alec told you that, well, I'm just trying to sort of shelter money from me, put in Maggie's name because I'm being a defendant in the voting code.
That's correct.
Now you and your firm, and you've had outside forensic accountants looking at everything, and you don't have any information or evidence or documents that would suggest that any of the Hirschberger fee went into Maggie's name.
I did not pursue that portion of it. We have testimony from Michael Gunn that there was no annuity set up.
Right. And I guess, right. So as far as you can tell Judge Newman here today is that Alec put that money in a fake Forge account that was Alex Murdaugh doing business as Forge.
Correct.
And you don't have any information that that money then went into Maggie Murdoch's investment account, personal account, or any sort of account, right?
I know that it went into his Forge account. After that, I don't know how it was used.
Okay. And I think you said that that you didn't start back up and looking into the Hirschberger matter until sometime in, I think you said, it did not readdress it until late September.
That's correct.
Okay. And early September, you were sitting in your office and you had a epiphany, or just a thought. Well, let's just see what these. How many times his cases have checks going to Forge?
Well, when you're speaking of epiphany, I had started digging through his client list for every fee that he had brought in. And rather than going one by one, my epiphany was, let me just run a payment ledger on Forge and see what that turns out, rather than digging one by one.
Okay. And what prompted you to do that?
Because I was trying to look to see if there had been any more settlements that had been written to Forge like this other one with Hirschberger, so that we could account for them and discuss how we were going to handle them at the year end with the bonus distribution.
I see. And at what time of the year do you have to prepare final reports for the
December.
partners? For December? And when do you start working on that?
It depends every year, but usually December.
But in September, you were, I guess, doing your job, trying to see if there were other Hirschberger type structures out there.
That's right.
Okay. And so you ran a report of financial records that were maintained at the law firm, correct?
Correct.
These were electronic records?
Yes.
And you didn't have to order bank statements from anyone. You had them right there on your computer system?
I have mine, yes.
And there's nothing that happened well, let me back up. We've seen checks to Forge, I think you said, going back to 2015.
Correct.
Have those checks been on the firm financial system and maintained them since 2015?
They were. They didn't catch our attention before that.
Okay. And there's nothing about the murder of Maggie and Paul that prevented you from accessing that information at any point in time, is there?
No, what prevented me was work and personal obligations to get to that point in time to have the opportunity to look.
And but the information had been at your fingertips. Anything that was done in 2015, it was there. 16, it was there. 17, it was there.
That's
18.
right.
And that's why you were able to go back and do the work, and law firm stood up and made these clients whole. Is that right?
That's right.
Now, do you have the summary exhibit 314 up there?
I do not.
I may have it right here. Well, I guess I can put on Mr. Elmo here. It's not my favorite animal, but well, let me just have you look at this right quick. Can you go through Exhibit 314 and there, the grand total is $2,841,512.55, and tell us, just identify anyone on this list that is just straight diversion of fees that were due to the law firm.
Both Hirschbergers were straight diversions of fees that were due.
Is there any other one on here?
Partials of some of the other ones, I can't remember the breakdowns, but I know like at least Mallory or one of those two, some of them should have been firms' fees due to them.
Right. But all the other ones, but the Hirschberger matter, involve proceeds that should have gone to the client, right?
Which your client stalled, yes.
Right. And that, well, you investigated it and you came to that conclusion and the law firm came to that conclusion, right?
Yes.
Okay. But as part of the investigation, did you have to interview the clients and ask the client, hey, did you authorize Alex to put this in a fake forge account?
We did interview the clients, most of them. We met with them. Most of them were very surprised and shocked and stated that they had no idea
Right.
that they had been stolen from.
And so to establish that the clients didn't authorize Alex to do what he did, I mean, you had to go to the clients
Correct.
and get their response.
Correct.
And you accepted their response, rightfully so, correct?
Correct.
On this list of 314, is there anyone where you didn't go to the client or the client representative, except perhaps Hirschberger, and say, did you authorize Alex to do this?
I might not have met personally with all of them, but somebody within our firm did.
Right. Okay. Now, Barrett, the second one, Barrett Boulware, said took insurance proceeds, and that's Exhibit 314. And I think you said Alex had power of attorney?
He did.
And was Mr. Boulware alive in 2018?
I don't remember.
And how is it that you know that Alex did not have permission from Barrett Boulware to keep that money personally, that perhaps Mr. Boulware had owed him some money?
When I believe Ronnie Crosby's the one who spoke with Jarrett Boulware, who is his PR, so that'd be a better suited question for Ronnie than it would be for me.
So we would need Ronnie Crosby and Jarrett Boulware to come in and testify as to what Barrett Boulware may or may not have agreed to do with Alex.
You may have one that he could come in and testify that too, but the rest of these on these lists, people have told me that they either did not know about it, it was covered up, or it was forged.
And they would need to come in and tell the
They
court.
would, and they have.
Or they've testified?
They believe they have.
Not in this proceeding.
Not in this proceeding.
Now, there was another group of cases that involved Palmetto State Bank, is that correct?
That's right.
And your brother-in-law?
That's right.
And again, there's Arthur Badger, Natasha Thomas, Hakeem Pinckney. Do you know if Mr. Lafitte or anyone at the bank was personal representative or conservator for any of these folks?
He was conservator for Natasha Thomas. I believe he was conservator for Hakeem Pinckney. I can't remember the exact circumstance. And he was the conservator for Arthur Badger's wife.
Okay. And Mr. Lafitte, I mean, all of these checks went to Palmetto State Bank, correct?
Correct.
And then from Palmetto State Bank, they were sent out to pay, according to your investigation, expenses that Alec owed. Is that right?
Correct.
And repayment of loans that Alec owed, right?
Correct.
And that Mr. Lafitte was knowledgeable about that, as far as you know, right?
Appeared to be.
Now, I want to go into a little bit more detail on some of these. Let's just go to, I'm going to put it up with Ms. Elmo, and it is the Ben Allen Kendall. Well, that's Hirschberger, but let's don't do that. Let's do the next one, Adriana. And let's see if I can do this right. Do you see that one? That's the disbursement sheet.
Yes.
And the recovery amount here is, and it says settlement proceeds to Forge Consulting, and that's $225,000.
Correct.
And that, according to this document, represents what the client should have gotten and didn't get.
Correct.
And then the attorney's fees here said $22,000. Is that the firm got $22,000?
Yes.
Okay. And then this same exhibit, there's a lengthy footnote down here. I guess, does this footnote explain what happened?
Yes, it does.
In this footnote, it says there were 3 previous disbursements in this matter. Is that right?
Yes.
And it says the first one occurred on December 13th, 2018, issuing attorney's fees and costs, $19,932.89 to Palmetto State Bank, satisfying loans and et cetera, and other matters. Is that right?
That's correct.
Now, do we know if any of those are fake bills?
They look to be legitimate.
did you confirm they were legitimate?
Yes,
And how'd you do that?
by looking at the paperwork and observing the paperwork.
Okay. And then here, there was another disbursement on December 20th, 2018. Is that right?
That's right.
And this document referenced some exhibits. There's an exhibit A through F. I don't believe that's attached. I mean, it may be. I don't have it. Did you prepare this footnote?
I don't remember which ones exactly I prepared. I've prepared a lot of them, and Chelsea Van prepared a lot of them as well.
So, and most all these have an explanation and a footnote as to what the entire transaction was
That's
about.
right.
Okay. And you didn't do every single one. It was a team effort, I take it.
That's right.
And so people on the team investigated it and then would have to come here, explain exactly what they did and what they learned. And
That's correct. It's also been through forensic audit and also looked at former FBI, and it's been provided to law enforcement who all looked over it as well.
okay. All right. Now, I think you also said that back to June the 7th, that you said that Alex called you and asked for his updated balance in his 401k,
That's right.
and he told you he was putting together some financial records for civil discovery in the voting case. There was a hearing coming up,
Yes.
and that he'd asked you. He'd questioned you previously about the balance in the 401k.
That's right. It's not been the first time.
And the times that he questioned you, was it in the context of putting together information for the voting case, or just he was curious?
Putting together information for financials.
Okay. Financials in general, or financials in the voting case, or you just don't know?
I didn't really ask particulars.
Okay. So
The perception was that it's for the voting case. Talking in the office, we knew hearings were coming up. We knew they were looking for his financials.
okay. Well, when you said on the 7th he called you about financials, did he reference the voting case?
I believe he did.
Okay. Now, do you know what impact or what consequences Alec would have suffered from his partners if he had or if you had found that he had diverted the Ferris fee to himself personally, as opposed to putting it in a structure or putting it in the firm? Do you know?
I think that he probably would have had some bad repercussions for him, because they were adamant that we were not going to be part of having any portion of hiding or diverting any fees.
And the concern was hiding fees from the civil discovery in the voting case.
Yes, at that point in time it was.
And that wasn't And at that point in time, no one was saying that they thought he was stealing from the firm, but that he was sheltering money from being disclosed.
That was the opinion, yes.
And then it wasn't until September when you ran a report and you saw all these forged checks being deposited in the Bank of America account and endorsed by Alex, you'd seen his signature, that you realize there's been something far different going on than what anyone believed. Is that
That's
right?
correct.
And that's what led to his resignation or termination.
Correct.
And that information had been in the books and records of the law firm since 2015.
Correct.
One last question: that the information that in part of the investigation, where you and members of your staff and the forensic accountants determined that the clients did not authorize any of these transactions. I mean, you have no personal knowledge other than what's been told to you by people working for you or by the clients, right?
I also saw some of the deposits going into his personal Bank of America account statements.
No, I understand that, but whether the clients,
If they had some back deal, I don't know about any of it, no.
right. And any information you have about what the clients told the firm is hearsay, as far as you know.
It's not hearsay if they said it to me.
Okay. And some said it to you.
Yes.
Okay. Thank you.
Very briefly, Your Honor. One thing you know is that the money that you've talked about for the fake forge went into an account Richard Alexander Murdaugh DBA Forge, correct?
Correct.
Is there any possible legitimate explanation for client trust funds to go into that account?
No.
And after you realized that they went into those accounts, did the firm ultimately refund the money to those clients?
Yes.
You mentioned that you actually found in his office some bank statements for that particular account. Is that correct?
That's correct.
We'll show you what's been marked as Exhibit 335. Have you take a look at it? Is that consistent with the Richard Alexander Murdaugh DBA fake forge account that you saw?
Yes.
That you had repeated instances of client trust money going into?
Yes.
That there's no possible legitimate explanation for?
That's correct.
You were asking questions about the manner of your inquiry and that sort of thing. And I want to take you back a little bit further very quickly. Do you remember, is it common for, after the books get cleared at the end of the year, for certain partners to loan money to the firm to handle operating expenses until fees start to come in?
It is. Basically, we wipe out all the cash reserves, so in order to operate for the first couple of months, attorneys will loan money to the firm for operating expenses.
At some point in time prior to all of this, did you become aware of an instance in which Alex Murdaugh had erroneously received a repayment that was actually meant for his brother, Randy?
We did.
All right. And did that happen once, or did the same thing happen twice?
It actually went through twice. The check was written to him erroneously, and within a few days, he brought the check back to my staff and had it recut to him. So the first check that was recut was held for him for about a year. So the replacement check went through immediately, and the first check cleared about a year later, and that's when we discovered that going back and looking, that I discovered that he was paid erroneously, that it should have been Randolph Murdoch and not R. Alexander Murdoch.
So it was one repayment, but he managed to get it twice.
That's right.
How much was that check roughly, do you recall?
$125,000 roughly.
$125,000. Was he confronted about this when that was discovered?
Yes.
What was his explanation?
His explanation was that it was an accident, that he thought it was due to him and that he didn't know, and that he found the other one later and deposited it too because he thought they were due to him.
Okay. And was he required to pay that money back?
Yes.
And after he gave that explanation of, oops, I didn't realize these $225,000 checks were for me, was that matter then forgotten or moved on from?
It was shelved, yes.
It was shelved. Nothing, no repercussions happened at that point in time or anything like
No.
that? Okay. So the money gets paid back and people moved on. Is that right?
That's right.
Okay. You testified before that when the murders happened, that the inquiry, nobody was going to bring that up now in the wake of the murders, the Ferris fees that you had talked to Alec about the morning that Maggie and Paul were killed, correct?
That's right. It's a family-like place. Everybody was concerned for him, his family. We knew we had time to discuss this before the end of the year, and at that point, like we said, we didn't think he was stealing any money from us.
They had no reason at that time to think he was stealing, correct?
That's right.
And so it did get shelved, correct?
That's correct.
All right. And then in July, you got an email, is that correct?
That's right.
And you testified to this before. What did the email say from Chris Wilson's office?
It said that the money was in the account and available to us at any time that we would ask.
And then, so at that point, the money seemed like it was there. The money is not missing, and so the matter was shelved. Is that correct?
That's correct.
All right. However, you've testified that things have been going on for a while, and it was months later that triggered you to do that inquiry. Is that correct?
That's right.
Okay. Because there have been multiple instances over the years. Is that right?
That's right.
But that has nothing to do, the fact that that might have occurred regardless of at any point in time because of all the things that have been going on. That has nothing to do with the fact that when things were happening in June, they got shelved, and then you found out the money was there, and you thought that matter was closed. Is that correct?
That's right. We never knew about the prior. We had no reason to look. We had no complaints from clients. We had nobody saying they were missing money. And this just turned up when we started searching because of the Hirschberger and the other relevant things.
Has there been instances in which Alec used the firm credit card for personal expenses and was required to pay that back?
Yes.
And if the money got paid back, well, then everybody moved on. Is that right?
That's right.
So there was a history of that.
That's right.
You get the money back in, and everybody moves on. Is
That's
that correct?
right. It's a history of trust and brotherhood.
And that's what happened in July with the Ferris fees. Is that correct?
That's right.
You were asked about whether or not you were told in July that the money was in Chris Wilson's trust account. That's what you were told. Is that correct?
Correct.
Have you come to find out, however, that it actually had not been there?
We did.
And you found this check proving it, correct?
That's correct.
The bottom line is that there had been a long history of if the money got paid back, people would move on, correct?
That's right.
Things were continuing to percolate. They got delayed in June because of everything that happened, correct?
Correct.
But you were now curious, and eventually, months later, you look back at that. Is that correct?
That's correct.
And that also was highlighted and sparked by the discovery of the check, proving that he had not been telling the truth the entire time.
Correct.
Thank you. Nothing further.
Anything further? All right, thank you. You may step down. running up on lunchtime. Mr. Waters, what's next?
Well, we can certainly continue with this. We have Annette Griswold, who is Alex's former paralegal, who in large measure will testify to the similar events with Thomas Moore Hirschberger and the Ferris fees. Again, I don't want to be cumulative for purposes of this, but she will certainly add to that. We also have available on this particular issue Michael Gunn, who is the principal in Forge, who of course will testify that he had never had any discussion with Alec about structuring fees, or at least nothing had ever been set up, and that this account is not his, and that all the money in these various transactions never went to him, and that they were diverted. And then we have Chris Wilson as well, who can describe the circumstances of those Ferris fees. All that would be very lengthy, but we have all of that available in as much as that's necessary to complete the story for purposes of the in-camera hearing. We do have, though we have arranged to get additional SLED and other witnesses here related outside of this for the afternoon, if you wish to make use of the jury for that. And also, as it relates to this, and we're also prepared to offer testimony about these particular instances, but we do have a confession of judgment that I would offer to the court at this point in time in the Satterfield case. And again, before the jury, we would have testimony about that, but for purposes of clear and convincing evidence, we have this confession of judgment that we would offer for purposes of this hearing as well. In addition, we have his disbarment from the Supreme Court, which also refers to his admissions of financial misconduct, which we believe also are relevant to the court's decision at this point as to whether or not there is clear and convincing evidence established of these various other crimes. And so we would offer those as well to the court for its consideration now. However, we can certainly offer testimony about those aspects as well. I think, Your Honor, if we can get to a decision point on the law firm witnesses, then we can move forward. And again, we have some witnesses related to Satterfield that we could address and try to work that in over the next few days of court time. And then finally with the boat case as well. And so that would be some of the financial witnesses that we would offer. And then finally, Your Honor, we do have some witnesses from Palmetto State Bank who will talk about the extent of Alex Murdaugh's financial condition at the time the murders happened, and the reason why, explaining the reason why all these things were occurring and why they were all coming to a head in June of 2021.
Mr. Griffin.
Your Honor, I think there's more than enough in the record from this witness to establish that this evidence is not admissible under 404B. And, I mean, without even getting to whether they can prove it up by clear and convincing evidence. I'm happy to make that argument at any point in time. But if the whole landscape that he just talked about, Your Honor, 403 also includes a component of undue delay. And as he just described, all the financial misdeeds or crimes that he wants to prove up, we're going to be here until end of February, I suspect, or March, because that's adding 2 weeks to this trial.
Yes, sir.
Yes, sir. And obviously, as I even pointed out with this witness, we're trying to streamline the presentation. Frankly, the extent of misappropriation is very, very broad, and we're trying to focus on just a few areas. And the ones that we're focusing on are the ones that really came out of his mouth within seconds of law enforcement being on the scene, within seconds of the 911 call happening, and that is, of course, the boat case. And what does that mean? But there's two things that are very temporally connected with this particular crime, and that is the confrontation with Ms. Seckinger that morning over the Ferris fees that have been percolating for a while, and then number two is that pending hearing that very week in the boat case, which again, the purpose of that hearing is to, in a specific request for production and interrogatory, to identify all accounts. And again, once you do that, once those accounts are identified, just like Ms. Seckinger was able to do, just like law enforcement was able to do, the state grand jury was able to do. It doesn't take long to figure all that out and then lead to not only what's happened here, his disbarment, but also, I don't have to get into this specifically, but 99 counts for which he's facing a possible sentence of life without parole on that alone. And so that kind of consequence that's hanging out there is very much relevant and very timely to what was going on June the 7th in his life. The defense asked the question, can you think of any reason? And all of this going on in his life, which is a stellar series of events like nothing ever seen, is certainly relevant for the jury to consider when they consider a perfect storm that was arriving for this man on June the 7th.
Griffin, the witnesses that are here, Ms. Griswold, Chris Wilson, and Mr. Gunn, the confession of judgment and the disbarment, do you contest the matters which they are here to testify concerning?
It depends on how far they go with their testimony, but I'd certainly, that's predicate for Mr. Gunn to testify. They didn't have an account at Bank of America, and those checks were not deposited with us, and I didn't know anything about this. I mean, that we're acceptable to that, and just, without knowing the full scope of what they intend to offer, it's hard to say yes, but that's all. I mean, just like this witness, I mean, she has a lot of information that is that she learned through investigation. But if we had to try this case, 90% of it she couldn't testify to.
Your Honor, I point out that those witnesses that I mentioned, as well as every single one of those victims, all testified. There is transcripts on that, which the defense has had, which Your Honor has access to as well. So I don't know that necessarily it needs to all be repeated for Your Honor's determination now, because again, as he just said, those facts have been testified to. It's just a question of the parameters for this particular trial, which again, the state's intent is not to try 100 white-collar cases in the context of this murder case. It's only to explain to the jury enough of what was going on in an unfathomable set of events for a lawyer, what was going on in his life that were all coming to a head on June 7th. I think that's extremely relevant, and we plan to do so in a very expedited and focused fashion.
Your Honor, I would say for purposes of the trial, going forward with the jury, I mean, we're not stipulating to any facts.
Yes, sir. Well,
for purposes of hearing, I'm very candid with the court.
yes, sir. As far as the court's view of things and what the court needs to determine to be convinced that clear and convincing evidence exists, clear and convincing evidence is not proof beyond a reasonable doubt and all that. It says that degree of proof which will give me a firm belief as to the facts sought to be proven. And if those specific facts are not being contested, what the communications with Ms. Griswold that's in the record, with Chris Wilson, there may be, Attorney Wilson, may be some dispute, I don't know. Mr. Gunn, Forge is a well-known consulting firm, and the Bank of America account says Richard A. Murdaugh, sole proprietor, DBA Forge, confession of judgment, disbarment. I'm happy to sit and hear any and all of the testimony. One of the things that did occur in the Siegel case was the judge who got reversed didn't want to spend time listening and hearing all of the evidence because of the expediency of things. And the court says, although we sympathize with the court's concern about the length and complexity of the trial, we nevertheless conclude that the importance of the evidence, due to the importance of the evidence, it must be presented and the court must receive it. So I am happy to do that without needless presentation of evidence twice, more than once. And now, I understand the defense's position, and I'm not seeking any waiver on the question of whether or not this should be admitted or not admitted. I know you each have your arguments on regarding 404 issues, and haven't heard much argument on the race gestae issue, which is equally important, or perhaps more important. But if you are interested in contesting the nature of each one of these witnesses' testimony, if they're here and available, we can hear them. I mean, we can. You indicate that there are some other witnesses on other matters that can occupy the jury for a bit of time this afternoon?
Yes, sir. After our discussion this morning, we got some folks rolling, and after lunch hour, I think we can take us through the end of the day with witnesses that don't relate to this specific issue.
We can go in that direction and then resume with this with more witnesses later this afternoon, tomorrow morning, tomorrow afternoon. I just don't want the jury to sit and to be in an idle format. And to the extent that you all can be in agreement with a path forward, that's best. If you can't, then I make the call.
Your Honor, as I mentioned earlier, I strongly believe that based on what you've heard thus far, it doesn't meet the elements of 404B, and you don't need to get to whether it's been proven up by clear and convincing. I mean, if you rule against us on that, then we have to.
How about res gestae?
Well, the only thing that would come close to res gestae is tomato, right? And so the only thing that comes close to that is, the encounter on June the 7th by this witness up there about the Ferris matter. So one matter, it's the Chris Wilson co-counsel fee issue, and that was the only thing he was confronted about in the afternoon before the murders. And
the state has to prove the state of mind of the defendant, right, not solely what this witness knew at that moment in time, but what the defendant knew that was subject to exposure.
So, Your Honor, in the with regard to the res gestae issue, we had briefed State v. King 334 SC 504, and that is somewhat similar in that it involved thefts for someone stealing money, and there were remote thefts, and there was a theft the night before or close in time to the murders, and the claim was that the murders were done to get money from the victim, and that we had thefts earlier in the day or the day previous, and then a number of thefts months and years before.
Did the judge do the 403 analysis, 403, 404 analysis in King?
Well, the trial judge allowed it in. The Supreme Court, Justice Burnett in 1999, overturned Judge Hicks Harwell for admitting the evidence.
Without conducting a 404 analysis, 403 analysis?
Well, I mean, they have a footnote in there.
You have to do what we're doing now. Yes, sir. But in the case, they said while the remote thefts may have been
minimally relevant to show motive under law, the prejudicial effect of this evidence far outweighed the slight probative value. So the Supreme Court did a 403 analysis, and that's in footnote 5, Your Honor.
Anything else before we break? We'll resume at, what is this? We'll resume at 2 o'clock with, at 2:15 with witnesses, and we will resume with witnesses and the jury witnesses, and we'll resume with this in-camera hearing involving witnesses later. Yes, sir. So we'll be in recess at 2:15.
Lay down, be seated.
You may bring the jury. With the jury and then resume with in camera. And perhaps delay the jury coming for till later tomorrow morning.
The jury is present, sir.
All right, thank you and welcome back. You may call your next witness.
State calls Investigator Dylan Hightower.
Raise your right hand and left hand. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God?
I do.
Take a seat on the witness stand. State your name again for the record. Spell your last name.
My name is Dylan Hightower, Hightower.
Investigator Hightower, good afternoon.
Good afternoon, sir.
Where are you employed, sir?
I currently work for the 14th Circuit Solicitor's Office as an investigator. I also supervise the Criminal Intelligence Unit within our office.
All right, well, what is the 14th Circuit Solicitor's Office?
The District Attorney of the 14th Circuit, which is comprised of 5 counties, Allendale, Beaufort, Colleton, Hampton, and Jasper counties. Our office handles all general sessions-related criminal offenses in court.
All right. And specifically your role as an investigator, what are your duties at the 14th Circuit Solicitor's Office?
Yes, sir. My duties are to prepare cases for trial, locate and identify witnesses, interview witnesses, obtain any additional evidence that may be needed prior to trial. We also prepare witness testimony for all of our potential witnesses for all of our trials. I also, outside of preparing cases for trial, I assist with local, state, and federal law enforcement agencies with active and criminal investigations.
Okay. And can you just briefly describe your background in law enforcement that led to your employment at the 14th Circuit Solicitor's Office?
Yes, so in 2010, I graduated from the University of South Carolina in Columbia with a Bachelor of Arts degree in sociology. Soon thereafter, a criminal intelligence position became available within the 14th Circuit Solicitor's Office, to which I then applied and accepted. Initially, when I first was hired, I attended a 4-week on-the-job training at the South Carolina Law Enforcement Division in the Fusion Center for Criminal Intelligence Analysis School. Afterward, I attended the PennLink Call Analysis Training Center there in Columbia as well. In 2013, I became a Class 1 certified law enforcement officer. In 2014, I attended the ETS Fundamentals of Call Detail Record Analysis in Pinehurst, North Carolina. In 2015, I attended and became a Sistine SecureView cellular forensics operator to obtain the evidence from a specific device or telephone, cellular telephone. In 2016, if I may refer to my notes for
Yes.
timing. Later on in 2015, I attended a course, Gladiator Cellular Forensics course, where we learned about ESPA and GAR. ESPA stands for Enterprise Sensor Processing and Analytics. GAR stands for Gladiator Autonomous Receiver. Essentially, that class taught us to use specific devices and software to identify digital footprints of cellular towers within a specific area. In 2017, I attended a operator course for Black Bag Mobilize, which is a forensic tool to extract data off of a cellular telephone. In 2018, I attended the FBI CAS. CAS stands for Cellular Analysis Survey Team, on a class involving historical cell site analysis, which identifies tower activity, tower orientation, sector information of incoming and outgoing calls on a specific telephone number.
And Investigator Hightower, I'm going to stop you there. So as part of your job as investigator, 14th Circuit, your role is to help with cell records and cell tower information, correct?
Yes, sir, among other things.
And you've also had training on downloading and doing extracts from phones as well, correct?
I do, yes, sir.
Okay. All right. Is it unusual for you to respond to murder scenes in the 14th Circuit?
No, sir, not at all.
And you've personally met the defendant in this case, Mr. Alex Murdaugh, is that correct?
Yes, sir, I did.
All right. And does Mr. Alex Murdaugh, or at least at one point, have an association with the 14th Circuit Solicitor's Office?
Yes, sir, he did.
What was that association?
He was identified as a volunteer solicitor within our office.
All right. And when you say assistant solicitor, what does an assistant solicitor do?
They prosecute cases in General Sessions Court.
And you've, in your role, you've participated in a number of trials before, correct?
I have. I've been doing this for approximately coming up on 12 and a half years.
Okay. Have you had an opportunity to participate in any trials with the defendant, Richard or Alexander Murdaugh?
Yes, sir, there was one.
All right. And approximately when was that?
Probably 2015, 2016. It was a murder case out of Hampton County.
And what role did Mr. Alexander Murdaugh fill in that case?
He was essentially one of the prosecutors on the case. His father, Randolph Murdoch, was technically the lead on the case and who I spoke with and met with prior to my testimony in the trial.
Okay. All right. Let's move forward to June 8th of 2021. You recall that day, sir?
Yes, sir, I do.
And did you have an occasion to respond to 4147 Moselle Road here in Colleton County?
Yes, sir, I did.
All right. And briefly explain how you became involved and why you responded out there on that day.
So that morning, multiple phone calls were crossing through multiple employees throughout our office regarding the incident that occurred. We being myself, two other investigators, my solicitor and my deputy solicitor, traveled to Sled Low Country here in Walterboro and attended a briefing involving all the law enforcement agencies responsible for the investigation. During that briefing, we learned more about the particulars of what had occurred, and then afterward, we had all traveled together in multiple vehicles to 4147 Moselle Road.
Okay. So yourself and several other 14th Circuit investigators responded, correct?
Yes, sir. I drove with one other investigator riding with me. One additional investigator met us there. Captain Ryan Neal with the South Carolina Law Enforcement Division was in the vehicle with Solicitor Stone and Deputy Solicitor Thornton.
And now you just testified that it's not unusual for you yourself to respond to murder scenes, correct?
No, sir. And all of the murder cases that I've been involved with and any type of criminal proceeding, probably 95% of those scenes I've actually gone to.
Okay. And was it unusual for the solicitor to respond to a scene that quickly after an incident in your experience?
No, sir, not at all. Again, we, as a staff involved with the prosecution team, we had always traveled to a crime scene if we go to a courtroom.
All right. And just so it's clear, I don't know if you said it yet, but who is the solicitor of the 14th Circuit?
Solicitor is Duffy Stone.
And he'd be your direct boss, right?
I go through the Deputy Solicitor, Sean Thornton, but
He'd be the ultimate boss.
the ultimate boss is Solicitor Stone, yes, sir.
All right. And once you got to the scene, what did you do?
Once we arrived on scene, we met with Captain Ryan Neal, kind of all in a group. Captain Neal then walked around the scene and kind of noted different points of view, different pieces of the crime scene had already been relinquished at that point by the crime scene agents. There was no crime scene tape up. It was wide open. There are multiple members of the law firm there, other SLED agents as well. We had all kind of walked around the scene, around the barn, around the kennels, identified the points of interest of where each of the bodies were with Paul and Maggie, and then kind of circulated around the property and got a better visual of what all actually occurred.
Okay. And while you're there, did you bring any equipment with you to help aid in the investigation?
Yes, sir, I did.
What did you bring?
Our 14th Circuit Solicitor's Office drone.
Okay. I'm going to show you some pictures. Let's see, they are marked Exhibit 242, 241, 240, 239, 237. Get these papers apart. 238. Do you recognize those pictures, sir?
Yes, sir, I do.
All right. What are those pictures?
This is drone imagery of the scene right around the kennels and the general vicinity around the kennels.
And that was from a drone you operated?
Yes, sir, it is.
And about what time do you recall that you took those pictures and what day?
It was on June 8th of 2021 between 1:30 and 2:30 p.m.
Okay.
that afternoon.
Take those back from me. Look at them anymore. Exhibits 242, 241, 240, 237, 238, and 239.
They're admitted without objection.
I'll need the Elmo, please. Okay, can you see this picture on your screen, Investigator Hightower?
Yes, sir, I can.
All right, and what is this image of?
So this is closest kind of in the direction of the house, looking back towards the hangar area, as well as the dog kennels off to your right. My vehicle is right dead center in the picture, and then other SLED agents' vehicles were over on the left.
Okay. And I'm going to ask you to step down real quick to point out a couple things, if you don't mind. All right, and you might have to step over these boxes, but can you point out, from what you were told when you're on scene, approximately where Paul Murdaugh's body was found on that picture? However you need to.
Paul's body was right here near the dog kennels.
Okay, and where was Maggie's body?
She would have been right under this area over here, just on the corner around the edge.
And you testified by the time you got to the scene, the SLED crime scene, you cleared it, and it departed, correct?
Yes, sir.
And when you say, you can take a seat again. When you say that the crime scene had cleared, what does that mean to you?
It was no longer an active crime scene. Once the crime scene tape is removed, it's no longer active.
So other individuals could walk and view the crime scene at that point?
Yes, sir, that is correct.
All right, and that was Exhibit 240. And I'm going to show you Exhibit 241. And that's the same general area, a little bit closer on where Maggie and Paul's body were, correct?
Yes, sir, that is correct.
All right, and now I'm going to show 242. All right, and that's a little bit lower angle, looking at the same area where Maggie and Paul's body were, correct?
Yes, sir, that is correct.
Okay. All right. And I'm going to show you Exhibit 239. Okay. What is this? What is this angle? What is it looking at? And in fact, if you want to step down again and point to the jury, what? That glare is pretty bad. Yeah, that's better. Okay, so at the top of this picture, in kind of the center, what is that?
So this here is the residence of 4147 Moselle Road. That's the actual residence. This is the field between the residence and the kennels. Again, the kennels, the edge of the kennels is right there. You can see the top of the hangar there as well. So this is a direction looking directly over the hangar, pointing directly back towards the residence.
All right. And I'm going to ask you to sit down a second, but I want to call your attention to this line of trees right here. You see that, sir?
Yes, sir, I do.
All right. In this picture, you can take a seat. This picture was taken again when?
These were taken on the afternoon of June 8th, 2021.
And we see some pine trees kind of running diagonally between the kennels and the house, correct?
Yes, sir, you do.
And you were out there at the scene personally, correct?
I was.
And from the best of your recollection, can you remember the approximate height of most of these trees at that time?
I would approximate probably 6, 7, maybe 8 feet on certain ones, but you did get a clear channel, a clear view back towards the residence.
Okay. And you've been out there more recently, haven't you?
Yes, sir, I have.
And did you notice any differences with those trees, at least present day, compared to June of 2021?
Yes, sir. It's much more overgrown than what it looks like in that picture.
Have those trees grown higher?
Much higher, yes, sir.
All right. I'm going to show you, this is going to be Exhibit 238. And this is approximately the same angle, correct?
The same angle, just the drone shifted backwards a little bit so you could actually see the full hangar, the full kennels, as well as the residence.
All right. And finally, I'm going to show you Exhibit 237. All right. And what angle is this in relation to the others?
So the idea behind this was to identify both driveways accessing the residence as well as accessing the barn area. So this is further back, kind of closest to the field area, looking back towards the hangar, the dog kennels, and the 2 driveways that you could travel or arrive onto the property.
And this gives a good angle of those trees we were just discussing to show how closely they're spaced, correct?
Yes, sir, that is correct.
Okay. Let's step back a little bit chronologically, a little earlier in the day of June 8th, 2021 for you. While you're at the scene, did Maggie's cell phone come up in conversation?
Yes, sir, it did.
All right. Describe the context of that. How did it come up, and who was there when it came up?
It was during the general overview of the scene. We started asking questions about pieces of physical evidence that might have been identified. I learned at that time that Paul's phone was found on him, and Maggie's phone was not located anywhere near the scene during scene processing. So therefore, I explored other options to try and identify where her phone may be.
And you testified a while ago. You've got pretty extensive training and experience dealing with cell phones, correct?
Yes, sir. Every case, I would say 95% of all of our cases we put to a courtroom involve all forms of digital forensics, cell phone extractions, cell phone records, things of that nature. It's a part of our everyday life.
So with that background, when you learned Maggie's phone was missing, what did you have any ideas?
I did, yes, sir.
What idea did you have?
Knowing that they were the Murdochs were a close-knit family, I figured one of the family members might have had her direct location on Find My iPhone, knowing that they all utilized iPhones.
And did you communicate that idea to anybody?
Yes, sir, I did. I spoke with John Marvin Murdoch on scene.
All right. And what did he do in reaction to your suggestion?
He believed that one of the family members did have access to Maggie Murdoch's phone location via Find My iPhone. He left for a few minutes, short minutes, and came back to me with a cell phone believed to be Buster Murdoch's phone.
You're not 100% positive whose phone
Not
it was?
100% positive.
All right. And what did you do once this phone was handed to you by John Marvin?
I took possession of the phone, obviously looked at the virtual map, walked in the direction of where I believed it to be to see if it might be in the general vicinity of where we were around the dog kennels. As I walked probably 30, 40 yards, I realized I was much further away than I originally anticipated. So I then went back to my vehicle. I got in with John Marvin. I had possession of the phone the entire time. Two of our other investigators, Solicitor JoJo Woodward and Investigator Donnie Hutto, rode with me back towards the general area of where the device was showing.
Okay. And so you had this family phone the entire time, correct?
Yes, sir, I did.
And you were tracking to where Maggie's phone exactly was?
I was driving and looking down at the phone, making sure I was going in the proper direction.
Approximately how far did you drive?
About a half a mile from the entrance to the barns, the driveway to the barns.
I'm going to show you what's been marked as Exhibit 227. Do you recognize that?
Yes, sir, I do.
All right. And what is that?
That's an overview from Google Maps that shows both the residence as well as the general location of where I ultimately located Maggie Murdoch's phone along the edge of Moselle Road.
And you prepared that to
I
show
did.
the location?
Yes, sir.
All right. And state moves 227 into evidence. Okay. Can you see that on your screen, Investigator Hightower?
Yes, sir, I can.
All right. We're going to ask you to step down one more time. All right. On this overview, can you point out where the residence is for 4147 Moselle?
The residence is here. You can see the driveway here as well. And then the kennels are up here.
Okay. And there's a marker on there, correct, that says general location of phone?
Yes, sir, that'd be right here.
All right. And that's where you found Maggie Murdaugh's phone, correct?
Yeah, so I was walking, when I was trying to get a better idea of where the phone actually was, I was walking up and down the driveway here to the kennels, obviously looking down at the phone, trying to identify the general location. Once I started to realize the phone was much further away, that's when I jumped into my vehicle. I turned and went southeast of the residence area. Once I got to this specific area where the field kind of opened up, I started getting closer and closer to the blue dot that you would see on Find My iPhone. Once I got closer and closer, we all got out on foot and walked the property to identify where that phone was.
Okay. And you can take a seat. And I'm going to hand you Exhibit 236, 235, 234, 233, 232, 231, 230, 229, and 228. Do you recognize any of those?
Yes, sir, I do.
All right, and what are those?
These are photographs that I took of Maggie Murdaugh's phone as it was laying in the brushed area or leaved area closer to Moselle Road, about 15, 20 feet away from Moselle Road.
And did you ever personally pick up Maggie's phone?
I never touched the phone. Once I identified the location of where the phone was, I contacted Captain Ryan Neal with South Carolina Law Enforcement Division. He sent a team with Special Agent Katie McAllister and Special Agent Jeff Croft to take possession of the device.
So when you took these pictures, Maggie's phone had not been touched, correct?
It has not been touched. No, sir.
All right. At this time, the state's going to move exhibits 236, 235, 233, 231, 228, 227, 230, 232, and 234 into evidence.
There's no objection.
They're admitted without objection.
Okay, I'm going to show you first Exhibit 230. All right, and in the center of this, I see two orange flags. Do you see those?
Yes, sir, I do.
What are those orange flags?
So once I located the device, I found some standard landscape flags laying around. I then obtained those, walked over towards where the phone actually was, put one towards the phone and one kind of where you could see from the roadway as the SLED agents were responding to collect it.
Okay, so where was Maggie's phone in relation to these two orange flags again?
So it'd be the furthest one away. This is just a point of view from the street looking back towards where the phone was.
Okay. And we see, looks like pavement in the foreground. Is that correct?
Yes, sir. That is Moselle Road.
And so that represents the edge of the road, correct?
That is correct, yes, sir.
And just so it's clear, is this the north side of the road or south side of the road?
This would be,
Well, let's go back to the map. Let's go back to Exhibit 227. So this represent north-south is up and down on this map you prepared?
yes, sir, it does.
Okay, all right. So was the phone found on the right side of Moselle Road on this picture or the left side?
It would be on the right side
Okay.
from this angle.
Okay, I'm going to show you Exhibit 234. And do you recognize what's in that picture?
Yes, sir, I do.
All right. And right in the center of that picture, what is that?
That is the Apple iPhone that actually had a camouflage case with an orange tint to it, and there was standing water on top of the screen.
Okay. And I see a little black area if you look up and left of the phone in the center of the picture there. Do you know what that was, or was that anything significant?
I don't believe it was anything significant. From what I recall, it might have been a bottle or something of that nature.
Okay. I'm going to show now Exhibit 231. Okay. And I believe in the center of this picture, towards the bottom, what is that?
That is the cell phone identified as Maggie Murdoch's phone.
And we see an orange flag just a little bit in front of it. Is that correct?
Yes, sir, that is correct.
Okay. And is that the orange flag you placed?
It is.
All right. And then in the distance, I see a line, a white line. It doesn't show very clear on the Elmo. But what is that? And I can bring the picture to you if you need.
Well, I could explain what this picture is of looking back towards, because based off the glare, I can't even see the roadway.
Right. I'll show you. Okay. What? On this this far line here, What is that?
This back here?
In front of that?
Okay,
That
this
white.
is 40, this is Moselle Road
Okay.
here. This is just on the opposite side of the cell phone, looking back towards the field area, the trees for line of reference to identify where it was actually located.
Okay. All right, and can you approximate the distance from the road that you found this phone?
I did not step it off or measure it, but I would say between 15 and 20 feet.
Okay. Okay. I'm gonna show you exhibit. Excuse me. All right. We are looking at exhibit 228. All right. Describe what's in this picture, please.
That is just a more close-up picture of the Apple iPhone recovered from the leaves.
And do I see something on the screen of that phone?
Yes, sir. It's standing water, believed to be from the moisture from the night before.
And that screen, is that facing up or facing down?
The screen is facing up.
All right, I'll show you exhibit 235. All right. And what's in this picture?
It's just the opposite angle on the other side of the phone, more of a close-up of the iPhone.
And you can see those water droplets on the phone.
Yes, sir.
All right. And I see some sort of line on top of the phone. Can you tell what that is?
Appears to be some sort of plant or
Okay. And finally, 236. What is in this picture?
again, more of a close-up from the top of the phone looking down.
Okay. All right, and this is Exhibit 233. All right, what is in it? Describe this picture.
So the reason behind this is to obviously identify the location of where the device was. I had walked out to Moselle Road, gotten to the center of the roadway, and taken a picture of the trees in the field directly on the opposite side of the road of where the phone was found.
Okay. All right, and this is Exhibit 232. Describe this picture, please.
This is me standing in the same location as the previous picture. This is me just turning right towards the residence to show the pitch in the road as well as the start or the break of the field off to the left.
So you're standing basically across the road from where Maggie's phone was found, correct?
That is correct. It would be directly to my right in this picture.
And facing down that road, what's that way?
That's back towards the residence and the kennels.
And whose vehicle? Do you recall whose vehicle is in that picture?
That was Captain Ryan Niels.
Okay. Finally, Exhibit 229. All right, and what's this picture?
That is a close-up of the back of the picture, or back of the iPhone. That's Special Agent Katie McAllister that has possession of it. At that point in time, we had put it in airplane mode and sealed it into an evidence bag.
All right. Now, you did not physically pick the phone up, correct?
I never once touched the phone, no, sir.
You observed it being picked up, correct?
I did, yes, sir.
And, all right, and did you have any further to do with Maggie's phone after it was collected?
I was provided the extraction once that was completed.
Okay.
But yes, nothing further with the actual device.
Okay. And that was from Lieutenant Dove?
That is correct, yes, sir.
Okay. Let's go forward to the day of June 10th, which was 2 days after you found Maggie's phone. Is that correct?
Yes, sir, that is correct.
All right. And did you have reason to respond back out to Moselle on that day?
It was not Moselle, but I believe it was John Marvin's hunting property.
Okay. All right. You responded to John Marvin's hunting property. And why did you go there on that day, June 10th?
I was requested to extract cellular phones from Alex Murdaugh, Randy Murdoch, John Marvin Murdoch, and Buster Murdoch, while they're all being questioned by SLED agents.
All right. To your knowledge, did all those individuals provide consent for that
Yes, sir,
search?
they did, as well as their passcodes.
Okay. All right. So how many phones did you download again? I'm sorry.
During that time frame, I had extracted 3 total phones. There towards the end, once the interviews were being concluded, a phone call was made to multiple family members explaining Randolph's condition, and they all had to leave and go back into Alameda.
Okay.
I was only able to extract 3 phones at that time.
And whose phones were that?
That would have
was
been
3?
Alex, Randy's, and Buster Murdoch's phone.
All right. And just generally speaking, why did you download? Why were you needed to download his phones on that day? What was the purpose?
I was tasked by multiple SLED agents to assist them while they were conducting all their interviews to extract the contents of their phone to see if there might be any evidence of the murders in any of their phones.
And was it unusual for SLED in this area to request your assistance with some cell phone evidence?
No, sir, not at all.
Okay. All right. So you downloaded those 3 phones. This jury has heard testimony about different types of extractions. What type of extraction did you do on June 10th with, let's focus on Alex's phone. What type of extraction did you do?
The initial extraction was an advanced logical that I had done there on scene at the hunting property.
How long do you recall approximately that logical extraction took?
Advanced logical was basically just a surface area of the phone, identifying the call logs, incoming and outgoing phone calls, text messages, any emails, general location information. You won't always get a whole lot of location information, but ideally to get a pretty good idea as to what's happening on that phone during that time frame.
And just time-wise, I know every phone's different, but do you recall approximately how long it took to download Alex's phone?
I would say between 30 minutes and an hour. None of the phones took any longer than an hour to conduct an advanced logical. Full file system takes much longer.
So between the 3 phones you successfully downloaded today, it took you between, in total, an hour and a half to 3 hours approximately, you would say?
Yes, sir.
Okay. This jury's heard about full file system and physical extractions before. You have that capability, correct?
Yes, sir, I do.
All right. But you did not perform that on those 3 phones on June 10th, correct?
That is correct.
And just, again, generally speaking, knowing every phone's different, how much longer does a physical extraction take than a logical extraction?
It depends on the size of the phone. Obviously, phones these days are getting much larger. Depending on the size of those phones, depending on how long a full file system extraction would actually take. It could be hours, it could be days. It just kind of depends.
Okay. And did you feel like you had hours and hours and days to download those phones?
No, sir, I did not.
Because what did you do after you were done extracting them?
I supplied each of their phones back to them, obviously because of the issues dealing with Mr. Randolph at that time.
And you felt some pressure because of the health issues of Mr. Randolph to return their phones to him so they could take care of family business?
Yes, sir, that is correct.
Okay. All right. And so you said a minute ago, so all you removed from these phones was that surface layer of information, correct? Is that what you?
Yes, sir.
All right. And that surface information includes text and call logs, pictures and videos and that sort of thing, correct?
Yes, sir, it does.
And you said sometimes you get some location data, but not always, correct?
That is correct, yes, sir.
All right. Now, in relation to Alex's phone, was there a concern about his status as an attorney on that?
Yes, sir, there was.
All right. And that phone could potentially contain privileged information, correct?
Yes, sir, that is correct.
All right. So you did the raw download, logical download, and did you initially look at anything on Alex's phone on June 10th?
I did not. I was once the extraction was completed, I obtained the UFDX file, which is the raw file for a Celebrite file. I then transferred that electronically over to Sergeant Paul McManigal with the Charleston County Sheriff's Office, who also serves in the United States Secret Service Task Force, the Cyber Crime Task Force. I also did that with Randy Murdoch's phone as well. So I sent him 2 of the UFDX raw files from Celebrite for him to dump into what's called physical analyzer to extract the data. At that time, a Tain attorney was assigned from the Ninth Circuit Solicitor's Office. She had met with Sergeant McManigal and gone over all of the attorney-client privilege information, and I was provided a working copy of Alex Murdaugh's phone from Paul McManigal a few days after that.
Okay. But just so it's clear, you said she was from the Ninth Circuit?
That is correct, yes, sir.
And that's a totally separate office from your circuit, correct?
Yes, sir, it is.
Once you received this redacted logical phone extraction from Sergeant McManigal, what did you do next?
I opened it in what's called Celebrate Reader, which is an executable file that allows you to go in and view the contents of the phone. It's essentially a dashboard that allows you to maneuver around the device itself in a more readable format and identify incoming, outgoing calls, read text messages, any type of emails, photographs, videos, or anything that might be in that person's camera roll.
And in the course of your assistance to this investigation, did you acquire any other records to assist you in looking through these phones?
Yes, sir, I did.
What did you acquire?
I was supplied with all of the call detail records from Verizon for all of the parties that we had obtained information on or obtained a search warrant on to identify ideally location information. What I like to do in my cases, if we have a phone extraction as well as phone records, I like to compare the two and identify any discrepancies or any issues that might occur. But the call detail records allow you to obtain location information if you don't get it from the Celebrite extraction.
Okay. And so you obtained via search warrant or assisted obtaining via search warrant cell records for Mr. Alex Murdaugh and some other individuals, correct?
Yes, sir, I did.
And those records have been entered into evidence as 268, correct?
I believe so, yes, sir.
All right. And you said, you just testified that you took those cell phone records, which, to remind a jury, that's information that's stored by who?
By Verizon, in this case Verizon, but
Yes. By the cell company, correct?
yes, sir.
All right. And you compared it to the information you found on these phones, correct?
I did, yes, sir.
And specifically, with Alex's phone, what did you discover when you're comparing these phone records to the phone itself, the call log?
Once I started, I essentially built a digital timeline of all forms of digital evidence that we had during that time frame, and it was kind of a working copy. During that time frame, I compared the call logs from the extraction or from the actual device to the phone logs that I saw in the call detail records provided from Verizon. On the date in question, on June 7th, I only saw 2 FaceTime calls on the phone extraction, and I saw a series of around 73 phone calls on the Verizon call detail record.
Good. And what did that tell you when you saw that missing information?
It could be a multitude of things. They were either removed by the user or the one responsible for using the device. It could have overlapped from the call log history. It could have been a series of things, but I just wanted to make sure that I identified the phone numbers that were in communication during that time frame and the lack of that information on the actual phone.
And you just said it could have overlapped in that. What does that mean?
Over time, your call log obviously gets historically just kind of removes itself from the call log history on your actual device. It's nearly impossible, or actually I know of no way to delete any phone calls that you might have made that had processed through the network, or in this case, Verizon.
So there's no way for a user to delete records from Verizon, correct?
That is correct, yes, sir.
But you know, in your investigation of his phone, of Alex's phone, I mean, is that what happened? Did his call log just simply overlap? Were you able to determine that?
I was not able to determine it because it was an advanced logical, so I wasn't able to recover any deleted items during that time frame.
So you didn't recover any deleted artifacts of the phone call?
That is correct. No, sir, I did
When I
not.
say deleted artifacts, what does that mean?
Anything that was manually deleted from the device itself.
All right. And there's sometimes a trace left in memory when something is deleted, correct?
Yes, sir, that is
But a
correct.
logical extraction is not going to find that, correct?
No, sir.
Okay. All right. But did you, in your review of the call logs, did you discover whether sometime prior to the June 7th, that there were still calls in those logs?
Yes, sir, there was.
All right. And so is this a case where simply the calls just simply overlapped and the oldest went out as the new calls were made?
It's possible.
Well, if there's a gap, you just testified there were phone calls.
Yes, Your Honor, we.
Did you just testify that there were phone calls from prior to June 7th still remaining on that phone?
FaceTime calls, yes, sir.
Okay.
On the call log on the phone extraction. The report that I was provided, because it was a working copy, was from June 1st to June 10th.
Okay. All right. But there were FaceTime calls prior to that, correct?
Yes, sir, that is correct.
And when a user accesses just the phone itself, and they look at a call log, will that display both calls made over Verizon? It will display calls made over the Verizon network, the call log?
Yes, sir.
It will-
Anything that connected to the network.
All right, and will it display FaceTime calls as well?
It would, yes, sir.
All right. And you found FaceTime calls from prior to June 7th, correct?
Yes, sir, I did.
All right, and, but as far as you could tell, as far as calls themselves, when did you start seeing call records start?
Right around the morning, late morning, early afternoon of June 8th, 2021.
Okay. All right. And is there, other than this overlapping situation, is there any other way that you're aware of that could have removed that gap in phone call logs?
If the user went in and manually removed it
Okay.
themselves.
But there's no other automatic process other than what we've already discussed?
No, sir.
And did you discuss with Sergeant McManigal whether his process in redacting certain things, did that process remove any call logs from that download?
Yes, sir, I did review with Sergeant McManigal, and obviously we had discussed the results that were provided to me, and we both agreed on the same opinion.
All right. And that Sergeant McManigal did not remove those records, correct?
That is correct.
For this witness.
Yes, sir.
Understand you, and it's sort of an alien concept to me, Swister's office going to murder scenes. You go to a bunch of murder scenes?
Yes, sir. Among my other duties, I am involved with the ATF. I'm a task force officer with the ATF, the Bureau of Alcohol, Tobacco, and Firearms out of Charleston. So I do some proactive roles there, as well as reactive roles in investigating crimes that will ultimately be my case anyways and come into a courtroom.
If they arrest somebody.
If they arrest somebody, in some cases when no arrests are made, yes, sir.
When they're what?
In some cases when no arrests are made, I would still arrive or respond to the crime scene.
And you took Solicitor Duffy Stone with you, the chief prosecutor for the circuit, right?
We rode in separate vehicles, but yes, he was along with me, yes.
And I think I saw somewhere in evidence he actually took photographs that morning, did he not?
Yes, sir, he did.
Is that usual? That the solicitor go around doing evidentiary photos?
Not at all. With the way his mind works, he goes in and he thinks of every idea possible of what could possibly be an issue later on down the road if he prosecutes a case, and he wants to make sure that's all documented in his own phone.
And so if he takes a picture and wants to use it in the prosecution, does he introduce it, authenticate it, and take the stand, authenticate it, and then come back down? Or he ask himself questions? How does
No,
that
sir,
work?
he does not.
Okay. Let me move on to something a little more productive. You went to a briefing that morning, you said, when you got there.
Yes, sir, I did. It's
And
Sluglow Country.
who was the briefing by?
There were probably 30, 40 plus investigators, officers, but multiple, essentially SLED, Colleton County Sheriff's Office, a few Walterboro Police Department, I believe, and a few from my office.
I guess when I think of a briefing, I think of someone standing in front of the room and saying, here's what we got. Was there one person speaking?
There were multiple people speaking, but that was the whole idea, was to get a better grasp as to what had occurred the night before.
But I guess, so who spoke?
Multiple agents, multiple responding officers from the sheriff's office. I don't recall exactly who spoke.
How long did the briefing take?
Approximately 45 minutes, if I had to guess.
And you have no specific memory of any specific person saying any specific thing?
There were multiple people speaking, going over the.
So the answer is no.
I do not recall exact people's names and exactly what they said. No, sir.
Do you recall any one person that spoke?
I know Captain Ryan Neal spoke. Special Agent David Owen spoke. I believe Captain Jason Chapman with the Colleton County Sheriff's Office spoke. There was a multitude of people talking about different things that they had seen the night before or the morning of.
Had they indicated to you, any one of those people, that they had a suspect, that they were focused on any particular person?
No, sir.
Did they have an explanation for anything? I mean, at that point, was there some theory about what happened?
At that point in time, we were trying to identify all the physical pieces of evidence as well as obtain and preserve all digital pieces of evidence to make sure we had a strong enough case moving forward.
Were you aware that the Colleton County Sheriff's Department had issued a statement to the public saying there's nothing to be afraid of? People, this is not something that you should view as a threat.
No, sir, I'm not aware of that media release.
You did not hear anything like that morning. Well, let me ask you this. If you had an active shooter at large, would police take any proactive steps? Would they put up roadblocks, or would they put out a statement, look, we've got 2 people brutally murdered, and we don't know who did it, so keep your doors locked. Be careful about if you see somebody in the woods or walking along the road. I mean, you see these, unfortunately, much too often these days, but did you?
Your Honor, object. Ms. Harpilly seems to be testifying. Are we getting to a question?
Yeah, the question is, did y'all do any? Did you see any, not you, did you see any evidence of that or hear any evidence of that morning?
Not that I recall, no, sir.
Okay. Not that I recall means?
I don't remember. I wasn't focused on what was on the media.
Okay. But did you see any roadblocks?
No, sir, I did not.
Did you see anybody searching fields or the woods around the place?
There were multiple tasks that were provided to each investigator during the briefing, and multiple people went out and did their own thing of whatever they were tasked with.
Do you remember what those tasks were?
Following up with potential witnesses.
Right, but I'm talking about, did you see anybody going through the woods armed looking for a person or persons?
No, sir, I did not.
Okay. You didn't see any roadblocks, you didn't see any active search for a suspect in the sense of somebody was armed, well, they knew at that point there were spent shotgun shells and spent blackout casings, right? You've heard that?
Yes, sir.
So somebody, either 2 people or 1 person with 2 guns, was at large at that point as far as y'all were concerned.
Yes, sir. I mean, ideally.
Okay. Did any of those agents indicate during your briefing that they felt that there was somebody at large that posed a danger to the community? Did you hear any of that?
I don't believe so.
Okay. So, let me find the critical element here. So, when you got there the next morning, there were no bodies, there was no physical evidence there. It was after all that had been removed.
All the bodies have been removed. All of the trash from the crime scene agents were stacked up. You could see some blood stains in the ground, and as well as some body matter over towards the dog kennels.
And I'm not going to belabor this and put these pictures up, but you had a drone up, right?
Yes, sir, I did.
And did you ever go up to the residence?
I did not go all the way to the residence. No, sir.
Okay. And I don't see any pictures taken from the kennels that you took or under your direction up towards the residence. Are there any?
From the kennels looking back towards the residence?
I mean, but looking from the murder scene back up towards the residence.
Yes, sir, I did take those photographs.
That was during the day, not the night, correct?
Yes, sir, that is correct.
Okay, so you don't know what somebody from the house could see at night looking down towards the kennel?
No, sir.
Okay, I just want to make sure it was clear that you weren't testifying somebody up at the house at night would have an unobstructed view of where the bodies were found or the front of the kennels. You're not testifying to that, are you?
No, sir, I'm not.
Okay. So let's talk a little bit about the phone. I thought I had the exhibit number of the phone down. You don't know it off the top of your head, do you? Anybody? What? Oh, up there. Okay. It's I think it's 204, which I would find in that box. While he's looking for that, if you continue to look for that, I'd appreciate it. Let me ask you some questions. You indicated the distance from the shoulder of the road to the phone was about 15 to 20 feet?
Yes, sir.
Okay. And you took a number. Did you take those pictures of the phone?
Yes, sir, I did.
Was there any other person there taking pictures other than you?
I was the only one with a camera, so I took the photographs.
Okay. And Were you there the entire time until the phone was removed?
Yes, sir, I was. I stayed right next to the phone until Special Agent Jeff Croft and Special Agent Katie McAllister arrived on scene. They took possession of the cellular phone and placed it into an evidence bag.
Okay, and during that period of time, did any sort of forensic team come up and measure how far the phone was from the shoulder of the road?
No, sir, they did not.
Did anyone attempt to come up with a specific location for that phone in terms of measurements, a forensic assessment of where that phone was?
No, sir.
And what are those exhibits that were just introduced? So, for the record, the state's exhibit number 204. That looks like the case and the phone are separated. So this is the actual phone, is that correct?
Based off of this case, I remember seeing a camo and an orange labeled case.
If somebody's written on this, that's not you.
No, sir, it's
Because
not.
you never touched the phone.
I did not, no, sir.
All right. And this is a SIM card. What is a SIM card?
It's stored within the device. It's a secondary form of storage for a cellular device.
And so if you, anything you do on the device is stored on the SIM code?
Not necessarily, no, sir.
What's stored on here?
It depends on the network, depending on the provider that you utilize. Different providers offer different resources through your SIM card. But
Did you ever examine the SIM card?
I never examined anything on that phone, no, sir.
You did a download, but you didn't examine.
Not on Maggie's.
Oh, you didn't do Maggie's phone.
That's
stand
correct, yes,
corrected. Okay, but somebody could look at the SIM card and get perhaps information that's not on the phone?
Yeah, in some scenarios, yes, sir.
Okay. Now, what I'm going to try to figure out by looking at these pictures while I'll bring this phone back in just a minute, is I want to. Is this still on? Okay, how about get that so we can see it? I have it also on. Well, let me get just easier for me to put this down. So that is exhibit number, sorry. 228. How about push that again? And that's what you saw when you came upon the phone, correct?
Yes, sir, that is.
And I think we see, and I think he pointed it out a little while ago, there's pieces of straw and other things around it, right?
Yes, sir.
So you would agree with me if someone had carefully walked over and placed this phone, there wouldn't be anything above it because everything that straw would be under it, correct?
It's possible, yes, sir.
Okay. And in addition to that, did anybody forensically check the area around it to see if there were footprints?
No, sir. I mean, it was heavily treed, heavily wooded, a lot of leaves there. You could not see any foot impressions around that phone.
Okay. A lot of leaves.
Yes, sir.
And so is this sitting, I mean, when it's sitting there with the straw over it, is it sitting flat on the ground? Is it tilted? Is it, what do you remember? Or if you don't?
There was a slight tilt, probably centimeters, nothing major. Nothing out of the ordinary around the phone, no holes, no pushed up leaves or anything like that.
So you couldn't, I mean, strike that. Okay, let's look at, let me make sure I get the right one. Let's put this this one on there. Okay, so again, that's another picture taken by you of the same phone in the same location, correct?
Yes, sir, it
And
is.
it's heavily wooded in that area, correct?
Right on the edge, yes, sir.
And it's almost a thicket where you found this, right? There are bushes around it,
No bushes. There were a lot of trees
a lot of trees, and underbrush.
and underbrush, yes, sir.
Okay. So nobody actually took measurements of where this was found. No one actually measured from the road, nor did they measure. I mean, there's no way to figure out exactly. If you had to go back today and find the spot, could you find it? The exact spot?
Within a couple of feet, yes, sir, I probably could, based off the angles of photographs that were originally taken.
Okay. But you couldn't give us the exact spot, right?
I couldn't give you an exact step from the actual device to where Moselle Road was.
Okay, this is exhibit number 232. And that's a vehicle on the same side of the road as where the phone was found. Is that correct?
Yes, sir, that is correct.
And so that car window that we see in this photo, the driver's side, the driver's side window would be 15 to 20 feet from where that phone was, correct?
I would add a few more feet just because of the roadway. Yes, sir.
Okay, you add, so 28 to 30, 25 to 30 feet? Fair?
That would be fair, yes, sir.
But nobody measured it, so we don't.
No one measured it, no, sir.
Okay. And so if that car was going towards Alameda, you know where I'm talking about?
Yes, sir, I do.
It would be on the other side of the road, right?
On the right lane of the road, yes.
I mean, it'd be on the right, but here it's improperly parked, correct?
Sure.
I mean, the driver's window is, I mean, if there's a car coming the other way, they'd head on, would they not?
That is, yes.
Okay, that's the point.
You
I'm
would be
making.
operating the vehicle on the right side of the road, or left in that image.
Okay, so if someone were driving towards Alameda on this road, and they wanted to get rid of that phone, they would either have to throw it 40 feet out the driver's side window, or pull over as this car has and throw it out, correct?
It's a series of things that could have happened, the reasons why that phone got there, but it's possible.
Well, it's just assume with me for a second that they want to get rid of that phone by throwing it out the window. They could either throw it from their lane of traffic if they're going towards Alameda, or they can pull over like that and throw it out. It'd be easier, when I say easier, it'd be a much tougher toss that far in from if they never left their lane of traffic, correct?
Guess it depends on who's throwing it. There's a multitude of things.
Me. It'd be me, and I don't throw very well.
No. Well, I do, so I could 100% make that throw.
You could throw it from, okay, so you wouldn't even have to change lanes. You just throw it out the window.
Yes, sir, 100%.
And you would throw it overhanded or underhanded?
I'd throw it sideways, flick it.
Sideways, okay. Okay. So there's no way to tell, we don't know, if somebody threw it out. Out of the driver's side window. Are you throwing it with your left hand or right hand out the driver's side window? I mean, you said you could toss it pretty far.
I would throw it with my left hand from the driver's side and could easily land it to where it actually was found and located in the woods.
But you right-handed or left-handed?
I'm right-handed, yes, sir.
But you could still throw it with your left hand with that much power?
Yes, sir, 100%.
Okay. Now, let me ask you this. When you found it, you wanted to put it in, or somebody with you wanted to put it in airplane mode, right?
Yes, sir, I wanted it to be placed in airplane mode to preserve its contents.
Because in airplane mode, less chance of any data being overridden, right?
That is correct, yes, sir.
Now, that doesn't prevent all data from being overridden, but most data, correct?
A lot, 99%, I would say, to prevent any issue with the phone.
Does it prevent GPS data from being overridden?
From another device,
No. I mean, just
internally, just
yes.
automatically deleting
Internally?
itself?
Yes.
I've never seen that happen.
Okay. But you don't know whether it's going to happen or not.
Presumably, no.
So you needed to put it in airplane mode to prevent anything from being overwritten, right?
Any outside tampering from another device that had access to its iCloud
And
information?
you told the agents with you, I want to put it in airplane mode, right?
Yes, sir, I did.
And to do that, you have to be able to open it. You need the passcode.
No, sir, you do not.
Don't?
Not on an iPhone, no, sir.
You can put it on airplane mode without
Yes, sir.
opening it.
You
Well,
just-
but what did you need the passcode for? Because somebody called and got the passcode.
We did not get the passcode at that point in time. No one knew we had located the phone, so there's no reason to ask for a passcode if we didn't have it.
Thank the court's indulgence for a moment.
Later on, we received the passcode, but not at that point. I was not present. I did not analyze the device, so
Was it at the scene or was it somewhere else?
I do not recall. I was not there.
So no one told you that Alex Murdaugh provided Maggie's?
No, sir. No one told me that.
Now, if someone had the passcode, they could go in that phone and eliminate, delete text messages, phone calls, just about any piece of data that's captured there, correct? Even apps, you can delete those, correct?
They could have, but once the full file system extraction was done by Lieutenant Britt Dove,
No, you misunderstand my question, I'm sorry. If you had that phone, and obviously Maggie Murdaugh had been murdered, somebody threw it on the side of the road, and during that period of time after her murder, before it was thrown on the side of the road, if you had the passcode, right?
Yes,
Open
sir.
it. Without the passcode, typically you can't open it, correct?
No, sir.
You agree with me?
I did, yes, sir.
Okay, I'm sorry. So if you had that passcode, you could open it, delete photos, delete phone messages, delete text, delete whatever you want, correct?
Yes, sir.
Okay. And when you found that phone, it was locked?
Yes, sir, it was.
Okay. And was there any evidence that you saw that anything had been deleted from that phone in any of your, after your download, extraction?
Again, I did not download or extract the contents of the device. The only thing that I saw was the home screen and made sure that the airplane mode was applied at that point, and then it was placed into an evidence bag. We never got past that lock screen or home screen that allows us to turn on airplane mode. Obviously, the device was on because we were able to locate it from my iPhone, and the battery level was significantly low.
Was significantly low.
Yes, sir, it was.
Okay. Beg the court's indulgence.
Anything further?
We talked about the call logs, and so you downloaded Alex's phone on June 10th, correct?
Yes, sir, that is correct.
3 days after the murder, correct?
Yes, sir.
And
Not responsive to my cross-examination. I never mentioned Alex's phone, not once.
Response?
I'll proceed, Your Honor. At some point, after you were involved in this investigation, you were informed by Solicitor Stone. You were informed by the Solicitor Stone to stop, correct?
Yes, sir, I was.
And you recall approximately when Solicitor Stone.
Objection, Your Honor. Again, not not in response to a matter raised by me on cross.
Sustain the objection.
And Mr. Harpootlian asked about the crime scene and its state when you got out there, correct?
Yes, sir, he did.
All right. Did you notice any vandalism?
No, sir, not at all.
Did you notice, were you informed or did you notice anything missing?
Objection, Your Honor. How do you know it was missing?
Maybe the witness knows. Overruled.
I knew Maggie's phone was missing, and that's it.
Okay. But you noticed any vandalism or anything?
No, sir, not at all.
Okay. All right. And when it comes to Maggie's phone, return model, are you aware whether that can be placed in airplane mode without the unlock code being entered while the phone is locked?
You can place that phone in airplane mode while it's locked, yes.
Okay. So you don't need a code to just simply put it in airplane mode, correct?
No, sir.
All right. And did anybody manipulate any data on that phone in your presence?
No, sir, not at all.
Okay. Not further from the state.
You may step down. We'll take a 10-minute break, ladies and gentlemen. Please do not discuss the case. they're all rise.
You may now be seated.
You may bring the jury. Thank you. You may call your next witness.
The state calls Katie McAllister.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about the judge of court in this trial shall be the truth? So help you God.
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Katie McAllister, McCallister.
Good afternoon, Agent McAllister.
Hello.
Could you please tell the jury where you work?
I work for the South Carolina Law Enforcement Division, more commonly known as SLED.
And how long have you worked for SLED?
10 years.
And what is your position there?
I'm a senior special agent in the Low Country Region Investigative Services.
And were you a senior special agent back on June 7th of 2021?
I was just a regular special agent then.
Did you have a chance to respond to Moselle Road in that capacity as a SLED agent?
I did.
Can you tell us when you responded out there?
I was told late on the night of June 7th to be at the office on June 8th. I was given some assignments, and then I responded to the actual property around lunchtime on June the 8th, 2021.
So June the 8th, the day after the murders took place.
Yes.
And what did you do when you got out there?
Myself and Special Agent Croft were almost to the house. There were several people in the roadway. It appeared to be blocked, so we stopped and got out.
Did you, what were those people up to?
There had been a phone located on the side of the road.
Okay. And whose phone was that?
It was Maggie Murdoch's cell phone.
And can you tell us about your involvement in the collection of Maggie Murdaugh's cell phone?
Yes, so once we got out of the car, I had gloves. Captain Neal retrieved the phone from where it was laying. I was standing right beside him when he got a phone call. He handed me the phone with my gloved hands. I held the phone for Investigator Hightower to take a picture of it. The phone call was Captain Neal receiving the passcode. He asked me to confirm it. I typed it in. We confirmed that it was the right passcode. I locked the phone. At that point, Investigator Hightower asked me to put it in airplane mode, which I did.
And so what was the point of you putting the passcode into that phone?
To confirm that the passcode we were given matched the actual phone that we had.
To confirm that was Maggie Murdaugh's phone?
Yes.
Okay. And when you unlocked that phone, did you delete any calls?
I did not.
Did you delete any text messages?
I did not.
Did you alter any data in that phone?
I did not.
You locked that phone back immediately?
Yeah, as soon as it opened, the screen clears to show that that is the right passcode, I immediately locked it back.
And then what happened to the phone as far as you know?
Captain Neal, who was standing right beside me, took the phone back.
All right, let's move on. What else did you do?
So once I arrived on scene, myself along with Special Agent Croft were asked to go up to the main house to do a search of the property, or of the home.
Did you have a search warrant?
There was a search warrant, yes.
Was that search warrant executed?
It was not.
Why not?
At the time of my arrival, multiple family, close friends were at the house. Rather than executing the search warrant and displacing all of those people, we asked for consent and we were given it.
And were a lot of people at that residence at the time?
There were.
You could give us kind of a rough estimate of the amount of people that were there.
I would say maybe 20 or 25 people were in the home.
And you didn't want to have to ask all those people to leave?
Some of them were very upset, and we thought it was better to simply ask for consent.
Tell us what you found in the search of the house.
So upon consent, I walked through the residence. I was looking for weapons and ammunition and observant to anything else that may have been of value. I found nothing, and once I came back downstairs to the gun room, Agent Croft had located several items of interest, some weapons and some ammunition. He and I collected those. I completed a property receipt.
Let's go back to your search a little bit. When you walked through the house, were you alone?
I was not.
Who was with you?
I believe it was John Marvin Murdoch and Lee Cope.
And who were those people?
John Marvin Murdoch is Alex Murdaugh's brother. Lee Cope is an attorney from their law firm.
And what rooms of the house did you search?
All of them.
And these John Marvin and Lee Cope were with you when you went in every room?
They were.
Did you search any other places?
We searched bathrooms, tubs. There were several attic-type spaces where different holiday decorations were stored. We looked in there, or I looked in there, and we didn't locate anything of value.
Did you look anywhere that you thought there could be a long gun?
Yes.
Did you observe any bloody clothing when you were searching the residence?
I did not.
And you said you were observant?
I was.
You mentioned that Agent Croft had collected some weapons and some ammunition.
He did.
Would that be the 3 shotguns, a Mossberg, a Browning, and a Benelli Super Eagle, along with a 300 blackout rifle?
Yes.
And then some various ammunition?
Yes.
Okay, and what did you do with those items?
So we gathered them together. I filled out the property receipt. We took them back to the SLED office here in Walterboro, where we met with the crime scene agent, Agent Worley, and I receipted those items to her.
So Agent Worley took custody of those items?
She did.
Do you recall at some point speaking or being present at an interview with Buster Murdoch?
I was.
And was any evidence collected during that interview?
Yes, we asked him for consent to do a buccal swab and also consent to look at his cell phone.
I'm going to show you this case exhibit 217. If you could tell me what that exhibit appears to be.
This appears to be the buccal swab from Richard Alexander Buster Murdoch Jr., collected June 10th, 2021 at 3:26 p.m.
Now, did you collect this buccal swab?
I did not.
Who collected it?
Lieutenant Charles Gint with SLED.
Okay. Were you present when it was collected?
I was.
How did Lieutenant Gint collect this swab?
A buccal swab is just 2 cotton swabs. He opened them from the packaging, swabbed his mouth, sealed them back up, placed them in the envelope you see there, sealed it, initialed it, and dated it.
And he would have sealed that up so it was not tampered with. Is that correct?
Yes.
Your Honor, at this time I move State's Exhibit 217 into evidence.
No objection.
Admitted without objection.
Your Honor, I have no further questions for this witness at this time.
Cross-examination.
Please, Your Honor.
Yes, sir.
Let me get. You were present when the phone, Maggie's phone, was recovered, correct?
Yes, sir, I was.
Matter of fact, that when we look at one of these pictures, a rubber glove, that's your hand, correct?
Yes, sir, it is.
And are you aware when you got that call with the passcode that had been gotten by John Marvin? Was John Marvin down there with you when you found the phone?
I don't recall seeing him there, no, sir.
Okay. Are you aware that that passcode came from Alex Murdaugh?
No, sir, I was not aware of that.
And who gave it to you?
Captain Neal.
Okay. Now, you searched the house on the morning of, was it the morning of the 8th?
It would have been the afternoon.
Okay. And you went through the entire house?
Yes, sir.
How many bedrooms in that house? Do you know? How many bathrooms in that house?
3 or 4, I don't recall the exact
Okay,
number.
but you went through every one of them.
Yes, sir.
And you looked at the tub, you looked at the showers, right?
Yes, sir.
What were you looking for?
Ammunition, weapons.
Blood?
If it was there, I was observant. We were looking for anything at that point.
Right. So when you look at the drain in a shower, if somebody's recently showered off blood, you would expect to see some trace evidence there, would you not?
I don't know that I'm qualified to answer that.
Do you know whether there are trace evidence forensics people that actually go in and swab those, right?
There are, yes, sir.
Were they there?
No, sir.
Did anyone ever ask them to come that you know of?
Not that I'm aware
Do
of,
you know
no,
whether
sir.
any of those showers or tubs were in any way swabbed or checked for blood or tissue or any DNA, anything that would indicate somebody had washed off evidence of a crime?
Nothing that I'm aware of.
Okay. But you, apparently you were the only one to do this, correct?
Yes, sir.
The only person that actually looked at the showers and the tubs, you eyeballed them, right?
I did.
You're the only person who SLED had examined the showers and tubs. And you're telling this jury you saw no evidence of blood, tissue, or anything that would indicate somebody had showered or washed off or bathed to remove evidence of a crime from them. Is that what you're telling us?
Yes, sir. There was nothing visible to me.
Okay. And you were the only one asked to do that by SLED?
As far as I'm aware, yes, sir.
Did you search the bedrooms?
I did.
You find any clothes anywhere? Shirt, pants, shoes that would indicate?
Objection, Your Honor. Could we ask one question at a time, please?
Well, I'm just including a class. Rather than asking it individually, I apologize. I can do it individually. Take a little longer. Thank you. Any clothes, shoes, any evidence of clothing that would have blood on it or indicate it had blood on it or tissue, anything that you saw in any of the bedrooms. How many bedrooms?
Several.
Several. You looked at all of them?
Yes, sir, I did.
Looked under the beds?
I did.
In the closets?
I did.
See any evidence of any clothes that had been involved in any sort of altercation that had left blood or tissue or brains? You see anything like that in any one of those rooms?
No, sir, I didn't find anything like that.
Thank you. I'll seek the court's indulgence. Thank you. No further questions.
Any redirect?
No further state, Your Honor.
Thank you. You can step down. Ladies and gentlemen, we're going to have you leave for the day and to return tomorrow at 11:30 will be our start time tomorrow. 11:30, so you get a few extra hours today and tomorrow. Please remember not to discuss the case, to be exposed to any information concerning the case. And we will see you tomorrow. You'll go to the jury room. Be seated. Mr. Waters, we'll continue with the 404 witnesses.
Yes, sir, Your Honor. I might have miscalculated by about 30 minutes, so I apologize. The witness is close by. If you'll give me 1 moment, please.
Does that?
Yeah, we'll be at ease for a few minutes.
Yes, sir. The state calls Michael Gunn for the in-camera hearing.
Left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God?
Yes, ma'am.
Thank you. Speak loudly. Take a seat in the witness stand. State your whole name. Spell your last name for the record.
Yes, ma'am. Michael Gunn. Last name is Gunn.
All right, Mr. Gunn, this is obviously an in-camera hearing to determine the admissibility of some of the testimony. Do you understand that?
Yes, sir.
All right, and so I'm not going to go into all the background and everything for purposes of this hearing, but just very quickly, where do you work?
I'm a principal at Ford's Consulting and also do some lobbying work for the South Carolina Association for Justice.
Okay, and just very quickly, tell us what Ford's Consulting is and what services it provides.
Ford's Consulting, we are a general insurance agency, but also offer financial services such as structured settlements, regular annuities, deferral of attorney's fees, trust. We do lien resolution, back office trust account reconciliation, all sorts of things for plaintiffs primarily and their families.
All right, and then if you could, just very quickly, just for the record, explain what a structure is and how that interfaces with plaintiffs' lawyers.
Sure. So a traditional structured settlement is between the parties, and that normally means between the plaintiff and the defendant or their insurer. And so usually it was set up in the 80s. It was designed to help plaintiffs protect their money and to keep their money. And it can be earned tax-free. Interest grows on that tax-free. And it's a very good tool, especially for minor children, for those who are incapacitated, disabled. Because of that growth, it can provide a steady stream of income, hopefully for the rest of their lives. Yes, ma'am.
You're talking faster than I do, and that says something.
I've been accused of that before.
All right, I know you just ran over here, so let's take it down just
no worries,
a notch.
no worries.
All right, good deal. Okay, so take it up from there. If you want.
So essentially, the structured settlement, though, would come primarily, usually, except in very small circumstances, would come from the defendant and or its insurer to fund the annuity for the client.
Okay. And so the idea is instead of getting a settlement in a lump sum, it's in an annuity, so they get regular payments over the course of the term of that annuity.
That's correct, yes, sir.
So explain to me just very quickly again for the record the concept of constructive receipt and how that affects structures that you may do for a plaintiff's attorney and their clients.
Sure. So constructive receipt by the IRS is deemed when the money arrives in the plaintiff's trust account. That would be considered they have received the funds, and therefore the ability to do a structure has been taken off the table. The only way that you could do a structure after that would be to return the funds to the defendant and or its insurer, and then therefore let the they would have to agree to play ball and redo all the documents because there's so much language that's included in the documents that specifies this.
All right, so the settlement can't go to the law firm and then to the annuity company. That will ruin the constructive receipt and ruin the tax advantages of that.
It is in very rare cases that we're able to do that.
But
generally speaking, correct.
All right, so generally your services that you provide are consulting to sort of match up the client with an annuity company, and then that money is going to, in the settlement or whatever it is, verdict is going to go from the defendant or the insurer that's paying whatever that is, that verdict or settlement, directly to that annuity company for the benefit of that client.
That is correct.
Can't go to the law firm, generally.
Generally speaking.
Okay. All right. How long have you been with Ford's Consulting doing this work?
It'll be 18 years this summer.
All right. And what's the actual full legal name of the entity that you are part of?
Ford's Consulting, LLC.
Okay. Over the course of your involvement with this business, have you gotten to know the defendant, Alex Murdaugh?
I have.
All right. And just very quickly, tell me the capacity in which you got to know him.
It bore from a professional relationship, doing work with the trial lawyers, conventions, CLEs, things of that nature, which ultimately turned into a friendship born out of business.
Okay. And when you say friendship, was it a close friendship or more like a business relationship type of friendship?
I would say a business relationship type of friendship, but one that you would text with and call on occasion and things.
Okay. Did you ever do any structures for any clients that were represented by Alex Murdaugh as a plaintiff's lawyer?
Yes, we did.
All right. And just roughly, you remember how many?
I would probably say around 5.
Did you ever, what's the last one you remember at least having some discussion with him about doing a structure?
The last one that I remember having discussion with, I believe, was the Dion Martin case.
Okay, and tell me about that. Did that ever come to fruition or not?
It did not.
All right, and tell me what you mean.
We sent over some quotes. We got some information back from the defendant. He sent us information, a signed option, which I would assume was Mr. Martin's. Sent some information back, and annuities, you have to understand, are priced on a daily market. Sometimes that rate is good for a week or two. I sent several emails back saying, hey, this rate is going to expire. We need to move forward. And ultimately, we ended up closing the case cash because we never got a response.
All right, when you say you sent emails asking for a response, who were you sending those to?
I was sending those to Mr. Murdoch as well as his paralegal, Annette Griswold.
Okay. And so ultimately got no response, so you just closed the file without any services ultimately being provided by Forge Consulting, LLC?
That is correct, yes, sir.
I'm going to show you very quickly what's been marked as Exhibit 321 for this in-camera hearing, and specifically direct your attention to the 5th page of this exhibit and just see if you recognize that. And then you can flip to the next couple of pages, please.
Yes, sir, I do.
All right, tell us what that is. Just kind of flip through first.
That's just an annuitized payment stream showing you when the payments will be made.
Okay.
And what the amount is.
And that's kind of the market rate thing you were talking about?
Yes, sir. Yes,
All right, and what are the next documents? Just in
the next page is a disclosure page where we list all our disclosures, and it appears to had been signed by Dion Martin.
Okay, keep going. That's the only Forge-related documents you see?
Well, I see this. That's the only Forge-related documents I see. Yes, sir.
All right, let me take that back.
Yep.
All right. Put those up on the screen real quick. All right, so that's sort of the annuity schedule, is that correct?
Yes, sir.
And then this is the disclosure page you were talking about?
Yep. Yes, sir.
And that is Forge-generated paperwork typically?
That is correct, yes.
But this particular structure was never done because you never got a response from Elkin?
No, sir.
Or his office, is that correct?
That is correct.
Sirens pass. Are you aware generally of what people call the boat wreck case or the boat case as it relates to the defendant, Alex Murdaugh?
Generally, yes.
All right, and just without going to specific facts, generally what was your understanding of that?
There was a terrible accident that happened somewhere down in the Low Country involving Mr. Murdoch's son and several others, and a young girl passed away.
Were you aware that his son had been charged in that particular case?
I was.
And were you aware that Alex Murdaugh had been sued in a civil matter relating to that case?
I believe I was made aware through the news, yes.
Did you ever have any conversation? Well, let me ask you this first. Is it possible for lawyers to structure fees? Not the client, but the lawyer, if they're going to get a big fee from a large recovery and they decide they want the protection of an annuity, can they do that?
Yes, they can.
All right. And how does that work? Kind of the same thing?
It's the exact same manner as if the client were to do it. The check would have to come from the insurance carrier and or the defendant to fund the structured settlement annuity for the lawyer for their fee.
Did you ever have any discussion with Alex Murdaugh, either before or after the boat case, about structuring any fees that he had received in the case?
We had general conversations about structuring fees, but it would be the same conversation I would have with any attorney, like how you would do it, how you would go about doing it, and how checks would be made payable, et cetera.
Did you ever have any specific discussion after the boat case about the boat case and him wanting to structure any fees?
Not that I recall.
I want to take you to September 2021. Did you, around that time, receive a call from Lee Cope?
I did.
All right. And what did Mr. Cope ask you?
He called and asked me if he could, in confidence, give me a list of cases and see if we had any files on them. I told him that'd be fine. I was standing in my driveway. I wrote them down, got back with him later that evening, and let him know that we did not have any of those cases open.
Okay. He gave you a list of clients and asked if you had any structures open for those, or potential structures.
He had asked me if we had any files at all. Generally, what we will do is if an attorney calls, we will open the case immediately, just so we have a name associated with the attorney.
Okay. And so he gave you a list of names. Did any of those names have any files?
No.
All right. Did he ask you about any banking that Forge Consulting LLC did?
He did.
And what was his question to you?
He asked me if we banked with Bank of America.
And what was your response?
I told him that we had banked with Bank of America, but had not for the last 3 or 4 years.
So you did not have an active account with Bank of America
We did not, no.
in September of 2021?
No, sir.
Did you have any subsequent conversation with Mr. Cope about the issues that he had raised with you?
I did. He called me the following day as well, which I believe was a Thursday, with another list of cases.
All right. And what was his inquiry to you?
Same inquiry. This time, the only one that popped up was the one I mentioned earlier, which is the Dion Martin case.
All right. And your response was there was a file, but it was never completed.
There was a file, but it was never completed, and we closed it out.
Did you ask him at this point, or did what was going on, or why these inquiries were being made?
I did not.
Did you ultimately find out what was going on and why these inquiries were being made?
I found out on the Tuesday after Labor Day.
All right. What did you find out?
I spoke with Lee Cope, and he told me that Alex had been using an account called Forge to process the checks.
Is that account that he had been using, is that a legitimate Forge Consulting account?
Absolutely not.
Did any of that money that went into that account go to legitimate Forge?
No, sir.
Did Forge Consulting have anything to do with that particular account?
No, sir.
Let me show you a couple things real quick. Show you what's been marked as Exhibit 335 to your testimony in this in-camera hearing, and just have you look at that. You look at the name on that particular account.
Yes, sir.
All right, what does that say?
Richard A. Murdoch, sole proprietor, DBA Forge.
All right, and is that account a legitimate Forge account?
It is not a legitimate Forge consulting account, no, sir.
Any money that went into that account, did it have any legitimate relationship to the services and business that y'all provide to claims attorneys?
No, sir, none at all.
Exhibit 328. You see that check right there?
I do.
Made out to Forge?
Yes, sir.
Did that come to any legitimate Forge account?
It did not.
Stand by for me 1 second. Your Honor, to save a little time, I believe defense is willing to concede that if we went through all these exhibits that we introduced with Ms. Seckinger with all those checks made out to Forge from the PMPD trust account, for purposes of this hearing only, they will stipulate that none of those went to a legitimate Forge account and instead went to the Bank of America DBA, Richard Murdoch DBA Forge account that he just testified is not a legitimate Forge account.
I want to be more careful with the words. We are not contesting that issue for purposes of this hearing. That's correct. I don't want anything coming back.
Accept that stipulation as well.
They're not contesting that these checks all went to this particular account and did not go to legitimate Forge. For purposes of this hearing alone, I think that's acceptable to the state, Your Honor.
Yes, sir.
Right? It's so stipulated.
Yeah, we're not contesting. That's
Yes, sir.
yes.
Not contesting. Just want to be real quick. 327, is that legit?
No, sir.
326, is that legit?
No, sir.
325, is that legit?
No, sir.
324, is that legit?
No, sir.
323, is that legit?
No, sir.
322, is that legit?
No, sir.
321, is that legit?
No, sir.
320, is that legit?
No, sir.
319, is that legit?
No, sir.
318, is that legit?
No, sir.
317, is that legit?
No, sir.
315, is that legit?
No, sir.
And finally, 311, is that legit?
No, sir.
And by asking you not legit, did you just look at the checks on those various exhibits?
I did.
And all the ones that had forged on them from a client trust account, those are not checks that went to any legitimate forged account. Is that correct?
No, sir.
Is that correct?
That is correct, yes.
Thank you. Your Honor, I believe that's all the questions I have for this witness. I'm sorry, excuse me. Thank you. Just really quick, at any time, did you ever hand deliver any checks to Alex Murdaugh for forge-related business?
No, sir.
And would that work?
I would not be delivering any checks. The only time that I would ever deliver a check would be made out to someone other than Forge. You would never make a check payable to us.
But you never had any legitimate business where I was like, hey, I'm gonna be in town. I'll come by and pick up the annuity, the check for the annuity, or anything?
No.
Nothing further for purposes of this hearing at this time, Your Honor.
Defense.
Very briefly, Your Honor.
Good afternoon.
Yeah, I am sure that your Forge Consulting LLC has done a full investigation into this matter.
Yes, sir, we have.
And in that investigation, did you find in any record of this account that Bank of America under Alex Murdaugh doing business as Forge, did you see the name Maggie Murdoch or Paul Murdoch as co-signatories to that account?
No, sir.
You seen any record, any document that Maggie Murdoch or Paul Murdoch had anything to do with this account?
No, sir.
Your company is an insurance agent. Did you ever sell any life insurance to Alex Murdaugh on the life of Maggie Murdoch?
No, sir.
Did you ever sell any life insurance to Alex Murdaugh on the life of Paul Murdoch?
No, sir.
All right, that's all I have, Your Honor.
Anything further?
Nothing to say, Your Honor.
You may call your next witness.
Your Honor, state calls Chris Wilson. I'm sorry, Your Honor, he's downstairs. We'll get him right away.
microphone on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? I do. Take a seat in the witness stand. State your name again for the record. Spell your last name, please.
My name is James Christopher Wilson, Wilson. I go by Chris.
Mr. Wilson, you understand that we're here for an in-camera hearing to determine the admissibility of your testimony.
I do.
All right, and you're a lawyer, so you get that.
Yes, sir.
So I'm not going to go into a lot, everything that I might cover with you in a trial, but I do want to focus on particularly the Ferris case. You know which one I'm referring to?
Sure.
First of all, though, just very quickly, you're a lawyer, is that correct?
I am, since 1998.
1998. And describe very quickly your practice for the record.
Actually, since 1995. I've had my own practice since 1998. In the last 15 years, I've done primarily personal injury work, automobile accidents, people that are injured at work, practice type cases, those things.
And where do you normally practice? Where's your home base?
My only office is in Bamberg.
Do a lot of claims work?
That's all I do anymore. For the last 15 years, that's really all I do.
And do you know the defendant?
I do.
And when did you get to know the defendant?
I've known Alex since we were in high school. Bamberg and Hampton. I grew up in Bamberg, and they're only about 30 miles apart. And so I knew of Alex and had been around him some growing up. We had some mutual friends. I was a lot closer to some other guys in Hampton that I grew up playing golf and things like that with, but I would cross paths with Alec. Played on the same baseball team one summer, I think like our senior years in high school or somewhere around high school age. Didn't really keep in touch with him or cross paths with him until we ended up going to law school, and we started law school together at Carolina. 3 years there together at law school and lived together part of the time.
Did y'all become friends?
We did.
Become close friends?
Very close.
Best friends?
He was one of my best friends, yes. And I thought, he was, and I thought he felt the same way about me.
You feel that way now?
I don't know how I feel now, Mr. Waters.
Fair enough. Over the years, as you developed that close friendship with Alec, did y'all also have a professional relationship as well?
We did. When I finished law school, I went to work in Greenville for a judge for a year. Alec went to Beaufort to work with a law firm there. So we'd see each other, but it was more socially then. When I moved back to Bamberg to start practicing where I'd grown up, and he moved back to Hampton a couple years later, we started doing a little bit more work together, and we've done cases together really since 1998. I opened up my own firm in 98. I think that's about the same time he had moved back to his firm. And it was a bigger firm with resources that I didn't have starting out on my own, and so we started working cases together and worked a lot together.
Tell me, for the record, how that works when you're in a different firm than the firm he was in, correct?
Yes.
And so when two lawyers from different firms, or three, however many it is, share a case, how do you handle the payment of the fees if there's a successful recovery?
Well, it really all depends on the agreement that's reached up front between the lawyers and with the client's consent. But generally, all the cases that I work with his firm and with most firms I do business with, it's a 50-50 split on the fee recovery, or at least an equal split. Maybe if there are more than two lawyers, it'll be an equal split across the board. But generally, it was just my firm and his firm with a 50-50 split on attorney's fees recovered, and each firm recovers whatever cost they've advanced in the case. And sometimes his firm would advance more of the cost because they had a larger number of lawyers bringing in more money than I was and could afford to handle some of the bigger costs. But it's kind of whoever got the bill paid the bill, and then we reimbursed at the end whoever had advanced the cost.
Okay.
The client signs off on all of that.
Who ultimately, in those situations where is splitting a fee, is that a good way to call it?
Yes, sir.
Who handles the ultimate disbursement? How does that work?
whichever lawyer receives the settlement checks or the checks to pay whatever verdict or judgment that was received. I can't say in every single case with Alex firm, but in having gone back through my files and audited my paperwork, it looks like in almost every single case that we worked together, the disbursement, the money would come through to me and I would handle the disbursement. They were generally clients where I would associate his firm. They were my clients. They were people that had come to me, and I wanted them to, frankly, know that I was the person that took care of them, and if they needed anything, they could come back. And so I wanted to be the person handling that part of it also.
All right. So if the money comes through you, then just mechanically, how do you go about paying Alec in a case where y'all are splitting a fee, or paying the firm?
Money comes in. Client has to come sign the check or whatever it is, along with my firm if it's made payable. It's generally made payable to Wilson Law Group or Wilson Law Firm and the client. Client comes in and signs the check. I endorse the check. We deposit that into my trust account. If it has to sit under Supreme Court rules, sometimes it has to sit for 10 days or more. Some smaller checks don't. Once it's been in the account long enough to be able to be dispersed pursuant to our rules, then my bookkeeper does the checks that I instruct her to do, and I sign the checks to make disbursements. If they're checks to another law firm, then the money is dispersed to that firm.
All right. In the course of litigation, are there typically costs and expenses that accrue during the course of that litigation?
Almost always.
And do those typically get paid out of whatever settlement is reaching, assuming a successful result?
They do. All of my fee agreements and every lawyer I've ever worked with have a provision in there that the client understands that the fees are advanced by the lawyer, but upon recovery they're reimbursed or recovered by the lawyer.
In a particular case where you're splitting a fee and there were in fact fees and costs associated with a successful recovery, costs and expenses associated with a successful recovery, are those issued in a separate check typically, or a check together?
When I first started, I think my firm was doing costs and fees, not just for other firms, but costs and fees that were payable to my firm in the same check. But I mean, 10 plus years ago, if not longer, we started doing separate checks just to make the accounting and keeping up with it easier. So generally it's a fee check and a separate cost check.
And in 2020 and 2021, were you issuing those separate checks?
Yes.
Very quickly, without getting into the details, did you have a case in Allendale where you split it with Alec in the early part of 2021?
Yes, sir.
All right. And ultimately, was there a recovery in that case?
There was.
And
it was actually 3 cases, but they were similar factually, and so we treated them as one case, but it was three separate plaintiffs, 3 separate cases.
And ultimately, did your office disperse the fees and the expense check to PMPED?
On all 3 cases, yes, sir.
And those checks were made out to what when you dispersed those?
All 3 of the fee checks were made payable to, I don't know if we used the acronym PMPED or if we actually spelled out Peters, Murdoch, Parker, Dietrich, and Ellsworth, but PMPED.
And generally, except for the Ferris case, which we'll talk about in a minute,
Sure.
When you had those fee splits with Alec, were the checks made out to PMPED?
Yes,
They
sir.
were signed by you?
Yes, sir. And I'm the only person who can sign checks in my office. So, well, and now I had a partner at one time, but now I'm the only person that can sign checks.
Did you have a case involving Mack Trucks that involved Alec?
Yes, sir.
And can you describe to the court how you ended up getting that case and how you ultimately associated Alec in that case, please?
Sure. And I've heard it referred to as the Ferris case, so Mack Trucks and Ferris. I'd rather refer to it as the Mack Trucks case. Another lawyer had contacted me about a case that he was working on. Felt like he had a wreck involving a tractor trailer and an automobile in which a gentleman was injured. I believe he had already filed suit against the tractor trailer company and its driver and maybe another party. Started looking at the case for and with him. It involved a drive shaft that had fallen out of a Mack truck into the interstate, and this gentleman had, and a number of other cars had hit that drive shaft. And in looking at it and doing a little bit of research, I and he together realized that there very likely could be a products liability case involving a defect with the drive shaft of the truck or something like that. So, so I reached out to Alec and asked him if he could get involved in the case or would get involved in the case. I mean, that's what his firm specialized in a lot, was products liability cases. And we were pushing some deadlines to bring in all the parties that we needed to, and so I reached out pretty quickly because I knew we needed some help.
And did he agree to be part of that case?
He did.
As that litigation proceeded, did y'all have, as is typical, some discovery hearings, discovery motions, and that sort of thing?
Well, we had a number of them. I don't remember how many, but we had a number of different motions and discovery that went back and forth, documents being exchanged, things like that.
All right. And did that ultimately set up the prospect of a trial in that case?
It did, but it was unusual. It wasn't a jury trial like is normally done in personal injury cases. It was a non-jury trial tried before a circuit court judge with an admission of liability. We waived punitive damages, and there was an agreement between the parties that neither party would appeal the result.
And in a case, plaintiff's case, civil plaintiff's case like this, if there's a large recovery, let's say for the plaintiff, and the defendant decides to appeal, does that typically delay payment of the recovery until that appeal is heard and resolved?
I mean, it can. Appeals, you never know how long an appeal is going to take, and so if the losing party, the defendant, the company that you're suing, whoever it might be, decides to appeal, they can tie the verdict up for a while. If you win the appeal, you're going to recover cost and interest, so you know, that's the remedy, but it can tie up money for people that are injured that need that money.
Did y'all ultimately try that case in a bench trial?
We did.
What county was it?
Excuse me?
What county?
It was in Richland County, Columbia.
And when did y'all try that case?
The first part of January of 2021.
And who did the closing argument in that case?
Alec.
Alec did. Did y'all ultimately, there had been a concession of liability, so the amount was really what was in question. Is that correct?
Yes, sir.
And how many plaintiffs did you have?
There were actually two cases, when we call it Ferris or the Mack Trucks case throughout all of this, but there were actually two cases. The gentleman that was injured and then his wife, we brought a loss of consortium claim for her for the loss of companion services that she had lost from him. And just not to get too detailed, Mr. Ward, that her case had gone into default. In other words, Mack Trucks hadn't answered the papers like they should have, and so they were in a really bad position on that case. And in the gentleman's case, they had answered, but we were discovering some things. When we were doing some discovery, it was clear they didn't want us looking much further. And so that's why this deal, everybody agreed to a non-jury trial without appeal with a waiver of punitive damages and an admission of liability was done. And we were in COVID, and it was going to take us a while to get a trial. So it worked out well for both parties, and the result worked out well for us.
And that's often how it goes in litigation. Both sides kind of decide what's best, and sometimes they can have a meeting of the minds.
Yes, sir.
All right. Was there ultimately a verdict by the judge in that case?
Well, two verdicts since two cases, yes, sir.
And what were those amounts?
I believe it was $4 million for the injured man and 1.5 for the wife. I remember it was 5.5 combined, but I think it was 4 and 1.5.
And so how did the fees break down, to the best of your recollection, that were going to be split among the three lawyers involved?
There were
let me ask you this. Do you remember how much Alex shared of the fees?
$792,000.
Okay. And yours?
There was a larger split to the attorney that initiated the case, but I believe Alec was $792. The math didn't work out perfectly. I was $791, and the other attorney was higher than that, but I don't remember the exact numbers.
In recognition of his origination?
Yes, sir.
In March of 2021, did you ultimately receive the monies and prepare for disbursement?
Yes, sir. I believe they came in late February because we dispersed in March, and I had to wait at least 10 days. Part of the money came by a wire, which would have been kind of immediately available and accessible, but it was a smaller portion of the money. The larger portion came in a check, And because it was such a sizable amount, I waited maybe 12 or 15 days or so. I didn't disperse on the 10th day.
And did you have a conversation with the defendant about dispersing those fees?
I had a conversation with Alec and with the other attorney I worked on the case with when the fees were ready to be dispersed.
What about your specific conversation with Alec? Did he make any requests of you or have any discussion with you about how to handle his $792,000 share of the fees?
He did.
And tell me about that conversation, please.
When I contacted him and told him we were getting ready to disperse and we would have checks ready, he indicated to me that he was looking to place his fees in an annuity. He called it like a structure. I've never done one of those before, so I didn't really know how it worked. I've never done structure for my fees myself. I've structured client money, but not my fees. He indicated he was looking to do a structure by putting the monies into annuities, and that the checks needed to be made payable directly to him, that he had already cleared it with his firm, that the monies were going to be put on the books and accounted for, and he would be credited as having received those monies.
Based on his representations to you that he had cleared it with his firm, did you agree to do something different and make the checks directly out to him?
I did.
What's been marked as Exhibit 345, states 345 for purposes of this in-camera hearing, and see if you recognize that particular document.
I do.
All right, and what is that?
So this is the initial check that was written per Alex instructions directly to him on the gentleman's case for fees made payable to Richard Alexander Murdoch, Esquire, for $600,000. It's voided.
And why was it voided?
Because he instructed me afterwards, and I don't remember if it was in the same conversation or shortly thereafter. It must have been shortly thereafter, that the checks on that case needed to be made in 2 separate check payments. He was doing 2 separate annuities.
Marked as 346 for purposes of this in-camera hearing, and see if you recognize these documents.
Yes, sir. The first page is the check payable directly to Richard Alexander Murdoch, Esquire, for $192,000, and that is on the loss of consortium case for the wife. And on the bottom, just like that $600,000 check that was voided, it indicates it was for fees. I guess the other writing on here is maybe from
I'm just focused
the checks.
on the checks.
It's something to do with the way we recovered the checks.
All right.
The back page looks like an endorsement. Pay Bank of America deposit only. Looks like a signature, Bank of America.
Okay. And again, I'm just asking you to see if you recognize those checks.
Yes, I do.
Yeah.
I recognize
All right. Tell me the second check, just the amount and what that's for.
The second check is for $225,000 payable directly to Richard Alexander Murdoch, Esquire. It indicates on the bottom that it's for fees. This would be part of the rewrite of that $600,000 check that had been voided.
All right.
And then the third check is $375,000 check payable directly to Richard Alexander Murdoch, Esquire. and it indicates fees, and that would be the remainder of the rewrite of that $600,000 check initially written that was voided.
And those second two were rewritten, why?
At Alex's request, he had indicated that he was putting the money into two different vehicles or annuities, and needed the checks written that way.
All right. What did you do with those checks after you, the 3 checks after you had finally cut them?
Obviously, I signed them, and at some point in time, I think Alex sent somebody up to my office to pick them up. I don't think I delivered them. Oftentimes, I put checks in the mail. Sometimes when they're larger, I either offer to have them picked up or delivered, and I think he had somebody come pick those up from my office.
Like a law firm runner or somebody like that?
Something like that, yes, sir. I don't even think I was in the office when they picked it up.
You've known Alex for a long time, right?
Since they're since the mid-'80s, mid-'80s, yes, sir.
Worked with him for a long time?
Many times.
Did his explanation to you about what he was going to do, did that raise any suspicions with you, to your friend that you've known for such a long time?
No, sir. It was different, but it didn't raise any red flags or suspicions to me that anything wrong was going on.
Because you trusted your friend, right?
Very much.
What was your perception of Alex's general wealth and success?
Thought he made a lot more money than I did. Always seemed to do well in his practice. All I ever heard is that he was one of the biggest producers in the firm. It's his family's name on the firm, but they acted like it was his name on the firm too. He and I handled big cases together. When I talked to the partners and other members of that firm, they were talking about big cases that they were handling with him. Felt like he did really well. And we never got into direct discussions about the amount of money he made or the amount of money I made. We talked about, sometimes business and sometimes money and sometimes things, but I always thought he made a lot of money.
Is that part of the reason why your suspicions didn't arise when you were asked to do this request by Alec?
I guess so. Not so much as just I'd never had any dealings with him that I'd had any reason to distrust what he was telling me. I mean, he was a partner in that firm. He had the authority, as far as I knew, to make decisions. If he'd have wanted to reduce the fee and take less, and it was payable to the firm, I wouldn't have questioned that. I didn't feel like he had to have his authority, his partner's approvals to make those type decisions.
All right, I'm going to show you what's been marked as 347 and see if you recognize that document.
Yes, sir. The first check is a check that was made in May of 2021, May 13th, to Peters, Parker, Murdoch, Ellsworth, and Dietrich for $14,619.13. I don't think on the bottom it says anything, but this was a cost reimbursement check on one of those two cases. And then the second check is a check made payable on the same day, May 13th, for the same amount of money plus 1 cent, so for 14 cents. And it was a cost reimbursement in the other case.
All right.
And that's made payable to the law firm also.
Who was your assistant or paralegal at this point in time?
Vicky. I mean, she's one of several, but Vicky is my primary paralegal.
At some point in May of 2021, did Vicky advise you of any inquiry coming from PMPED about where these fees were?
No, she didn't advise me in May about any inquiry about where the fees were. She had received an email in May from Alex Paralegal, Annette, that said, hey, we got the cost check, but we don't have the fees. Where are the fees? And she replied to that email to Annette and said, Your boss has already been paid the fees just like mine and the other lawyer. Vicky replied to that email. I didn't know about that email until all of this came out in September of what was going on. I didn't know about that reply email to Annette. Vicky did receive another email from Annette, and as I recall, it was an email that Annette had received from Jeannie Seckinger that Vicky did forward to me sometime towards the end of May. I think she had gotten it, but she was out on vacation for a couple of days, and when she got back, she forwarded it to me. And it was an email from Jeannie Seckinger that said something to the effect of, Alex thought he was owed more cost in the case, had some questions about cost, and they were trying to get some information so they could determine if they were owed more cost. She did forward me that email.
I'm going to show you what's been marked as 348 for the purposes of this hearing. States 348, and see if you recognize that document.
Yes, sir. This looks like the email string where Jeannie Seckinger, the Chief Financial Officer at PMPED, emailed Annette Griswold, which was Alex's primary paralegal, basically says that Nicole, I don't even know who that is, brought them the expense check and that didn't match their records. Alex thinks he has more outstanding cost, but can't say what, and they want to see if they can get some information concerning expenses and disbursements. Looks like Annette forwarded that to my paralegal, Vicky, on May the 27th. Vicky was out. Looks like Annette asked her again on June the 2nd if she could get her some information, and Vicky replied to Annette that she didn't deal with some of the documentation they were requesting, and so she would forward it to me.
And what? That's June the 2nd. When?
2021, June 2nd.
June 2nd, 2021.
Yes, sir.
At this point in time, are Alex's fees still in your trust account?
No, sir. They were dispersed. The check was March. I don't know the exact date, but they were dispersed in 3 separate checks in March.
Okay. At some point in time, around this June 2nd, thereabouts, did you receive any call from Lee Cope?
I believe I had a conversation with Lee Cope. I was trying a case in Hampton the week before that, and I was in and out of their office. And I believe I had a conversation with Lee. That would have been like the week of May the 24th or some of those days in there. And I believe I had a conversation with Lee. He asked me if all the money had been dispersed in the Ferris case. And I told him that it had not been, that we had some liens outstanding, medical bills and liens outstanding, and we were holding money for some additional costs in case things came in. And he didn't ask me any further questions. He did not mention that there were any issues or concerns about fees.
After you received that call from Lee Cope, well, what did you tell Lee Cope?
I told him I'd have to check into it.
After that, did you reach out to the defendant?
I did.
And what was your conversation with him?
I reached out to Alec and I said, Alec, hey, I don't know what all we talked about in that call, but at some point in time we talked about, I said, hey, I've got this email that's been forwarded to me by Vicky where your firm is saying that you believe you're owed more cost. I put the cost down on the disbursement sheet that you had given me. But if you've got more cost, just figure out what it is and get it to me. We're holding some money to deal with some medical bills and liens. And with the client's consent, we were holding some money in case additional costs come in. Sometimes costs are slow coming in, and that's normal. And if there's an issue, just let me know. He said, I'll check on it, or there's not an issue, or I'll check on it. And I said, hey, this is the case that I disperse the fees to you, per your request. is everything all right? And he said, yeah, I just got to make sure they know it's on the books the right way and that this is the case that we've already worked out, the put it on the books.
Did he tell you he had structured those fees and annuities as he had told you before?
Yeah, that he had put them in the annuities.
Put them in the annuities. Firm's going to make sure they're on the books.
As far as I knew, the firm was aware that the monies had been paid to him, that he was putting them into annuities, that they would credit him as already having been paid, and they would account for that whenever or however they split up money.
Just to be clear, those funds were not in your trust account. They were gone at that point.
Yes, sir. They've been gone since March, and whenever those checks were cashed after I wrote them in March.
$792,000.
Yes, sir.
For purposes of this hearing, I'm not going to go into the night when Maggie and Paul were killed, but just very quickly, you did have some texts and calls with Alec that night. Is that correct?
Yes, sir.
And you were at the residence and responding as friends and family did in the aftermath of that event. Is that correct?
Yes, sir.
After a few weeks after the murders, did you
I've got one. I got one.
You good? Take a second.
Fine.
You good?
Fine. Yes, sir. I'm fine.
A few weeks after the murders, did you have another conversation with Alec, asking him if everything had been handled with the firm and those fees?
Yes, sir. I don't remember if it was 2 weeks or 3 weeks or what it was. I mean, everybody was destroyed. I don't think anybody was focusing on that. I know I wasn't, but at some point in time after that, I just said, hey, is everything all right with the contact I got him with those fees? And he said it was.
At some point in mid-July 2021, over a month after the murders, did Alec call you up and ask you anything about these fees?
He did.
Tell me what your conversation with Alec was about these fees.
He contacted me and said that he was not able to structure the fees the way that he thought he was going to be able to do, that he had messed that up, and that the fees needed to be paid to the firm, and they needed to go back through my trust account.
Okay. And what did you say at that point?
I didn't see anything that caused me any red flags or anything, and felt like if that's what had to be done, that the fees had to be paid to his firm and needed to go back through my trust account. He could send me the money, and I could run it back through my trust account and then pay it to his firm.
So he's promising, he's saying, I will send you the money back. Is that correct?
Yes, sir.
Did you ultimately receive any funds?
600,000 of the 792.
You only received 600,000?
Yes, sir.
And how did you receive that? Do you recall?
I think it came in two different wires, that either came on the same day or on back-to-back days.
Did one of those wires come from Palmetto State Bank for $350,000?
I believe so, yes, sir.
And that was on or about July 15th?
That sounds right, yes, sir.
And the other was about $250,000 on July 16th, 2021?
I believe from Bank of America, yes, sir.
That was only $600,000?
Yes, sir.
So you're short from what you'd already given to Alec, correct?
Yes, sir.
How much are you short?
$192,000.
$192,000.
Yes, sir.
Did you have a conversation with Alec about being short?
I did.
And what was your conversation with Alec?
He told me that he wasn't able to access the $192,000 immediately, that he had already put it into the annuity, but he couldn't do it the way he wanted to, but he couldn't access it because it would be penalized if it was withdrawn, and that he would get me the money.
So what did you do in response to what your friend told you to do, or told you about the reason why he was short $192,000?
I mean, at that point, I had an indication that I was supposed to have $792,000 in my trust account that was supposed to have been paid to his firm. I'm responsible for that trust account. I put $192,000 of my own money in that trust account to cover the shortfall.
Based on his representation that he'd get you back?
Yes, sir.
going to show you what's been marked as Exhibit 349, states 349 for this in-camera hearing, and do you recognize that?
I do.
Tell me what that is, please.
This is an email that I sent to Alec at his request. He said he needed to be able to provide it to his firm so they'd know the money was being held, and it was dated July 19th of 2021. It says, Alec, as discussed, I'm confirming that I'm holding in trust $600,000 in the gentleman's case and $192,000 in the lady's case, which represent attorney's fees. I'll continue to hold these monies in trust until I am instructed by you or your firm regarding payment.
You sent that email at that point in time. Did you receive any further inquiry at that point in time, at least, from the law firm saying, all right, go ahead and send us the 792?
Mr. Waters, I didn't hear anything else from the law firm at all until September the 3rd, 2021, about 3 o'clock in the afternoon, when Mr. Lee Cope called me. The first question he asked me was I still holding $792,000 in my firm? That seemed to be his first concern, and I said, yes, I am. And he said, well, we need to get that money paid to us. And then he told me that they had discovered a check that I think I remember him telling me that was from me to Alec in the firm, and that they had discovered that Alec was stealing money from the firm and from clients, and that he could not talk very long, and asked me not to say anything to anybody until the following Tuesday when they could issue a press release.
Let me slow you down just real quick before we get there. At some point in time in August, did you attend any event or any conference where you saw Alec?
I did.
And what was that?
It's called South Carolina Association of Justice now. I still call it the Trial Lawyers Association. We have an annual convention in Hilton Head every August, the first weekend, and I usually attend and was there. And Alec was there.
Did you see Alec there?
I did.
And did you have any conversation with him at that conference about the $192,000 that you covered for him when he was going to pay that back?
I believe I asked him about it, and he indicated he was working on it. Some discussion about his father's estate. His father had just passed, and there would be money coming from the estate, and then with Maggie's estate being tied up, also.
Did he say he might sell some property or something like that?
I think he did mention that he was working towards selling some property.
At this point in time, still a couple of months after the tragic murders of Maggie and Paul, were you still very sensitive to your friend's emotional health and well-being?
Sure. I didn't push him.
Didn't push it?
No, sir.
After that conference where you asked him about it, didn't want to push him, did you have another conversation with him about when that money might be paid?
I believe I did, yes, sir.
All right, I'm going to show you what's been marked as States 350 for this hearing. See if you recognize that.
I do.
Tell me what that is.
It is a very rudimentary, handwritten, scratched-out promissory note that I asked Alec to sign for me, which he did August 17th of 2021. Acknowledging that I had loaned him $192,000 that he would repay within 60 days, I think is what it says.
And tell me how the circumstances of how you came to get this, essentially on a folded piece of paper. This is a copy of it, right?
It is, yes, sir.
All right, tell me about it, please.
That was more about, I wanted to get repaid my money as quickly as possible, but that was more about, I was concerned, just like everybody else, everybody in his firm and everybody in his family, that he was going to do something to himself, that he was going to kill himself. And I knew enough to know that that I couldn't make a claim against his estate if there wasn't something in writing. And so that was more, I went to him and said, Alec, look, I hate to even ask this, but I need to ask you to do this in case something happens to you. And I phrased it like if you get hit by a car or something, but it was It was more about worried about what he might do. And I need to ask you to do this so that if there's a problem, I can deal with it. And he did. He didn't have a problem with it.
You already said this part, but at some point a few weeks later, you get a call from Lee Cope asking about those fees and saying that Alec had been stealing money, right?
Yes, sir.
That hit you like a thunderbolt?
It knocked me down. I mean, I was with a group of guys. I could not talk. Lee told me he could not talk very long. I didn't know how to react.
Did you try to get in touch with Alec?
I did. I mean, I couldn't do it immediately. I think I spoke to Lee for just a minute. He told me I needed to call him right back. I called him back. We talked for just a minute. He couldn't talk long. He said he had other things to take care of to deal with all of what was going on.
Do you remember what day this is?
September 3rd, Friday, 3 o'clock in the afternoon,
2021?
2021. Yes, sir.
You remember it like it was yesterday?
I can tell you exactly where I was and who I was with.
Tell me more about what happened.
I finished up what I was doing with that group. I think I tried to call Alec, or I know I texted him. And I believe I tried to call also, and I couldn't get him.
Okay. Did you continue to try to contact him?
I did. I think he did respond maybe that afternoon later and said, I forget what it was. It was in a meeting or something. I'll call you back as soon as I can. But at some point in time, I kept trying to get him, and we did talk later.
All right. What did you talk about? What day was that when you finally were able to talk to him?
I think I did speak to him that evening, this Friday, September the 3rd, by phone. I don't remember the exact of the conversation, but I said, look, Lee's called me and told me what's going on. What is going on? He said, I really can't talk about it much right now. I said, I need to talk to you, and I want it to be in person. I need to know what's going on. And
What happened next?
well, he said he would try to meet with me the next morning, and that he was sorry. And I don't remember all the gist of that conversation, but the next morning I tried to call him. I woke up and I started driving towards Beaufort because I thought he was staying at John Marvin's house down that way, and I started calling him and driving his direction. And eventually he called me back and said he would meet me in Alameda at his mom and daddy's house.
Did you meet him there?
I did.
Was that in the morning of September 4th?
Probably a little bit before lunchtime, kind of late morning, yes, sir.
Did y'all have a conversation?
We did.
Where was the conversation?
I got there before he did. I don't think I pulled in the driveway. I kind of waited out on the road. Pulled in the driveway. We went in the side door. The caregiver was there. We went out onto the front porch, and we talked on the front porch.
And what did he say to you?
I mean, the first thing I asked him is, Alec, what the F or what the H is going on here? What is going on? And have you done something else to me or that involves me that I don't know about? Because I know about this, and I've got to deal with this. But is there something else you've done that I don't know about that I need to be concerned with?
And what did he say?
He broke down crying. Said I can't right this second. He went inside, came back out with some paper towels, and told me that he had a drug problem, that he was addicted to opioids, and that he had been addicted for, I don't remember if he said 20 or 20 plus years, but for 20 years or so.
Did he say anything about the money?
He told me that he had been stealing money.
Did he have a particular phrase about what he had done to you?
Shit me up.
He said he shit you up?
Shit me up or shit me off or something like that, but I think it was he'd shit me up.
And he said that he admitted to you he had been stealing client money?
Yes, sir.
So he confessed that to you, is that correct?
He said he had shit a lot of people up.
I'm going to show you what's been marked as States 313 in this in-camera hearing. Do you recognize that?
Yes, sir.
What is that?
I think this is the original of that $225,000 fee check written in the gentleman's case directly to Richard Alexander Murdoch, Esquire.
Is that your signature on it?
It is. remember exactly how it ended, Mr. Waters. I was so mad. I mean, I'd loved the guy for so long. And I probably still loved him a little bit, but I was so mad. And I don't remember how it ended. I left. I mean, I asked him, how did I not know these things or see these things, and we talked. He was concerned about me getting my $192,000 back. Seemed concerned. I told him I wasn't worried about that. At that point, I wanted to make sure there wasn't something else.
Just a little bit before lunch on September 4th.
Yes, sir.
You
I
eventually,
mean, we didn't leave. We didn't. I'm sure I yelled at the beginning, or at least raised my voice, but I didn't leave yelling and screaming and hollering. We didn't fight. But I left, and I wasn't happy.
Where'd you go after you left? You remember?
I rode through Hampton. Actually, we threw Hardee's and grabbed something for a bite of lunch on the road and headed back to Columbia where I live.
That day, did you hear anything else about Alec?
I did.
About how long after you left Alec did you hear something?
I had stopped in my office in Bamberg or at the post office to pick something up, and I was somewhere between Bamberg and Columbia when I got a call. It was either from Randy or Lee Cope, but I believe it was Lee Cope.
And what were you informed?
That Alec had been shot in the head and that he was on a helicopter going to the hospital in Savannah. And I think it was Savannah Hospital, but they said the hospital, but I believe they said Savannah Hospital.
What did you do in response to that information?
What the devil's going on? I thought he'd tried to kill himself. I didn't think he was suicidal when I left, but when I heard that, I thought he'd tried to kill himself.
Did you go to the scene, or did you return back home?
I went back home.
Did you try to reach out to Alec after that?
I did not. I talked to his brother Randy, I think some that same day and some on the next day. But by that time, frankly, all this had, for lack of a better term, blown up to where I didn't think I'd be able to talk to Alec. And I don't know that I wanted to.
Have you had a conversation with him since?
I have not spoken to him since that morning at Alameda.
Have you had any other communication with him?
He's texted me once or twice, to which I've responded something very generic, like I'm thinking about your family. And I think he may have written a letter, some short letter that, frankly, I turned over to my lawyers.
I'm going to show you what's been marked as States 351. See if you recognize that.
I do.
And what is that?
This is one of the texts that I received from Alec and my response.
Is that a number you previously had recognized being Alex?
I don't know if I'd ever seen that number before, but it's not the normal cell phone number that I would have used to contact him or he to contact me. I mean, sometimes he'd tell me he was calling me from the phone in his car. Sometimes it would be a number I didn't recognize.
Screen there.
Yes, sir.
Does it say, "So sorry for all the havoc I created for you. I'd do anything to make it right"?
Yes, sir.
Thank you, Mr. Wilson. That's all the questions for this in-camera hearing, Your Honor.
By the defense.
We have no questions, Your Honor.
All right, Mr. Wilson. Take care. How many more witnesses do you anticipate on this matter?
There's a lot of moving parts, Your Honor. I do have a law firm witness that I would like to call on this particular matter, one of the partners. We have The Satterfield matter, there is a confession of judgment, but we can present testimony on that as well. And we have a bank witness to establish the financial condition of Alec at the time these murders happened, which was he was burning through cash like crazy. He was out of options. The $792,000 was gone in no time at all. And I think the evidence is very compelling that for an extended period of time he had been living in a velocity of money that is really quite stunning, and he constantly had to achieve more money to avoid the reckoning that was happening. I'm sorry, Mr. And so it will show on that particular day that on June 7th, 2021, when he's being asked about these Ferris fees, the financial condition is not good. There's not that money there. He's extremely leveraged in the debt that he has, and it will be part of a history where he is forced to do all these things that we've been showing through Ms. Seckinger to stay afloat and to stay one step ahead. And for the jury to understand the reality of what he was facing, they have to understand the extent of what is being potentially exposed. They have to understand why he would be doing these things and why he was out of time. This is not the kind of case where, and I don't know if you want legal argument at this point, but...
Well, I asked the question.
Yes, sir.
I guess this is still your answer. I don't know.
Yes, sir. Thank you. Thank you, Judge. So anyway, this is the kind of case where, for example, he mentions the Bose case out of the gate. The Bose case, the hearing was going to be that week. We will establish evidence that the hearing was to get access or get identification of his accounts. Once that happens, that he would be unable, there would be not long before what had been going on would be exposed. And what we're talking about, and this is really how it's different from some of the other res geste and other cases that you're looking at, is it's really about the fear of what is about to be exposed. And what we're talking about, again, is a decade of malfeasance and misappropriation that ultimately would result in the charges that it's resulted in, as well as loss of his livelihood and loss of his law degree. And that's the real fear that was there. And when we look at June 7th in particular, at that point in time, he's out of options. We've heard from Ms. Seckinger that in the past, if he'd been able to pay that money or repay that money, then he could always kick that can down the road. But on this particular day, the state believes we have evidence, and we believe it's a reasonable inference from that evidence that he was out of options. But for the jury to really understand what's going on, they have to understand the full picture of what this man has been doing and what he's been trying to hide. And frankly, what he was able to successfully hide in the wake of these murders. The bank witnesses will also establish, relevant specifically to this particular witness and the events that you've heard about, is that one of the first things that Mr. Murdoch did, business-related, was to secure $600,000. He got a loan from PSB, Palmetto State Bank, that wasn't even on the books. They just wired the money. Russell Lafitte wired the money, $350. He borrowed $250,000 from another person, and that's the $600 that he gave to Chris, that he used to talk Chris into telling PMPED that all $792 were back in the account. And so, again, that's one of the first things he did to stave off the inquiry that very morning, 6/7/21, was to get that money in there, and it did. It staved off the inquiry. The fact that Ms. Seckinger, there had been a number of things that had been occurring over a while, ultimately turned her attention back to Alec. It doesn't change the fact that it did effectively delay that time period and delay the ultimate detection of that. And he was able to put that money in, much as he was able to do when he stole the $125,000 from his brother, or he used the firm credit card, or what we see throughout this, throughout the extent of his financial matters. So the bank witness ultimately will establish two things. Number one, his financial condition at the time, and number two, his efforts in the wake of the murders to secure that additional money so that he could get enough back to Chris Wilson to talk him into telling the law firm that there was nothing to see here, that everything was okay. And frankly, it worked until two things happened. Number one, Ms. Seckinger started to look back at the Hirschberg matter, and then more importantly, and we have another law firm witness. I don't know the check's up on the screen. Stand by for me, Your Honor. That found this check right here, this very one, in his office right around that same time in early September. And at that point in time, they knew that he had been lying to them about these particular fees. And that's what caused everything to unravel. And then, just like we see, Your Honor, with what happened on June 7th, 2021, within a short period of time, the side of the road happens. And Alec immediately claims that he was the victim of a horrible attack, and everyone immediately assumes that the bad guys are back. There's a symmetry, Your Honor, between what happens on the side of the road and what happens on June 7th, because when the hounds are at the door, when Hannibal's at the gates for Alex Murdaugh, violence happens. And the same thing happened on the side of the road that happened on June 7th. And for this jury to understand the real picture of this man that I will remind Your Honor, I know you're well aware of, that they have already repeatedly put into issue his character and what a loving father he was and all the rest of it, they need to understand really what this man was hiding. And he was hiding something we have never seen before. And the pressures of that are important for the jury to understand why this man might do that.
Mr. Griffin, any comments you'd like to make?
Yes, Your Honor. I would like to respond. What you've heard thus far today does not establish that Hannibal's at the gate in any form or fashion. What you heard from Ms. Seckinger, is that what's the language she used? Hang on, I've got it right here. Quote, there's a history of trust and brotherhood in that firm, and that some similar events have happened in the past where Alec had been overdrawn with the firm through loan checks or expense checks, and that eventually the money gets paid back and everyone goes about their merry way. I mean that is basically what she testified to, Your Honor, and this sort of concept that Alec committed murders to cause a delay in the firm investigating this diversion of fees was debunked by her own testimony, where she said, number one, Mr. Randolph Murdoch was going back in the hospital to die, and that I stopped in my tracks and I became a friend and stopped looking, and that Mr. Murdoch did die. I mean, that's what stopped her conversation, and that's what stopped her inquiry on June the 7th, by her own testimony. And then you go forward, and then she says she passed it off to Lee Cope. And then Lee Cope kept following up, and he communicated with Mr. Wilson. And Mr. Wilson sent an email. Alec had gotten money back into the account. And frankly, Your Honor, if this plays out, as we attach to our response, the draft transcript from the trial testimony in Russell Lafitte's case, that Mr. Murdoch had in progress at Palmetto State Bank a loan application to get refinancing, and that Maggie's murder stopped and delayed that. And it had the complete opposite effect. He wasn't at the end of his rope. The murder of Maggie, if we have to play out this, the murder of Maggie actually caused a delay in the refinancing of the Edisto house, and it precluded getting additional loans from Moselle. And so those are the facts. And how murdering Maggie Murdoch and murdering Paul Murdoch eased his financial stress, it didn't. There's no financial gain, as we said. There's no life insurance. There's nothing to be gained by it. And so there's no logical connection from his, disastrous financial house and potentially
having to be answer to financial misconduct within the firm, losing his law license, being criminally prosecuted, first, and so to, and it's all just a theory. There's no facts. It's all just a theory. But the theory is the best way out is for him to murder his wife and son and put himself bullseye in that circle that you heard about in the testimony of this case, and that he is the prime suspect number one because he's the father, he's the husband, he finds the bodies, they show up and he's holding a shotgun, and he does that to get out from under scrutiny of a $700,000 diversion of fees with a history of trust and brotherhood in that law firm. Your Honor, there is no logical connection whatsoever, and it does not lead to evidence of motive. And we can have more testimony, but frankly, Your Honor, it doesn't meet. And then if we go into 403 and unfair prejudice, I mean, you heard a lot of unfair prejudice here, but the undue delay, confusion of the issues to the jury, I mean, they've got a whole lot more evidence about financial misconduct than they have about a murder and evidence of guilt in the murder case. And that's what this is all about.
Well, with regard to the list of other witnesses that Mr. Waters indicates that the state has, for purposes of the court being able to do an analysis as to whether there's clear and convincing evidence, you have indicated with regard to some of the witnesses, some of the files, you do not or did not contest them. But if you have a few employees from the law firm, including Lee Cope, Mr. Murdaugh's secretary or administrative assistant, excluding someone from the bank. Who's the other person you mentioned?
Well, we have also the Satterfield, which, of course, we have a confession of judgment. For purposes of this hearing, that might be sufficient for the court's analysis, although the circumstances, I think, are very relevant. And then with the boat case, the one thing I want to add, and that would be Mark Tinsley in the boat case, is to understand the context of the boat case and understand how this all relates to everything, is not only was the discovery there being sought by Mr. Tinsley, but there will be testimony. And again, this is all in transcripts, which they have, and I don't know, I've talked with the defense about, obviously they don't have to concede and they'll be able to cross and all the rest of it, but it is in transcripts. They've had a chance to review it, whether or not that's sufficient, at least for an in-camera determination. But one of the things that Mark Tinsley will say was the very aggressive posture which they were taking in the boat case, which meant that Alex Murdaugh was not a defendant of convenience, that the goal of the litigation, at least as it related to him, was a personal recovery. And that is why he was proceeding so aggressively in that particular case. Mark Tinsley will also say that, and we'll talk about how that litigation was going, but we'll also say that after the crimes of June 7th, 2021, that landscape completely changed. This was an extremely significant liability, and the testimony will be that that aggressive posture, seeking a personal recovery from Alex Murdaugh, actually of $10 million, that they weren't coming off that, and that was the manner in which that litigation was going. Once the murders happened, that was done, and Mr. Tinsley will testify to that, at least the posture that they were taking.
Well, the court has heard sufficient amount of, received sufficient amount of evidence to make a determination regarding clear and convincing evidence involving the law firm, and do not need to hear from Mr. Cope or the other witness, what's her name? Ms. Griswold, in order to make that determination of there being clear and convincing evidence. With regard to Satterfield, you do have a confession of judgment, which the court has not seen or reviewed. With regard to the boat case, there's been no testimony. In the record regarding the impact of that on Mr. Murdoch's state of mind or the like. So Mr. Tinsley, particularly considering the representations by counsel that the plaintiffs in that case were just seeking a financial statement, basically. And so the court can hear from Mr. Tinsley, review the confession of judgment, then hear arguments from the parties once again regarding the admissibility of all of this as relates to these other bad acts, and also the limitation on this, if any.
Yes, sir. Two matters right now. I do have the confession of judgment, which I can mark, as well as the disbarment.
I don't believe the rules require a full-blown trial on these matters for the court to make a determination of clear and convincing evidence.
I do have two issues. It would be, of course, we have the bank witnesses to establish that financial condition, and there's that.
The bank witness is also included. I overlooked mentioning the bank witness.
I do have and that we can definitely do that in the morning. I do have a problem, unfortunately, that Mr. Tinsley is not available in the morning, but can be here first thing Monday morning, Your Honor. But we can handle the bank witnesses in the morning.
All right.
And again, we do have a transcript. Is the transcript?
Yes, sir.
Your Honor, we have filed a separate motion with the court on the admissibility of essentially Mr. Tinsley's testimony for any consideration by the court, because he's giving, a legal opinion. It's a judicial decision. It's not Mr. Tinsley's decision, and we've submitted that to the court. So we don't think anything Mr. Tinsley has to say would be relevant. We'd be prepared to argue that tomorrow or tonight if you'd like.
Well, I haven't received that motion.
Here's a clocked-in copy.
When was it clocked in?
January 24th, 2023.
January 24th. Last Tuesday? When was that? Last Tuesday?
Seems like yesterday.
That was last week.
I did see that. I didn't realize that was pertaining to Mr. Tinsley.
Yes.
Well, we'll address Mr. Tinsley's issue when Mr. Tinsley is available. I cannot conclude based on argument that his testimony will only be relate to a question of law. So we'll defer anything, any presentation until Mr. Tinsley is available, and then we can press on with the other witnesses tomorrow morning before the jury gets here at 11:30. We'll start at 9:30. Hopefully that 2-hour window will be sufficient with a break in there somewhere. Regarding the Satterfield matter, what's the defense's position on that?
Your Honor, we agree that they have a confession of judgment. We agree that there's an order disbarring him for that conduct, and they concluded that confession of judgment, even though it has a disclaimer. Anyway, the Supreme Court concluded that is an admission. So, for purposes of disbarment, and I'd be hard pressed to argue against that satisfying, clear, and convincing standard.
And what year was that? The wrongful conduct.
Well, yeah, well, the Satterfield matter, I don't have it off the top of my head, but it was quite some time ago.
2019, 20, 20.
Satterfield issue separately. Aside from the court determining just the issues in general regarding whether or not this testimony should be admitted on motive, identity, common scheme, race geste, there's a separate issue regarding remoteness. And of course, I know the state believes that this is a thread that's woven through all of one thing to the other that culminates in the conduct on June 7th. We'll hear arguments on that later.
Your Honor, not to belabor the point, the additional ground would be consciousness of guilt, which is a basis for admissibility. And again, that's kind of what we're talking about. I mean, that goes under 404, but the case law is long. The consciousness of guilt is fear of detection is a basis for it.
You submitted something on that?
I'll get you some additional cases on that, Your Honor. We'll have that for you by tomorrow.
All right.
Not sure what act he is going under the consciousness of guilt prong to the extent it exists. I don't know what he's talking about.
I don't know either. We'll see.
Well, again, he's trying to avoid facing life without parole and the loss of his livelihood. And for the jury to understand that, it's more than just $792,000. It's this entire time period. And that is really the issue, is avoiding that detection.
Okay, well, we've done enough on this day. We'll resume at 9:30.